courthouse the other day in the hallway. You're singing "Oh Happy Day."
Just a second. Okay, we're just gonna make, Judge, we call our expert real quick. We're trying to save time here, if possible.
Let's,
No, hold on.
let's do it after the jury has left.
Because we're not coming back to one, can't be to one.
But wait, if we agree on the stipulation,
Then we would read it and then.
we read it to them and you do the charge, and then they could leave for good.
Well, that's
Right.
Yes, sir.
But we're gonna make them leave
Well,
for
we're gonna have to go through instructions because we haven't done it yet. We can't just read to the jury, we haven't done it.
Right,
You gotta go to the jury.
We gotta leave either way.
They gotta leave for the day.
No, no.
How long will you anticipate it will take us to? Thank you.
I have a pretty good grasp on the jury instructions. I'll listen to what people have to say. It shouldn't take more than a half hour to go through the jury instructions and reading them to the jury. Discussed with Mr. Mayers his right to testify?
Yes.
Have you also discussed his right not to testify?
Yes, sir.
All right, Mr. Mayor, did you hear what Mr. Tacopina just said?
Yes, Your Honor.
Do you agree with what he has said, just said?
Absolutely.
You understand that you have a right to get on the stand and give your side of the case. You understand and accept that?
I do understand and I'm not accepting.
Also, you have a right under the Fifth Amendment to the United States Constitution not to testify. You cannot be compelled to testify. It's totally your decision to either get on the stand or waive your right to testify and not testify. You understand that?
I understand.
Okay, which right do you wish to take advantage of? The one to testify or the one to not testify?
I'm on my right to not testify.
All right. All right, so do you in fact waive your right to testify in this case?
I do in fact, Your Honor.
Counsel John?
Yes.
I believe that Mr. Mayer's waiver is knowing, free, and voluntary. I accept it. All right, let's have the jury come in. They'll be told there may be a witness at 1:30. In the interim, the defense, you can ask for your exhibits to be admitted. I understand there's going to be no objection. The people have one additional exhibit. That will be moved in. Then I want to give the jury a 45-minute break. In that period of time, we will discuss the jury instructions informally, after which we will come out and formalize them on the record. After that, I will read the jury instructions to the jury. At some point, if the jury instructions go beyond 1:30, I'll stop reading the jury instructions so the remaining witness, if he testifies, we can take him out of order, and then I will resume the jury instructions. And that will be all for the day. Summations will be on Thursday. Is that the understanding?
Yes, Your Honor.
Sorry, you mentioned another exhibit from people going there.
Yeah, they marked a DVD. It's the DVD from Complex.
Oh. So it was something new, that's all. Okay.
All right, let's have the jury. Our jurors have returned. All parties and counsel are present. I understand that Mr. Tacopina, that there are no additional witnesses to be called by the defense.
Yes, Your Honor, the defense rests in this case and will move our exhibits into evidence.
All right, that would be A through EE. Any objection to A through EE?
No, Your Honor.
A through EE are admitted for the jury's consideration. There is one remaining exhibit that the people marked, which was number 44.
The people moved people's 44 into evidence as well, Your Honor.
Oh,
No objections? All right, all of the exhibits are admitted for the jury's consideration. What's going to happen now is, I wasn't sure if we were going to have more witnesses or not. There may be one at 1:30, I don't know. But, so we don't waste a lot of time. We are going to talk about the jury instructions informally in the office. That'll take about half hour, thereabouts. Once we're finished, then we're going to have you come back into the courtroom, and I'm going to read the jury instructions. If there is a witness at 1:30, if I am still reading the jury instructions, I'll stop the jury instructions. The witness will testify. Once the witness is finished, then I'll resume the jury instructions. The jury instructions are going to take me about 35 to 40 minutes to read. For those of you note takers, there's no reason to take notes because each one of you is going to get a package of jury instructions in the jury deliberation room. And as long as I'm talking about jury deliberations, you will not be deliberating in the jury deliberation room on this floor. You will be deliberating in the jury deliberation room in Department 115, which is on the 11th floor. So when you finally begin deliberations, you'll be escorted to the 11th floor into the jury deliberation room. Department 115 is my normal courtroom. So that's where you'll be deliberating. Once you arrive at a verdict, the verdict will be read here in 102. Okay? All right, so it's 10:30, actually 10:24. I'd like you all to come back at 11. Be outside the courtroom doors at 11, as close to that time as possible. I'll begin reading the jury instructions to you, and there's no reason I won't be able to finish before 12. So leave all your materials on your desk. Remember, do not talk about the case. The case is not over. You have not been released to deliberate yet. So keep everything to yourself. All right, we'll see you at about 11. I'll still be back. What?
Your Honor?
Yes, ma'am.
No disrespect intended. Could you, I don't know, that's why I'm asking this question. What happens with the alternates?
Oh, no, that's a very good question. Once the jury begins to deliberate, you and the other three alternates, you will not be in the jury deliberation.
Right, I understand.
You will have to be close by because if we need to summon you, you need to be here in short order. You will only go into the jury deliberation room if one of the jurors has to leave the case. But you will be in the jury box during jury instructions and during summations.
And can I just get a clarification for what you mean by close by? Are we allowed to go home?
No, no. You can be, I would want you to be able to be here in 5 minutes. You can be in the hallway, you can be in the jury assembly room, you can be in the cafeteria. But if we need you quickly.
Okay.
All right, we'll see everybody at 11. Come on back, let's go back. Drop the record.
Are you going to give him a big build-up, a little intro, anything?
Yes.
Come on.
Also teaches with us at Harvard Law School Trial Advocacy Workshop. Joe Tacopina was in the first week with us, although all of us were in different units. It's broken down into 6 groups, and we were all in different units of the first week, teaching young students how to try a case and how to ask a question, not to ask a question.
Was Joe? Was Lewin in there as a student or not? I guess he missed that class.
He's a former state's attorney for West Palm Beach County, or was it Palm Beach County?
Palm Beach County, right?
Palm Beach County. Probably had for many years. He looks like Dave looks like he's like 10, and he really is. He's got, he really is. He just doesn't age ever. He's got great experience. He's got great morals. He has great ethics. And now he has his own private law firm. So why don't you tell us about that first? And then we can go into your thoughts about today and the ethics of prosecution, given when I first called you, given that tape out there from Relli about needing a lawyer for a bag, or else it's called extortion.
Well, at first, it's great to be with you, Linda and Michael. I really enjoyed teaching with you, Linda. We were actually in the same section at Harvard Law School, right. And Joe Tacopina, who I had never met before, he's kind of a bull in a china shop. He was someone who, when I was involved with the Robert Kraft case, remember? Prosecuting
that was your
he was representing Robert Kraft, and he went on TV and was just reading me the riot act. He was chewing me out, and I was like, who is this guy? And then I never met him until then. I went up to him. I said, hey, I hope you're not going to continue your broadside against me here. He's like, oh my gosh, I didn't know that was you. And we became instant friends. He's actually a really, really nice guy, a charming guy, and a really good trial lawyer. So I'm not surprised that it looks like he's winning here. Of course, you don't have to win by 51% to 49. You just have to get reasonable doubt. Get one juror and it's a hung jury. Get more than one. Get an entire jury with reasonable doubt and you win. And I think there's plenty of reasonable doubt here. I thought this case was weak to begin with. I mean, they never found the gun. They never found the bullets. The only one who found the bullet casings was the victim, who came later after the police were done searching the place. And although at the same time, I got to say the fact that the defendant says that he carries a starter gun with him, and that's what he was using. I don't know if I believe that, quite frankly.
Yeah, there was some confusion over prop gun, starter gun, and I don't know that I disagree with the theory that, hey, I've experienced some violent episodes of home invasion, and I want to scare people off. If you think it all the way through, as Linda and I have talked about, you may be asking for more trouble than you want, because brandishing a gun that won't stop somebody who might have a gun, that's a losing proposition. And that is, I think, that was reasonable to me, Dave. Tell me what you think. First of all, congratulations on you're going over to the dark side now. You've left the state. Oh, yeah.
Yeah. So my firm is Dave Ehrenberg Law, and we do civil and criminal litigation, some land use. And so, 561-765-5555. Also, I have a YouTube channel, Court Authorities. I'd love to have you guys on where we talk about law, politics, and true crime. But I love being on with you guys because you cut right to it. First off, I think there should be a rule in court, a local rule that says that you can't have a Lewin and a Levin in the courtroom at the same time. That should be a no-no. I mean, how confusing is that, right? I was just reading their names in the documents, like, oh man, is that Lewin or Levin? And this case is a mess. And I can say that now that I'm a former prosecutor. When I was a prosecutor, you have to tread gingerly when you talk about other prosecutors. But this case is a mess.
Yeah, I think you've got some latitude here. So I was about to ask a second question, which I kind of lost track of, but it had to do with the gun or lack of a gun. But let me go back to Relli, because he's really the central figure in this case, even though the jury may have sort of lost track of him at this point. How do you recover from a witness like that, who so clearly has lied on a number of levels, and he has been far from helpful in telling his own story, but very little time do we have a surviving victim, because we do mostly murder cases we have to follow. So here you have the guy, and he's a disaster. How do you recover from that if you're the prosecution?
I've had cases, and I'm thinking of one right now, the Travis Rudolph case. I know that you guys
I'm
covered
very familiar with that one.
Right? Well, There was a case where you have a likable NFL player who was essentially jumped at night. The group went to his house to do him some harm, and then he responded by going into his house, getting an AR-15 style weapon or an AK-47, a semi-automatic rifle, and then chasing them and shooting at them from behind 39 times. And in the car, as they're driving away, he keeps shooting and actually shoots and kills one of the guys. And we put him on trial, Travis Rudolph. We put him on trial. Said, you don't get 39 free shots. You can't run down the street when these people are trying to flee and shoot in a neighborhood and kill someone. You can't do that. And the jury heard testimony from Travis Rudolph, liked him. They heard testimony from the victims, the surviving victims. They didn't like them.
And the ex-girlfriend. They hated all the people.
Hateable. Right. They didn't like any of them except for Travis Rudolph. So all it takes is for Relli not to be likable, which he's really not. I mean, or to give a story that people don't believe. I mean, one of the small details here is that he had this hand injury, and as Joe Tacopina said, waited to fly all the way across the country before seeking medical attention. And his response was, well, I had my hand wrapped that night, and I wanted to fly across the country because I don't trust LA. I didn't trust anyone in LA. Like, what? That doesn't make any sense. So that's just one of many.
By the way, thank you, LTOUXER became a YouTube member. We obviously appreciate everybody joining here tonight. Yeah, he didn't trust everybody, but I was more concerned as the ethics here and I wonder what would be the procedures in a DA's office this time of, the year we're in the year 2020. Well, this was taken earlier, 2022, 2023. You have somebody who's now on a tape. I don't know when they got the tape that says, look, I'm looking for 30 million. Then there's a second conversation. I'm looking for 30 million. And if I get it in cash, they'll never find me again. I'll be on some beach. They won't be able to prosecute without a victim. But I needed to get a lawyer because I needed to get the bag, meaning the money, you usually carry in the bag when you're paying somebody off. I had to have a lawyer or else it's called extortion. I think he spelled it, he said it wrong, extortion or something like that. But it was extortion. To me, that was clear. That's what came over. What's the ethics of prosecuting something like that? How do you choose to take the guy who says, hey, I'm going through legal extortion here?
Well, the Lewin, not Levin, made a good point on cross that says that even if he was motivated by money to try to get as much money out of this rich rapper, A$AP Rocky, it didn't mean the event didn't happen. Both things can be true at the same time, that this actually happened, and yet the victim really wanted money. But when you're a prosecutor, you're very careful not to let yourself be used as leverage for a civil lawsuit. And that's why I tell people to this day, and when I was talking to people before, I said, if you wanted to do a civil lawsuit, if you want prosecutors and police to get involved, you might want to wait on that because prosecutors and police don't like to be used. We don't want to be used as leverage. And here it looks like the prosecutor was used as leverage. And that's not a good look, even though ethically the prosecutor can pursue the case because both things can be true at the same time.
Don't you have to give something maybe to an attorney general to evaluate? Doesn't somebody have to evaluate though whether or not they made a decision that this did happen? They made their decision it did happen even with this tape. How do they make that decision or not give it to another office to at least evaluate it? Here, you decide whether this is extortion and we'll decide whether we believe the witness, or is that not possible?
Well, when you're a prosecutor, you have to evaluate every case to make sure that you can get a conviction beyond a reasonable doubt in good faith. You have to believe you can get a conviction beyond a reasonable doubt. This is different than probable cause. So police, they can just arrest on probable cause, but prosecutors should not take the case unless you think you can get a conviction beyond a reasonable doubt. And if you have this stuff on tape, if you knew about that in advance, that's got to put doubt in your mind whether you can get that conviction, and thus you shouldn't move ahead with the case. So I don't know exactly how much they knew and what kind of evidence they were privy to, but they decided to file this case, and it doesn't look good for them at this point.
That's why, Dave, I say they never even talked to Relli ahead of time.
Right.
Regardless of the audio tapes, which are damning, Relli is damning. If you are the prosecutor and you're doing your due diligence, you're interviewing, if you spent 5 minutes with Relli, what would you think?
Yeah, well, it's like the victims in the Travis Rudolph case. sometimes you just do it because, well, should we allow someone to shoot 39 times in the back? And here, should we allow a high-profile man of privilege to shoot someone, even though the victim is unlikable and wants money? And so that's what prosecutors are thinking. They're convinced that there was a gunshot here. And, if you think about it, it probably was. I mean, but the fact that see what I said probably was, that's not good enough to get you beyond a reasonable doubt, right? That's reasonable doubt right there.
Yeah.
But I do think if you said what really happened, I do think there was an encounter. I do think there was a gunshot. I don't believe the starter pistol is shot in the air and everyone else was shooting. But do I believe that with beyond a reasonable doubt? No. And that's the problem in this case.
Hey, Linda, let me interrupt here just a second. I know you're poised with a very sharp question. And some of our chatters have asked about this Travis case too. So this is a shameless plug for both Dave and I. I did an episode for Taking the Stand, which was the Travis Rudolph case, and it's on the show Taking the Stand. It's on A&E. I'm sure you can find this episode. Dave was an expert on there from the prosecution standpoint, and it's a crazy case. This former NFL player, Dave laid out the details there. I won't tell you. Some of the finer points because it's worth watching. But Dave did a great job on it, defending the prosecution's point. And if you hear the story, like Dave suggests, here's a guy that takes an AR out of his house and shoots 39 times, including at a vehicle that's driving away from you. You're going to have something in your mind that may not play out in trial. And we see that in this case, too. If you hear just the raw facts about this case, this guy, Rocky, allegedly with a gun, perhaps a prop gun, perhaps a real gun, brandishes that weapon and then shoots at or in the direction of somebody, that's not proper conduct. That should be investigated and perhaps prosecuted. So I think both of those cases at the starting gate sounded like they could be legit.
Yeah, exactly. That's the point. And that's why it's not unethical for the prosecutor to pursue this case. They've got grounds, but you need to look at everything and the chance that your victim is really unlikable and has some holes in the story. There's a money motive, all that combined. And I think you're right, Michael. I'm not sure how much they knew of Relli, the victim in this case, before they decided to move forward with the prosecution.
But here you have the cops came to the scene right away, based on the 911 call, right?
18 minutes, but okay, we'll give them right away.
Well, right away, that no one picked up in the area where incident one, because Lewin kept trying to say incident one, incident two, and incident one was pretty far away from incident, not pretty far, but far away from incident one. They go exactly. They look around. There are no shells to be found. They're nowhere, and they conclude that there was nobody. There were no evidence that real gunshots had been fired, even though it could sound like it. And then no one, we get the shells several days later when Relli supposedly calls his lawyer. His lawyer says, you go back to the scene and you go collect the shells. So he goes back supposedly with his girlfriend, who doesn't testify now for the prosecution after they opened with her. The defense now says, after cross-examination, the prosecution may even say that Relli never went back to the scene. So if he never went back to the scene, there was no evidence of it. Where did he get the shells that he brings in? And thank you, Rice Street, by the way, for gifting 5 Justice Serve TV memberships. Where does he get the shells?
I don't know. And I didn't know that detail before, because I thought that he went back to the scene and he scoured it where the police missed it and found the shells.
Yeah,
so
it's
he
questionable.
Said, right. So where did he get the shells if he didn't go back to the scene? That is a huge gap in the process.
Yeah, and we know that he went to a gun range after denying that he ever did, but he went to a gun range just prior to the incident. Could have pocketed some shells there, thinking, hey, someday I might need these. Or he may have had just random access to them. He found them, in theory, within an hour or so of the incident, turned them in the next day, or about, I don't even know if it was 12, 14 hours later. He had some time to get them. Yeah. Do you remember exactly when they were turned into the cops, Linda?
Yeah, he was 2 days, because the next day he says, I called my lawyer. First he says, I called my lawyer that night.
Like 3 a.m.
There's no call to the lawyer. So the next day he says, it wasn't that night. I called him the next day. He told me to go to the scene. So I go to the scene, and then he brings the shells back 2 days later, right?
Yeah, so he's had plenty of time to come up with some shells, And it would have been, if he had done a little investigation himself, he would have found out exactly what guns Rocky had in his possession, and he would have gotten shells to match that. Right. But that's a whole different problem.
Yeah, that's the problem, right?
It's a huge problem, and that's why I don't see this going to a conviction. I mean, can you imagine a unanimous jury finding beyond a reasonable doubt that ASAP Rocky did it? No, I cannot. I think at the best, a prosecution can get a hung jury here, but that's not good.
And we were talking about that, Linda. Remember, it's like normally if you're the defense, hung jury is, that's a victory. This is a weird case where hung jury may be as close as it gets to a win for the prosecution.
Right. And what do you do? You're going to try it again? Or
Yeah.
what do you do? I mean, that tape really bothers me, Dave. The tape really, really bothers me.
And it should. Also, what should bother you when the judge attacks the prosecutor saying, hey, stop yelling. And when you start admonishing the prosecutor in front of the jury, that is a terrible look. It's okay for the defense lawyers. In fact, if you're not getting admonished as a defense lawyer, you're not doing your job right. But as a prosecutor, that's a bad look.
That last little clip, Linda, that was in front of the jury where the judge reminds them of the 1054 issue. I'm sorry, 1074 issue. And says, I'm keeping track. The jury doesn't know exactly what that is, but it doesn't sound like he's, setting them up for an award of some sort. It sounds like it's a problem,
Oh, yeah, and he said a couple of times, keeping track about the yelling or the stop it. It's become very loose, Dave, that all this is now happening in front of the jury. It started out very tight, and now it's becoming like, just get it over with,
Yeah, it really is. And the fighting with Relli and Tacopina, it takes a lot to make Joe Tacopina look sympathetic, but Relli did it somehow. He did it.
Okay, so let me ask you this serious question, Dave. As we look at the pending charges, assault, battery.
Michael has a question.
Oh, okay.
How can the prosecution demand a defense witness to be recalled when they already rested their case?
Well, did the prosecution demand that the defense witness testify? I'm not sure how that played out.
Right.
The prosecution could have a rebuttal witness.
Right. And I think that's what we're talking about.
Oh, okay. Yeah, that routinely would play out after the prosecution rests. And we'll see. We'll see if that actually happens. So, Dave, assault and battery. Can you find assault in the best set of circumstances here? We know that Rocky brandished something, prop gun, real gun. If that indeed was used to cause apprehension on the part of Mr. Relli, that could be enough, right?
Yes, but that's not exactly a capital crime. It's not a big deal. He'll probably get a slap on the wrist and go home if that's all they're going to convict him on. Assault, battery is different. Battery, you actually physically hit someone, shoot someone. I mean, that's just the least of his issues. If they find out that he shot him, he's going to get hit with more than that. But the assault, sure. I think the assault, when he gets in his face and starts yelling at him and brandishes a prop gun or whatever, that's the easy assault. But again, it's not necessarily going to be anything that incarcerates him at this point.
Here's another muddy part of this, Linda.
Yeah.
If Relli knew it was a prop gun, because there's some talk that everybody knew.
Right. Yeah.
Okay, well, then you can't really be apprehensive, right? Because it's a prop gun.
Well, also you have the crime of aggravated assault with a deadly weapon, which is serious. That's not a misdemeanor assault. That's a serious felony. Aggravated assault with a deadly weapon is a prop gun that the victim knows a prop gun, a deadly weapon.
I guess if you bash him over the head with it, but I think it's hard to feel apprehensive when he's like, dude, that's a toy.
And he's running after him. I think that the point that he was running after them all the time. If he's scared of them and he thinks they have a real gun, why is he chasing them? Why is he chasing them down the street? After all this chaos. But let's see what some of our viewers think. And here's Wrestler's Mom. All the yelling is too chaotic. It has given me a massive headache. Lewin is petty. I'm not a fan. And I'm just following right down the list. Renette. Some of Lewin's questioning seemed to go in favor of the defense. Survivor speaks. The case is crazy. Prosecutors.
So how do you really feel there, Survivor? Damn.
And then there's also the view he didn't pull it out, it fell out, and Rocky was putting it away. I guess the question also is who was the aggressor? And that little tidbit in the tape, Dave, we started talking about this. I know you were on listening. Relli says to Wally that he pulled the gun out, whether it be prop or whatever, for self-defense. So he gives Rocky a self-defense argument in that tape.
I mean, the prosecutor must have been just cringing inside because as if things weren't bad enough. Now he's given Rocky an affirmative defense of self-defense. So yeah, it just keeps going downhill from here. You see the comments. If your viewers, your listeners are actually feeling this way about the prosecution, I mean, this is clear, at the very least reasonable doubt. If they don't like the prosecutor, then that's terrible. Normally you just don't like the defendant, right? But here they don't like the victim and they don't like the prosecutor. Bad.
Yeah. And I thought Joe Tacopina did, and I would say this to his face, a wonderful job. They're holding back. I thought he did what we teach at Harvard. Take those building blocks, right, David, and knock them down and rebuild your own wall with them. And I thought he actually showed great, shall we say,
Restraint?
Restraint it's kind of restraint. I was looking for a different word, but he wasn't strident in how he went after Relli. He was restrained in how he, and kind of built back up to the point where you hated Relli. And then, of course, you have this crazy rule, talk to us, where the prosecutor who doesn't present the witness can object.
Well, have you seen that, Dave, what they did in this case? It was something they established from day one because Lewin wanted it. The judge was clear, and this happens in almost every case. I don't want 3 attorneys on a team objecting. One person will object. And normally it would be the person who did the direct of that witness would then object on the cross. No. Lewin said, is it all right, Judge, if a different person objects rather than the person that did the original examination? There won't be 2 of us, but there might be a different person objecting. Well, who's the objector? Lewin. So he's objecting to witnesses he did not directly examine. How do you like that?
Well, that's like the designated hitter rule, right? You know, you don't hit the field. You're just all you do is object. You're the objection expert. But I wouldn't want that as a prosecutor because you study your own witness and the witness you're going to cross, and that's the one you know everything about. You're ready to object. You're listening to every word. Why would you do that for witnesses you don't call? That's not your witness. You have people to help you. Why would you do that? That doesn't make any sense. It makes it much harder for you. It raises the level of difficulty. So I don't agree with that. It's
so arrogant, I think. And it also, it cuts Pauly P's testicles off. Pauly P's supposed to be the lead attorney. Just not literally. He's supposed to be the lead attorney, and Lewin, parachutes in. He's second chair, but clearly he's calling the shots. And to take that step just undermines his own, his own teammate.
Well, Lewin could have come in and said, "You know who I am." You ever heard of Robert Durst? Ever heard of Durst? Yeah. Okay, so you're supposed to be first chair, but I'm doing the objections, okay? And you're getting the coffee. So, yeah.
poor Pauly P, who we like. We like Pauly P.
Yeah, no, we thought that he did he was very normal. Not normal.
Yes. Yeah. Earnest, straightforward.
Right. Yeah. At least he was trying to say, I'm going to give this to you. I'm not taking a side. I'm giving it to you. I got on this morning and I had to go to a meeting, and then I got on and I heard John Lewin again, and I know he's a very good prosecutor. I know he's very committed. I know he believes what he's doing, but this constant objected, and when the witness would say no and try to explain what he meant by no, or maybe he would, move to strike. And I don't think juries want to hear what the witness is saying. Not every question is a move to strike.
That's a great point. That's something that really should be taught in trial advocacy, because although he's right, technically, the witness needs to just stop. But it makes you look bad in front of the jury when, here's the jury that wants to hear this. And you're like, not only do you say strike, but you do it in a very loud way that gets you admonished from the court. It makes you look unsympathetic in front of the jury.
Very unsympathetic in front of the jury and all the people watching, right?
Yeah. Unlikable. Likability matters. It matters in politics. It matters in court.
Someone once said, never underestimate the power of likability.
Yep.
Somebody once said that.
You know what they say? The most important thing is authenticity. And if you can fake that, you got it made.
See what you did there?
Thank you, Michael. Thank you. Linda was ready to move on.
You're ready to move on, but I just pull back right now. I just pull back. Raynette said that she felt that Lewin was trying, and I think she meant Lewin was attempting to try to hide something every time he did this kind of move to strike. And I'll couple that with this comment again from Wrestler's Mom. And these are chatters who've been following this case. If Lewin played less of a role in the prosecution team, they may have this in the bag. And she doesn't mean the extortion bag. Thoughts.
That's a bad sign. Yeah. What do you think of that, Dave?
Well, it's bad when all of your comments are negative to the prosecution. That hurts me as a former prosecutor. We like to be on the, wearing the white hat, the good guys. And when you're losing the Baden and Bryant audience, that's bad.
Yeah.
Right?
And that's something that we've been talking about, because it just seems like we've seen a string of these cases in which the prosecution was a little shaky, and they've resulted in defense decisions in one way or another. I don't know. We don't know if it's a sea change or if it's just coincidence that some of the high-profile cases have ended up this way, from YSL to this current trial in Florida, the Ty Tucker case. I don't know. What are your thoughts on that? Is there some sort of swing that prosecution teams are getting, I don't know, more desperate to bring about a case that may not warrant it?
No, I think that these are just high profile cases. I've seen conviction rates pretty steady where I am. So I saw you're using a couple of cases as good examples, but generally these cases end up in guilty verdicts because most of the people who go on trial as criminal defendants are guilty. Wouldn't that be terrible if most of them are innocent? That would be a massive fail in the system. So, in fact, I'd say an overwhelming number are guilty, and that's me now on the other side. But
yeah,
the ones I represent, they're all squeaky clean, innocent. But but most of the people on trial are.
But they may not be guilty of the crime for which the prosecution charged. I always make that distinction to people. Look, people can get charged with murder. Maybe it's manslaughter. Yeah, you know what I mean?
True.
Maybe it's so that it's not just always so clear, black and white. You're doing a job because maybe there's an overcharge, and we've seen overcharges. I'm sure you've seen other officers overcharged, right?
Yes. In fact, I have, in retrospect, on some of the cases that we've lost, we've said, hey, maybe we overcharge. Sometimes the problem is in the statute also.
Right.
The person did it. And when I say they're guilty, it doesn't necessarily, you're right, mean that they're guilty of this specific statute. We know this person did something wrong, and we know this person shot and committed an assault, but can we prove that this was a real gun and not a prop gun? And there's certain issues. Then you have the Alec Baldwin situation, not to bring up another case where, you had the whole case thrown out because of prosecutorial misconduct. That's a whole nother level. So, and
that we've seen. And then the Karen Reed case, of course, an ongoing ball of mess, prosecutorial issues there too. I know you would never do this, but sometimes it seems like overcharging is used as a weapon, so that the defendant will cave into something lesser, whether guilty of it or not.
I've come on your shows in the past and talked about the danger of overcharging. You lose credibility in front of the jury. I would rather get what you can get and not try to go for the home run when the home run is not available because you're playing in a cavernous ballpark. So I'm with you. Be careful not to overcharge.
Okay, here's a good question. Can Rocky still get an assault charge, convicted, I guess, of an assault charge, if Relli was the aggressor?
It depends. So the whole thing of self-defense means if Relli retreats. So Relli's the initial aggressor and then retreats, then Rocky cannot go and be the initial aggressor. You don't get like a get out of jail free card. Once someone's the initial aggressor, after they retreat and turn away, you get to go chase them down and shoot 39 times from behind. Or, well, I guess in one case you're allowed to do that, but
in California, it's a little more liberal than that. They if there is a true self-defense that's legit, you can actually pursue until the threat is neutralized, whatever that means. It's pretty aggressive in California.
Well, if the person retreats, right? If the person retreats and ends the threat, you're limited as to what you can do. I use the Travis Rudolph example again, where you just can't, even in California, chase someone down the street who did threaten you after that person has turned tail and left and tried to run away and end the threat.
Well, that's just it. It has to be some reasonable perception that the threat exists, continues, even if they're running away from you. Like maybe they're running away and shooting over their shoulder, whatever the scenario might be. Yeah. But as long as it's reasonable for the person pursuing to think they still have something to defend against, then they can neutralize that person. It's pretty aggressive. Didn't get there in this case, but I saw a question that came and went. I think it's Ashley. Let me see if I can get that up here. Ashley, when do you use an affirmative defense? And then referencing Travis Rudolph again, he used self-defense. And we're starting to learn, Linda, that even though it wasn't really part of the story of the defense, that affirmative defense may come into play now, right?
Right, because it was because Relli said it. Relli said he pulled the gun out in self-defense, meaning that he was the aggressor, and Rocky was trying to defend himself. So whether it be a prop gun or a regular gun, but I don't see. The other thing I think there's a problem. I don't see those. Remember he hit the wall or the person 3 times. Relli did. That's the testimony, and that looks to me like. Dave,
that's how it might happen. Yeah.
Have you boxed or whatever?
I've done kickboxing.
Okay.
But not like the real stuff, MMA or anything. I'm talking about in the gym, in a controlled environment. So no, there were no major injuries.
Yeah.
No bar fights, nothing like that.
Not yet.
That's not a graze. The bullet just happened to go. Let me just graze 3 perfect knuckles. Around, and it looked like it was from a hit. That's what it looked like. I mean, I'm sure the jury, and there's no medical testimony addressing it. And it's interesting because the testimony is that Relli went to Metropolitan Hospital in New York when he got back, but no one from Metropolitan Hospital was coming in. There's no records coming in. That's
because the injury is a joke. I mean, I'm not saying it couldn't have happened, Dave. I mean, a lot's going on. Things are moving. Who knows? Maybe a president-to-be is going to get nicked in the ear. Who knows what's going to happen when a bullet's fired and all of these actions are taking place? So maybe that is how it happened. Maybe.
But there's no medical evidence to come say it. No one. Metropolitan's here in New York. We get a lot of gunshots in New York. Usually the Bellevue is the place, obviously, they get treated. But don't you think that Joe's going to say when he closes? Did you hear anybody?
There's no proof. Yeah.
Come and say this was he wanted to get treated. This is a bullet wound. And by the way, thank you, Rice Street, again for gifting 5 more Justice Serve TV memberships. So I think if I'm the defense, I'm going to finish up with another witness that shows Relli as a liar. And there was one area, obviously, there was a number of areas, but remember, and I only say this because I just ordered my.
Oh gosh, here we go.
Here we go. I mean, I'm color coordinated today with orange, but
it's a double shot of extra caffeine.
Dunkin' Donuts, my mango green tea, the cartridges, and I don't know if we saw the envelope, but remember he said the cartridges. Relli said the cartridges he picked up, he bought into the police in a bag. Dunkin' Donuts, and now I just got my Dunkin' Donuts order, and they delivered it in a white bag. If you get like the egg wraps or something, it comes in like a
the brown, recycled bag kind of color.
Recycled bag. And I don't know, did we see a picture of the bag that he brought them in? Because I'd want to track down everyone that can show that if I were doing this, that
you bring a Dunkin' rep in.
I bring a Dunkin'.
Yeah.
I bring a Dunkin' wrap in, right? Here's to my Dunkin' every single day. I have it. Right. Yes, I bring. And by the way, along with that, the hospital. I mean, the hospital. He didn't go to. He was 2 days later, 3 days later.
But he had it wrapped up, Linda. He had it wrapped up. Sorry, I can't do that with a straight face. That's what he said. He said he had it wrapped up.
Maybe with the Dunkin' wrap bag.
He had it.
Yeah,
he had it wrapped up, flew across the country, and he met with his lawyer, and then he went to a hospital because he doesn't trust hospitals in Los Angeles.
Right.
Well, yeah. They're not very good at treating gunshot wounds, right? Because they don't see very many of them. And that's just
near
bad.
A high school in Los Angeles.
Just bad.
Yeah.
So I'd want to. I mean, I think the prosecution ended the cross-examination of Lou Levin on a whimper today. I thought Lou Levin did a wonderful job for him. He looked like he was trying to answer the questions if he wasn't getting objected to by the person doing the cross-examination all the time when he was trying to say no, yes, explain what happened. And if I'm the defense, Levin was great. We don't need to bring anyone back from New York, but I want to reinforce him. I'd pick out one spot, maybe 2 spots, but we want to know it's one witness, one spot where you could show that possibly Relli lied and bring that witness that lied and then rest. I mean, that's would be my game plan.
Okay, I'm calling a late witness from Dunkin'. I'm calling a Dunkin' expert.
If there's a Dunkin', oh yes, what is that? A delivery checkout bag?
Yeah, it's some sort of black Dunkin's bag.
Where did that come from? Because
From my phone. I don't know.
Your
It
phone.
says Munchkin Run. So it's a little some sort of delivery bag or maybe a big.
Well, let's see. Let's see what happens. I don't
So
know.
what do you think of that?
Caught
Aha!
here on the East Coast. We have DoorDash and we have Dunkin' Runs the Dunkin' Run queen. Okay.
Just trying to plant some, seeds of doubt. Who knows? Who knows?
Oh my goodness gracious. So there we go. I don't know. How about you, Dave? How would you try to end it if you're the defense?
I like ending it on all the inconsistencies in Relli's story. Relli wasn't likable on the stand. Focus on him.
Yeah.
Don't put the focus on ASAP Rocky. Put the focus on the guy they didn't like and show how much of a liar he is. And really all it takes is one lie, and that should be reasonable doubt for this jury. But if you can show 10 lies, that's it. Then I think Tacopina is going to win this case.
That'd be really interesting. And really, by the way, I think he's been a very good client in the courthouse there in the trial. There was some issue with this AUG about whether or not he was telling 12E not to answer, but I think he just kind of blurted out,
Yeah, because that's it's a Fight Club ripoff, and
Right.
probably a little inside joke between them, right? And I think he might have been signaling kind of like wink, wink. That's the joke for AUG. And that's kind of what was repeated on the stand. At the close, I would do, as I've said before, play the testimony about I definitely didn't go to the range, and then bang, bang, he's at the range. You mix that up with your phone call and the reference to the extortion LKB, and
And Sergeant Logan to the front desk sergeant said he bought the cartridge in a black plastic bag.
Oh, plastic. That one was not. I don't think it was plastic. That's going to take further research.
That's not plastic coming there. I think California's a little woke when it comes to.
You think?
New Jersey and New York, we don't use like plastic anymore. As a matter of fact, in New Jersey, we don't even use bags. You can't give a bag.
Yeah, it's funny. That was all happening, and then COVID hit, and all of those rules kind of went out the door. And now, of course, I hear we're getting plastic straws back. So
yeah, you're getting plastic straws back. Although Dunkin' never, I have to dive them out. They never got rid of the plastic straws. They
good
always
for
said
them.
plastic straw.
Those are like oversized plastic straws, even.
Yeah, they always had a plastic straw. Everybody else here in the city was setting the paper straws, but the Dunkin' never wavered, because the rule was that you could use the stash you already have. And so I assume that Dunkin' worldwide had like millions of plastic.
And who's gonna try and enforce that? Dave, as the former state attorney for Florida, did you do any straw checks when you were out and about? Make sure people didn't have plastic straws?
That's the last thing I was going to do was to shoot our violent crime task force and go after plastic straws. But hey, at least now we're in a free society where you don't have to worry about the plastic straws or the environment or the price of eggs, right? Because
What is? I don't understand the egg thing. I don't understand. Yeah,
that's a whole other show. That we'll do on your show. We'll
do on Court Authorities. We do talk about those types of things.
Okay.
All right, we'll do that on your show.
Yeah.
So, any of our viewers, because we have 354 still watching, not just viewers. We have a lot more viewers watching, but chatters. This case is really taken over. Anyone have a final question to ask Dave before we say goodnight to you and see you tomorrow at lunchtime, because we're going to be back.
Do it again. Yeah, I think somebody just asked for your phone number again, Dave.
Sure, 561-765-5555. Because we're a new firm, the website goes live any day now, and so in the meantime, it may be tough to find us. So save that number, or just find me online. Easy to find. And thank you for having me on, Linda, Michael. You guys are awesome. Love your show.
Thank
cool,
you.
Man. Always appreciate it, Dave.
All right,
See you
guys.
See you next time, bud.
Take care. See you next time.
All right. I know it's time to run, so
Time
we
to
shall.
Yeah.
Tomorrow they're starting at 10 again, which is 1 o'clock for us. Then we'll. Could be very an interesting day. Did you say they're leaving early tomorrow? One of the jurors have something.
One of the jurors said something that they have to.
3 o'clock.
One of the jurors, unless it was somebody who's a court officer, but I assume it was one of the jurors, said they have to be somewhere at 6 o'clock, and the judge asked if it could be pushed back, and she said no, and I think it was she said no because she was had to give a lecture, so they're leaving early. So. Then it looks like if that happens, then it looks like summations is going to start Thursday.
Mm-hmm.
3 summations and a charge. Oh, I'm so sorry.
There you go. Get the hell out of here. That's telling you.
And the jury-
So we'll do that tomorrow. Yeah, at some
I
point.
will see you all tomorrow. Thank you. You can stay on the channel here and chat. Missy's gonna. Are you gonna run anything or run anything? Or
Yeah, you're just driving Missy into the ground, just working her to death.
Wait, we shout out to Missy and Dizzy. They just are fabulous and just wonderful. And know that you love this. You love chatting. You love your community that you're building, and we love the community building. And we will see you tomorrow at the lunchtime hour. Although
That's right.
Streaming from 10 o'clock California time, 1 p.m.
Yeah, and if something happens, before the normal break, who knows? We'll jump on and chat. Okay, well, until then, try to do the right thing. I'm Michael Bryant, and you are
Linda Kenney Baden. Together we are Justice Served TV. And if you like us, please subscribe, share, hit the like button, and you'll get that notify rings.
Oh, I just cut her off. She never likes that. So who's going to be the new mystery witness? What's the deal there?
Working on that. Working on
it.
I'm
You're working your sources.
yeah. Working on it.
So it sounds like self-defense might be raising its ugly head here.
Did you hear those two words? I've been saying
did.
it to you, Michael. We've been asking that question, right? I heard those two words because, look, if no one has to testify to it, because Relli has it right in that same tape that the gun was pulled, whether you call it prop gun or whatever, for self-defense. There you are. I think I would take it. I think I gotta have it in there. You know?
Yeah. We did talk about the what if, and well, now the what if is, and so we're, I guess, assuming it could be an expert to talk about self-defense.
Now the question I have is that last witness the person who received the gun?
Mr. Lewin.
And he's going to come to into California and say, no one told me to get rid of the gun. That was it. It's been years, and and they called to get me back. It was already gone.
Do you think they're going to call him? I know they know who it is now. Do you think they're going to call this person?
It is. Well, they interviewed him, and quite frankly, I don't see why you need to call him because they got his testimony in.
I think it's ridiculous because is it so hard to conceive, Mr. Lewin, that this is kind of a collective of small film rap video makers who just interchange props here and there, and when you're done with one, you just give it back to, in this case, I guess the assistant director.
Right.
He turns it into this loosely organized prop, department, and then who knows where it goes from there. So the jury is going to have to believe that is just a concocted story, totally unrealistic, and that this witness, Mr. Lewin, I don't know, former manager, former DJ, kind of a fluid relationship, that he just made this up because that helps explain why they don't have the prop gun. I don't know. I think he was credible, even though annoyed at the Lewin cross at the end. But what do you think about?
Everybody was annoyed at the Lewin cross at the end. You have a couple clips we're going to play about the Lewin cross at the end.
I think I might. Is that a cue? Is that a cue for me to find these?
That's a cue, everyone.
Okay, let me see if I can find it. Which one did you want first?
Surprise me.
Okay, let's go with the every possible objection that was granted or not granted. Here we go.
Does what you're saying sound reasonable?
Objection or
It's not for.
No, we're done with Mr. Phillips.
We're done.
He asked every question that he could possibly
I have
ask.
more.
All right. I can't fathom another question.
Good one.
Excuse.
What?
It's a good one, all right.
Excuse subject to recall, Your Honor. That's foundational.
All right, yeah, if you're notified to come back, you must come back, but if either side wants him back, I'm gonna wanna know what the officer feels.
Your Honor, just so it's clear, that's foundational under the evidence scope of the work.
Right, I understand that.
I do not anticipate that he would be called back.
Evidence code section 1235?
Yes, sir.
Okay, if it happens that you're notified to return, you must return, so you are not excused. Understand? Well, you don't have to stay in California, but if you're notified to return, you must be here the very next day. All right, but now, you can go.
Get the hell out of here while you can.
Let's play the next one too. Let's play the next one because I think these kind of things go together about how the judge.
You're so demanding? What is the next one here? Which one did you want?
I'm not so demanding.
You want? Let's see. I think you want not the no speaking objection one. That's an old one, I think. You want the sanctions. You want the stop yelling. I think that's what you like.
Stop yelling.
I think you want that one. Okay, let's see if we can give you that one here.
Did he ever tell you? You ever asked me, why are you bringing a prop gun with you when you're meeting with another ASAP?
I don't think he brought it to like this.
Motion to strike is not responsible.
Stop yelling.
Stop yelling. Motion to
You
strike.
can just make the motion and state the reason. You don't have to yell. What was the objection?
Now, it's believed that Mr. Lewin has kind of a hearing impediment or deficit.
He said that even at Durst.
It could be because he yells so much. He's given himself a hearing problem. Is that possible?
Also, sometimes people that have hearing deficits.
I know. I get that. Of course. But he doesn't have a normal speaking voice. It doesn't seem.
But everything is at you. I don't think the defense needs to call another witness because what and I'm going to say Levin, it's really hard because, we're just transposing. There's a Levin and a Lewin here.
Yeah.
Right?
I just keep thinking of 11 witnesses. Everybody thinking it said 11 witnesses. Yeah, that Levin. Yeah.
By the way, before I go on with what I was going to say, thank you, Rice Street.
Oh, thank you so much, Rice Street.
Membership. So we really appreciate it. But what Levin got in was that he called and he tried to ask for the gun back. If the prosecution is going to say you were trying to dispose of it, why would you ask the gun to come back to California? You want the gun back to exactly this is saying you get the gun back. No, the gun's gone. It's in the people take things back and forth.
And Lewin kept bullying that point, asking, "Did you do anything else except?" Ask the guy you gave it to if he still has it. No, I mean, who am I, Columbo? This guy doesn't have any obligation to do more than that.
And I was trying to say, do you know what the conversation with the attorney objection? There was a way around that question. Are you representing him in any way? Did you take on the role of an attorney? Did you take on the role of a private investigator? You know that he's got attorneys and private investigators. Why would you in any way want to try to take on that? Except to find out that the gun was, you try to get it back and it's gone.
Yeah, I asked if he still had it. He said no. I know how these things get kind of tossed in this communal prop area, and that was the end of it. And, if you, Mr. Lewin, had reached out and suggested it was very important, or anybody in your office, I would have given you all the information you need to pursue it. But I don't see a badge. I'm not deputized here.
And they didn't hide it. this morning. There was no way to the defense didn't hide. We just discovered it. Here it is. The judge says, okay, if Levin's going to testify as to the fact he tried to get the gun back, right? Prosecution has the ability to interview on tape the person in New York, and that's exactly what they did. And obviously, they didn't find out anything that was different than Levin was saying. That it was a prop gun. I think they've done a great job of that, Michael. Also answering your question, because you thought that was the one deficit.
I really did, and I think they did a reasonable job. It's not as satisfying as here's the gun. We've traced it to all these locations, and now we have it. But still, if you're looking for a reasonable explanation, I think the jury now has that.
Right. I think the jury absolutely has it right now. But we'll see. I mean, there's another witness that the defense may call, as what I expected. The defense wanted to sum up tomorrow, right? As I expected, right?
Yeah, they're working on it. Yeah.
Wanted to sum up tomorrow. The judge said it wasn't Lewin who was going to do the first summation. The judge said he's not going to force the prosecution to sum up because what I think I heard Judge Tacopina say, look, if we put the witness on and then you're finished, Your Honor, it takes about an hour to charge the juries. Can we do this early afternoon? Can we sum up tomorrow? Because if not, we're talking about next week. And then Lewin said something like, well, really, here in California, well, maybe Friday, do it because then we've got a rebuttal summation, and then the jury wouldn't come back to what? Is it Monday a holiday, or are they taking the court holiday on Wednesday that we take in the East Coast?
I know it seems like they have Wednesdays almost as a dark day for cleaning up other cases. So Monday is President's Day. Is that right?
Well, they're taking Lincoln's birthday off tomorrow. It's a court holiday.
Oh, okay.
Oh, well, not tomorrow, Wednesday. So President's Day is here on the East Coast, but do they work instead on President's Day there?
No, because that's a federal holiday now.
Yeah,
so I don't know.
Yeah, well, it does have like George Washington. Who knows anymore?
Yeah, well, all I know is that anybody could take those extra days. They take them. States, federal, schools.
The jury back and to deliberate on Tuesday. It's ridiculous. Push it. But that's clearly what the prosecution wants. They want the defense. I think if the defense could have closed today, they wanted to close today.
Oh yeah. Another interesting point. I made a couple of notes here about Mr. Levin. Hey, Mr. Levin. He was talking about the Glock 43 magazine that they found at Rocky's house.
Right.
And Lewin kept circling back because there was some confusion over the guy has a couple of guns, but he somehow got that magazine by mistake when he was at the gun store, and they're $20, so he never bothered to take it back because Lewin was trying to make a big deal out of it. If you don't have that gun, why didn't you take that magazine back? Well, it's $20, just gas and a pain in the butt. I kept it.
Right.
But he keeps circling back to that to make it sound like Levin has purposely planted this Glock 43 magazine, to which he has no matching gun, at Rocky's house to explain why it's there.
Yeah. And at one point, I thought really the judge should intervene because it was like Lewin was saying, maybe trying to make him say that for some reason he had to have the permit to have this weapon, and he didn't have the permit. Almost like he was trying to get him to admit to a crime. I was like, well, yeah, no, everything's registered. I mean, it was insane, Michael. It was insane.
It's just a bad look, and I understand he did make a couple of points. He did with Levin, who on repeated questioning was getting a little soft, getting a little wishy-washy on the series of events and why he had the prop gun, and then there's the magazine that doesn't match, and when did you go to the gun range, and how often have you been there? And so he made a little bit of hay out of that. But again, on balance, it was at worst, it was a push for the defense. And I think it was probably more like 70-30 favoring the defense.
And because Lewin was getting so frustrated, he again gave away what he's going to do in I don't know if he gave it away in closing argument, that Rocky had a Glock 43 and that he had 2 magazines come with it when you buy it, and that this one magazine, they got rid of the other, but they accidentally didn't get rid of this. Well, if you're going to be a mastermind and get rid of the gun and the magazine, you think you're going to forget the one next to your bed?
That's what gets me back to the big picture in this particular case. Nobody involved, except for Relli, gave this a lot of attention. The prosecution didn't. The key witnesses didn't. And Relli was all over it, but he was the only one. Everybody else kind of, and so the investigation was horrible. The recollection and the actions of these different witnesses, not so good, because to them, it wasn't the big deal that Relli was making it out to be, either for his financial gain or just to get back at Rocky because he wasn't being treated properly. So he's going to stick it to him with a criminal case. It's just really a poorly put together case.
But it all comes down to the jurors. You and I are done. I think certainly our viewers are done. Our chatters are done. I think that if the jury hasn't found in their mind that the state has proven their case now, there's nothing that's going to change them at this point.
No. I do not think people are sitting there going, "Oh, closing arguments! I can't wait to hear them so I can figure out what I'm thinking." Oh, I have. Dizzy tells me that we have another speaking objection here. One that I have two of them in the folder.
Well, before you go, Rice Street, thank you, became a YouTube member. We appreciate
Oh, very
it.
nice.
And before you get to that, just one other point. If the jury, however, is on the fence, I want to talk to our viewers about that. If they're on the fence, are they going to stay on the fence or what?
What do they need to hear to push them over one way or the other?
Yeah. What do they need to be pushed over? What do they need to commit an assault and battery? Okay.
They need to be shoved off the fence. So am I waiting, or do you want to see this one?
No, I want to see it.
Okay, I think this is the right one. I have two that have the same title. Is this the right one?
What happened to the gun?
Yeah.
His response would have been, I have no idea.
Objection, Your Honor.
I can play it from there if you like. The court made certain rulings.
The objection is sustained. Do you recall the other day I talked about speaking objections, arguing?
I do.
Remember that? Do you remember that?
I do.
All right, I'm keeping track of every speaking objection that is made, every argument with the witness, argument with me. I'm keeping track of all that. He made an objection. I sustained it. Come on.
All righty. This is where, as I say, let's go to the tote board. Judge, let's go to the tote board. He's keeping track. So when we have been suggesting that, the judge has maybe been hesitant to rule solely against Lewin, where he did the very first day after he said, I'm going to impose these 1074 sanctions up to a maximum of $1,500 per day or per incident. He nailed both of them at the same time. That's one for each of you. And then we saw Lewin acting up, not so much Tacopina, but never an outward admonishment by the judge. So I kind of thought, well, I guess he's letting him off the hook. Well, apparently not. Apparently the tote board has been continuing to roll forward, and we won't know till the hearing after the trial exactly how many instances this judge is tacking onto the tote board. They could have quite a bit of money.
There's another stop yelling. Let's see. And then we have a special guest. We have Dave Arenberg waiting in the wings. There's another stop yelling, Michael.
Do you have a stop yelling one? Let's see. I thought I did a stop yelling one already. No? Or is there another one? Let's see. This is a different stop yelling when I get you straight. Yeah, this is the stop yelling. We did this one, I think.
All right.
Why are you bringing a prop gun with you when you're meeting with another ASAP?
I don't think he brought it to like this.
Motion to strike is not responsible.
Stop yelling. Stop your yelling.
Motion to
You
strike.
can just make the motion and state the reason. You don't have to yell.
Yeah, don't have to yell. Yeah. So anyway, so yeah. So what's happening then tomorrow is we're going to have a new witness,
Maybe.
perhaps, and they're starting at 10 tomorrow, 1:00 East Coast time.
Probably the defense is going to review whether or not they need the witness, whether or not they can push forward with getting the prosecutor to close earlier and get this case to the jury. I think it depends. We're not in the courtroom, all right, and you always have to see what the jury is doing. But I know our viewers are like done. I mean, they're done. They want to get this to a jury and get their verdict out. I mean, if our viewers are any,
and that's where the fun begins, because we all have our thoughts and observations and opinions, but we don't mean squat. It's what the jury does that matters. So. Hey, welcome to Justice Served TV. Hey, special interview today. You may remember that I accosted this man on the steps of the courthouse at the Karen Reed case about a week ago. We were talking about, I guess I should identify who you are. Robert Berschke, yes. That's an interesting name. We talked about that too. German derivation, right?
Yep. Swiss during the war.
And this guy is a First Amendment aficionado, and he was there in the Karen Reed case because he's representing Gretchen Voss, a reporter for Boston Magazine. She did 3 interviews with Karen Reed, one in June, one in July, I believe in 2023, and then there was a third interview where the attorneys were not present, and it was more at Karen Reed's house, more casual, and the prosecution had been seeking and had received audio tapes from interviews, but they also wanted notes, handwritten notes. And as we know, we've discussed in Massachusetts, the shield law there is, if it even really is considered a shield law, pretty weak in terms of protecting journalists. And that's where Rob comes in, and that is he steps in and says, "Wait a minute, this is not unfettered access to reporters and journalists' materials. You got to take a stand." But as I said before you went in there, Rob, this is a motion to reconsider. And that's like, Mom, I don't want to go to bed. I told you once you're going to bed. And then you say, Mom, I don't want to go to bed. It is so hard to win a motion for reconsideration. So tell me how you set this thing up, what the game plan was going in.
Well, I had to do a little bit more than say, Mom, I don't want to go to bed. And I credit the judge. It's not easy for any of us to admit that we may have gotten something wrong and to listen to somebody who's telling us that they think we got something wrong. And it takes some humility and it takes some integrity. So I credit the judge for being able to modify her ruling. And I'm grateful for that. We had been through this procedure once before, because as you know, and many of your viewers know, the case had ended in a mistrial when it was tried the first time. The prosecution had tried to get these notes for the first trial, and we had opposed it at that time, and the judge granted our motion. We opposed them getting the off-the-record interview notes, but we permitted them to get the, in that case, redacted audio recordings of the interviews that took place with the lawyers present. Our thinking behind that was that with a state like Massachusetts, which ironically has one of the poorest records in terms of the shield law of any state. We're one of only 10 states that do not have a shield statute. We do, though, have some level of protection for reporters keeping confidential the identity of their sources or the contents of their notes. But it's a hodgepodge in the law. It's based a little bit on the common law, a little bit on the First Amendment, a lot up to the judge's discretion. And all of that adds up to something that only a lawyer can love, because it's the grist for argument, and arguments that can be made on both sides. That ends up being expensive for a client, which is part of the reason why we have a bid on to try to get a shield law in Massachusetts to be able to shortcut this procedure. But in any event, given the lay of the land in Massachusetts, we thought we weren't going to win a case if we said we're not going to produce anything. So we said, look, we'll produce the material that we knew was on the record, that the lawyers were involved with, and that appeared in the piece. But we won't produce, or what we'll ask the judge not to have to produce, is this off-the-record interview, which was just between Karen Reed and Gretchen Voss at Karen Reed's home. Took place in between the other two interviews, actually. And the purpose of it really was twofold. One, to increase Karen Reed's comfort with Gretchen Voss and to put her at ease and, try to get her to open up with the reporter. and also to allow Gretchen to get the kind of extra detail that you need in a piece. The rosary on the bureau and the other tchotchkes in the apartment, in the home, and that sort of thing. That's where we wanted to draw the line. And we were able to draw the line successfully for the first trial. When the case came up for retrial with the new prosecutor, the same request came in, except this time even stricter. They wanted an unredacted transcript from the lawyers' interviews. And I, in my naivete, thought, well, we won this motion already, so this will be easy. And I went in and said, Judge, it's the same motion you denied before. The facts are the same. You should deny it now. And the judge said, well, no, Mr. Birchie. This is a new trial. We have new prosecutors. They've made a request for more than what the former prosecutors wanted. And I'm going to listen to them. And besides, part of the reason that I ruled in Ms. Voss's favor for the first trial was that she had been subjected to a fair amount of harassment in this trial that, as your viewers know, has become quite a cause célèbre in Canton, Massachusetts, and in Dedham, Massachusetts. And she said, and you tell me now that your client Gretchen Voss attended every single day of that trial, so she must not be getting harassed anymore. And therefore, I'm going to rule that she has to produce everything. I was taken by surprise. I met with my therapist. No, but this was an important ruling. And again, we wanted to fight what we thought we could win on, and not try to get more than we would be able to get, following the old axiom that a pig gets fat, but if you're a hog, you get slaughtered.
Yeah. So that precipitates the first motion for actually would that be the second motion after that?
It was the motion for reconsideration, really.
Yeah. So you basically go back saying, now you're armed for bear, to continue our animal references here. Now you know what to expect. And how did you change it up? What was the tactic?
Well, we did a couple of things. One, I went to great pains in our motion for reconsideration to tell the judge how this thing was not like the other thing, that this off-the-record interview was very different from the audio recorded interview, that the off-the-record interview was the result of a promise made by Gretchen Voss, an investigative reporter, to her source, Karen Reed, that nothing in that interview would be disclosed publicly, except incidental details, without Karen Reed's express permission. And it's important that a reporter be able to keep their promises like that, because if they can't, as social media comments were already revealing, if they can't keep those promises, they lose sources. And
that leads me to this question. Did Gretchen Voss ever reach out to Karen Reed and say, hey, they're pressing me for this stuff, can I do it?
She didn't. And I actually saw a courthouse steps interview with Karen Reed in which she said, I don't really care whether Gretchen Voss reveals this information or not. But the law says that the privilege belongs to the reporter, that the reason for the privilege is to be able to allow reporters to operate with First Amendment freedom to gather the news, and that a reporter should not be put in the position of having to go to their source and pressure them or ask them to renege on the promise of confidentiality.
I was curious what Reed thought. Obviously, her feeling about her situation should not penalize others who down the road are in a similar situation. Now, as I understand it, you guys provided the notes to the judge. Is that right?
Well, the judge after she got our motion for reconsideration, she set a hearing date, which I was happy about. I wasn't sure that she'd even entertain us in a hearing. But along with that hearing date, she said, I'd like to see the notes for myself. And that was another decision point, strategic decision point for us. On the one hand, if we said we're not producing the notes anywhere, what are we doing producing the notes to the judge on the case? And yet, I had a pretty good sense that if we did not let the judge see these notes for herself in camera, in her own chambers, without disclosing them to anyone else, without revealing the contents of them on the record anywhere, that if we didn't allow her to see it, she wasn't going to have much sympathy. Now, common sense tells us that if Karen Reed blurted out to Gretchen Voss in her off-the-record interview, actually, I killed him on purpose. I was drunk, but I was mad, and I just had it with him. Somehow Gretchen would have found a way to write that into her article.
You think?
But
Yeah.
I think the judge needed to see that that wasn't contained in the notes.
Yeah, and that was kind of the reason for my question, because it seems to suggest that there wasn't much in there, and therefore the judge seeing those notes and confirming for herself, I'm speculating now, that there wasn't much in there, made it easier for her to decide as she did.
Maybe. There was 18 pages of notes, single-spaced. There was a lot there just in terms of words, but it was factual. It wasn't particularly interpretive.
Do you think the prosecution was just fishing, or they had some idea what they might find?
I think they were fishing.
Yeah.
I think they were encouraged by the on-the-record stuff that they got from the audio recordings, and we had originally produced redacted audio recordings that did not have off-the-record comments in them. And they sensed enough there that they smelled something and felt that some of the passages implied that there might have been some other things going on in those interviews that they wanted to look into further. And that's why we produced the unredacted audio for the retrial. But as to the off-the-record interview with Reed, I think they were absolutely in a fishing expedition. They had no idea what was there, and they just wanted it. And, you can understand why they want it.
Oh, of course. The
reporter's done a lot of hard work and gotten a lot of facts. It would save them a lot of trouble.
And if it could corroborate their story, great. That's
right.
I get that. So is she going to testify, Gretchen Voss?
No. We hope she won't be called to testify. I don't think she's needed to testify, since the only thing that's been produced is the audio recordings, which really are self-explanatory. And one of our concerns was if we produced the off-the-record handwritten notes, that would have caused them to have to call Gretchen to the stand in order to read her notes.
Sure.
You can only read her handwriting so far. And that would have led to another set of problems that we raised before the judge in our motion for reconsideration, which is that if the witnesses in this case are being sequestered, they're not allowed to sit in on the rest of the trial. So if she's called as a witness, she can no longer report on the trial. And for an outfit like Boston Magazine, that is not the New York Times or the Washington Post or CNN, they have limited resources. And if Gretchen Voss could not cover the trial, they probably would not have been able to have anybody covering the trial. And that's obviously a loss to the public interest as well.
So with the issues that Ms. Voss has seen.
I'm sorry, you went out for a second.
Okay. Yeah, the drama that Ms. Voss has gone through, there've been personal attacks, and I'm sure things that she'd rather have avoided. Do you think she has any regret?
Absolutely not. She's a serious investigative reporter. And unfortunately, we live in a world where reporters have become to some degree celebrities, and on social media, their every action, along with everyone else's every action, is scrutinized and criticized by people who aren't necessarily very sensitive. That's particularly true, by the way, of female reporters. But Gretchen has a thick skin, and we joked the other day about how somebody out there said that she was ugly, and I assured her she wasn't ugly, and she said, "Don't worry, I don't care one way or the other."
Hey, that's a good one. Yeah, I mean, that's people are just
It's second grade.
Yeah, it really is. Well, she's got to be happy with the result, right?
I think she's very happy with the result.
Yeah, great.
And we all are. And one of the things that I think brought the result about was the fact that we made the strategic decision to call in reinforcements. We reached out to various media organizations in Massachusetts and beyond, and we were lucky to get the support in the form of an amicus friend of the court letter or brief to Judge Kenney from the Reporters Committee for Freedom of the Press in Washington, D.C., the Massachusetts Newspaper Publishers Association, the New England Newspaper and Press Association, and the New England First Amendment Coalition. And I can't help but think that seeing that this was not an outlier of a request from us may have helped to influence Judge Kenney's decision.
Wow. Nice. That chorus of voices definitely did not hurt, I'm sure. But you were the lead tenor or baritone on the program, and as I told you before, we want to give you an attaboy because it is so rare to see this kind of change of heart by a court. Sometimes it's stubbornness, sometimes it's laziness, sometimes it's just not something they do, and say, you know, I might have been wrong. And it's refreshing to see it, and the fact that you were successful in getting that to happen is laudable. So we appreciate it, and hopefully you'll get.
There was one judge who said, notably in a case where he granted a motion for reconsideration, wisdom often comes too late, so it ought not be rejected when it comes.
Well said. Yes. And so best of luck continuing to create a shield law there in Massachusetts, and in the interim, you keep fighting the good fight, Rob.
Okay, and thanks for your good coverage, Michael.
You bet. Take care.
Hey, did you see the guy handing in there? No. They weren't in. Oh, they weren't in the courtroom. No.
How you doing, sir? Michael Bryant, Justice Serve TV. How do you think it went in there today?
I went well. I thought it went really well. Where are you from, sorry?
Justice Serve TV.
Okay, cool. Yeah, I thought it went well. I think that she's definitely going to rule in the defense's favor with the Daubert hearing. She doesn't want to do this. You heard at the end, she's like, April 1st. We got to do this by April 1st. So I definitely think that they're not going to have, that they're actually going to rule in her favor for once. They wouldn't let us read her. No, I think they just told me. They have it for the available. Oh. There's a hearing. I mean, they could be here for another. They're here. Brino has a thing. And was there to protect them, so.
Mr. Jackson. Mr. Jackson, Linda Kenney Baden is my co-host. She wanted me to say hi. You know Linda Kenney Baden.
Tell her I love her.
Tell her you love her.
Love you, Linda. Love you.
We'll talk to you soon. Bye.
Hi, I know you're all waiting for this, boy. I am I don't know about you, but I am exhausted, and I actually was working during listening to this. Mr. Lewin is finished, and Mr. Lewin is finished on a put down in front of the jury. I think I got it right. He asked the question, I want you to tell me what you're testifying is reasonable, right? Is reasonable. Objection, argumentative, no, irrelevant. And then the judge says, as Lewin begins to argue, which he tried to a number of times today, without it had $1,500 being imposed, right? The judge then says, no, we are done with Mr. Phillips. He has answered every one of your questions. We're going to clip that and play that later on tonight.
Not going to be coming in because both sides have come to an agreement on what the witness would say. It's another stipulation. So who's going to?
I'll read it here.
All right. So listen to what he's going to say. This has been agreed to, stipulated. Go ahead.
The people in the defense stipulate that the prop gun testified about in this case would have ejected 2 fired cartridge cases as it was fired. The fired cartridge cases previously marked as People's Exhibit 32 were not fired from the prop gun. So stipulate this.
All right, the court accepts your stipulation. All right, I'm going to read the jury instructions to you now. And if I just read them, I think it's not going to make sense because you're going to get self-defense instructions. And you might think, well, why are we getting self-defense instructions? Here's why. So, and that will, I think, make it a little easier.
Were answered every one of your questions, basically over and over. We are done. Okay. I mean, I give Mr. Phillips great credit, great credibility for the fact that he did answer every single one of the questions. He never lost his cool. And the other thing, I don't know how you all feel about this, and I'll wait for Michael Bryant to get on, is that, yes, Bev Mills, beyond exhausted, is right. There's Michael Bryant. He's going to get hooked up as we start. Beyond exhausted is right. Michael Bryan, are you hooked up yet? Not yet.
I believe I'm hooked up. Do
You
I
are
look
hooked up. Okay. I don't know. Are you hooked up? I guess I got to get my shot in a little bit so I look as tall as you. I don't want to look like this little shrimp over here. Not that I'm denigrating shrimp, but at all. But I don't know if you heard the last put down. I'm just disgusting.
Oh, definitely. Why? You know,
Oh!
he's so much smarter than that. He really is. Why would he ask such a stupid question? It's such a desperate, stupid question. Do you think what you've testified to is reasonable? I mean, it's just a stupid question.
Yeah, because he can't stop. He just couldn't stop. I mean, he also asked for another half. Remember, he asked for an additional half an hour because with the new information he received. I didn't hear any new information that he received.
Well, here's the deal, and this is interesting. We'll learn about this when Lewin testifies, and that doesn't mean 11 witnesses. My speculation was correct about why people were saying there's going to be 11 witnesses. No,
yeah. We have it again. We tweeted it out this morning that we believe that
Lewin and people heard 11.
Right, will be the last witness for the defense, and the defense is going to try to sum up tomorrow. And if the judge has any indication about whether the judge is finished, well, I think we just heard it. Right.
So yes. So what were we talking about?
We're talking about Lewin.
So what happened was Lewin agreed to talk to the prosecution, unlike 12E did not agree to. Relli did not agree to. Lewin did apparently over the weekend. And so based on the information they received from Lewin in that interview, Lewin believes he deserves more time in the cross-examination of Mr. Phillips. And he
believed it. He believed it. He used it, but he didn't ask him anything except.
Well, we don't know. I don't know. I don't know what he heard.
He's asked him, Did you ever have a conversation with the defendant? He keeps calling him. That's ASAP Rocky about where the prop gun is. Do you know where the prop gun is? Have you ever talked about where the prop gun is? And I really I thought the judge should have stopped it at one point because he said, hypothetically, assume that it's a real gun. Well, hypothetically, assume you're committing a crime by hiding evidence. And I think the judge should have stopped it. The judge didn't because, Toby was like, I don't know. I don't know.
Yeah. So it'll be interesting when Lewin takes the stand. I assume that what they learned from Lewin helped them on this cross relating to who was where when, as they've gone over so many times, but who was where when based on the video and based on the testimony from Relli prior to today. So I think that was what he alleged needed that extra 30 minutes to kind of flesh that out a little bit. So we'll never know. We'll know when Lewin takes the stand if there's some interesting cross.
Well, but here's the thing. He said apparently Lewin supplied other information that the defense also got last night, that Lewin took the prop gun, told ASAP Rocky that he didn't need it after that incident. Let's just stop. Lewin took the prop gun, that it was a prop gun, and Lewin is the one who knows where it went or what happened to it or whether it was disposed of because it wasn't needed anymore because it was just a danger.
And I think that's a weakness in the defense case. Where in the hell is the prop gun? I really do think that's the weakest point.
But I think they're trying to address it. But if they address it, then what the judge says, that the person in New York who apparently Lewin gave the prop gun to has to be interviewed by videotape, right? There has to be a tape of it, whether it was a videotape or regular tape, before Lewin can testify as to what happened to the prop gun. So if it is a weakness in defense, they're trying to address it at this point, and the judge says, well, there has to be another witness. So if there's going to be another witness, then you know where this is going. This is going past Wednesday because Wednesday's a court day.
Happy Valentine's Day.
Happy Valentine's Day.
Right? So we'll see. And I mean, to me, I think they need to try to come up with some explanation as to why that prop gun is just missing in action. It just seems a little odd.
Yeah, I love it. Yes, assume the defendant. That was another question, right? Creed. Assume the defendant did it. I want you to assume he's guilty, right? And he says, I can't because I was there and he's not. And the objection moved to strike. Well,
listen to my question. Listen to my question. Listen to my question.
He must have gotten the tell that we're all saying that what I'm asking you is, because he didn't do that.
He changed that to listen to my question.
Listen to my question. Listen to my question, right? Listen to my question. Oh my gosh. I don't know, but I was just like, poor even Tubi the poodle is now barking, saying, gosh.
Yeah,
I don't know.
I had a few questions that came up as I'm looking at this. The key, of course, to this cross-examination is to try and get Phillips to admit that Rocky was the one who was putting people in danger, and Phillips continued to reinforce that, no, Relli was attacking us, and that's why we did what we needed to do. Listen to my question.
Right.
Until you give me the answer that I want, I will continue to say, listen to my question. I did think there was an interesting exchange about weapons. When Lewin was saying, "Isn't it true, sir, that you had no weapon? That Relli had no weapon that night?" He said, "Well, except for his hands." And he said, "You consider hands a weapon?" Yeah, I do. Sure, you may decide that hands are less lethal than a gun, but they are a weapon.
Right.
So I
Right.
thought it was a weird road to go down. But he did.
But he did. He went down a lot of the same stuff. I mean, when I started hearing today, I know I can see in our chat that people are kind of fed up. I mean, Pokemon 073 said about Lewin, I assume he's wound a tad tight. Yeah, yes or no. And then and when I had this theory that juries really hate when you object when the person's trying to explain their answer. And normally a judge will say, let them explain their answer. Here this judge is very, very tight on yes, no. And when Lewin says everything beyond yes or no, it's stricken. And I don't think the jurors like that. They're there giving their time. They want to hear what the witness is trying to say.
And they've heard most of it by the time he tries to get it stricken. They've heard most of it. And I understand the court is A, trying to move things along, and B, on redirect or recross, the person asking the question that's been cut short can ask the witness to flesh that out. I get that. But that just takes longer.
Right.
So, the judge can have it both ways. He can't be cutting these things off, trying to speed things up, knowing that they're going to come back to life when the examination continues by the other side.
Yeah, and I'm just telling it again, though. You never want to end 2 days of cross-examination with the jury and the judge and Lewin going back that he wants to ask more questions, and the judge says no. He has answered every question you asked.
And that was to Joe. He told Joe that, though, which is unfortunate, that the defense was the one who received that enough already. Because
it was Lewin. Lewin
wanted
to go back.
Lewin finished, and Joe wanted to use a couple of questions, and he said no. This guy's asked every question he possibly could be asked.
He's answered every question that he's answered. I thought it was to Lewin because Lewin wanted to do. So you and I have to go back and listen to the video.
Go back and look at that. I swear Lewin was done, and then he was going to have a couple of follow-up according to Joe, and it was no. This guy's asked, and then Lewin says,
"I have it that Lewin came on after Joe."
Check us on that. Check us on that.
He's answered every question that he's been asked. We're finished.
He's definitely said that. Then Lewin says, but this witness is excused subject to recall. And then there was a whole back and forth about, the judge is basically saying, why in the hell would you want to recall this guy? And if you do, he leaves the door open, though. He says, if you do, I want to know exactly why it is this witness needs to be recalled. Now, here's what he told the witness, Mr. Phillips. He said, if we do need you back, we can't keep you anywhere really, but if we need you back, then you may have to come. You may have to be here within a day to get here. If he leaves the state of California, even though technically there is some continuing jurisdiction because he's been there as a witness, he's not coming back. He's not coming back. So the judge, I think, almost kind of made it sound like, get the hell out of here while you can, pal.
I know. No, and then there was something else I read. I was writing all this. I was trying to, I was out for about an hour and a half this morning, trying to listen to my ears. I was traveling, but there was another thing, and it skipped my mind, and I can't read my own writing here. I know that doesn't come as a surprise to any of you who deal with me, right?
Well, I thought at least you could read it. I know that nobody else can. I had an Instagram question while you're looking. I had an Instagram question because I heard the topic was, social media posts, specifically Instagram, and we got back to, Relli standing in front of expensive cars and things of that sort. And Lewin suggested, I think it was Lewin suggested that you have to own the item you're standing in front of. There's some term and condition in the Instagram world that if you post something and you make it look like you own it, like I'm standing in front of this beautiful car, that you actually must own it. First of all, I think that sounds ridiculous. But is that really, could that be true? I started to do a little research on it, and I got sidetracked. If anybody knows who's more, in the Instagram world than I am, and that wouldn't have to be too much.
Yeah, does anyone know that? And is it enforceable, and has it ever been enforced by?
Well, it's
anyone?
just I never heard anything.
Just so you know,
I never heard anything like that.
My feed of you, and I may have to take off my microphone here, because my feed of you into my microphone. Can you still hear me now?
Oh, I can hear you fine.
Yeah, I'm going to have to take the microphone out. I think I'm having a little problem with the second microphone that we've bought here, and I'm going to have to go off the microphone. The microphones.
You got to go for the $15 one instead of the $10 one.
Well, no, this is actually the $100 one.
I know we bought relatively expensive
start with, remember?
microphones early on, and they both crapped out. So we went for lower grade models, and mine at least
we are
has been fine.
It's it may be my computer, by the way. It just may be the ports into the computer. They're Lewin tired.
Okay, so let's get into the is it a prop gun? Is it not? First of all, I think the whole term starter pistol has just confused people a little bit. They do make starter pistols that look like semi-automatics. It's just they're very rare. Most starter pistols, that you see at track and field meets, or where else would you see one? That's probably the most common place, right? Those are like a little 6-shooter, like a little revolver. Spin the barrel, throw the bullets in there. But they do make them semi-automatic, meaning no barrel to spin with the bullets in it, and it also means that the cartridges would eject, just like a real, more normal gun. So I think
I was going to ask you, right?
Just to think prop gun is probably the better way to think of it. It's just not designed to shoot bullets, okay? But starter pistol, I think, makes people a little bit confused as to what they would see if they had the actual gun, which is another reason I wish they had the actual gun.
Well, that's something I was going to ask you. For instance, like when you have sailboat races, right? There's a starter pistol, right? The shells don't object from that.
Right, because that is a revolver, and that's why I think to use that phrase starter pistol confuses folks, because it's a whole different animal. Dizzy has figured it out here. She's Instagram savvy. Not a shock. She says totally false, but yeah, that makes perfect sense. If you stand in front of somebody else's property, there may have to be some acknowledgement of that. That I get. Especially if you're doing it just like, hey, here's a cool car on the street, and you take a picture in front of it. Then that owner of that car may have some recourse against you. But
it's usually not enforced, right?
No, of course not. Unless somebody's license plate is readable and they can be traced to that, and who knows? Somebody has a nice car, maybe some thieves see it, trace the license plate number to your house and steal your car. That's a legitimate concern, but I don't think the rule is as harsh as it was made to sound in this examination of this witness.
Yeah. So there were a number of moments. I mean, the hypotheticals bothered me. Hypothetically. What about the whole idea of that video is great, and I love the fact that Joe Tacopina asked the word on that grainy video, because the video is grainy as best. I have called it. Why don't we get the experts of
I'm talking without
the
opening
Kennedy
my mouth.
assassination film out and freeze?
Oh, there we go. Quit interrupting yourself, Linda.
Yeah. Hi.
How are you?
How you doing? I've been busy. I've been trying to listen to the trial. A lot happening. I'm about to tweet some stuff out. I've been trying to work to see who the mystery witness was. Have you been following? Do you want to give an update to all of our viewers? Who we actually should tell them, Missy, that we're on live to answer their questions, and if they want to know what's happened, what's behind the scenes. I think I've got some information from. There's a lot of people around in that courtroom, boy.
All I can say is, when I first heard the judge this morning laying out the plan, I went, what? I've never heard. Let's come back in about a half hour. We need to try and sort out some things about a potential witness, and then I'll begin the instructions, and then we may stop partway through the instructions and have this witness testify.
Out of order.
Are you kidding me?
I think I think it would have been reversible error. Hello, Oasis Cat. I think it could have been reversible error. Now you can give instructions at the beginning. A lot of judges give the instructions at the beginning, right? So that but then they give them at the end again.
Yeah, that's like, but yeah, and the variations we see quite often, closing arguments before or after the instructions. That is a very common wiggle. Are we going to instruct the jury first and then have closing arguments? Are we going to have closing arguments and then instruct? That's not a big deal. But interrupting
not only that, instructions. When have you ever seen a judge turn a camera off because of instructions? That camera should be on.
Of
He
course.
started to explain. This was very important, and I started tweeting about it. He started to explain first to the jury, ladies and gentlemen, you're going to hear an instruction. This is my approach about self-defense, and let me tell you why. And then whoop, the camera's off. Come on. I wanted you and I have talked about that through this whole case since the Relli tape said that Rocky pulled out a gun in self-defense. We talked about that.
Yeah. And the facts as they've been developed by these various witnesses made it sound like, that could be a viable thing. And we figured it was coming. And then when it finally did, and the judge addressed it with the jury, it was like, sorry, go to the seal of California.
Yeah, go to the seal. But another very important thing happened. So here's what happened in the morning, and I will tweet because I have been working my sources because I did report initially that the defense was planning on calling a representative from Dunkin' Donuts. Linda runs on Dunkin'. You remember all that, right? Well, here's all my Dunkin'.
Working for a corporate sponsorship. All right, good work.
Yeah, so we certainly do need that, don't we? In any event, apparently there was a decision made that perhaps maybe because it would have, time schedules, getting the representative there, and all sorts of other things, like if Lewin would cross-examine for the next 3 or 4 days, right? That would throw off the schedule. And the defense apparently wants to close. They wanted to close yesterday. If they could have, they couldn't. They wanted to close today. We heard that yesterday, but they didn't want to, they didn't want to start closing Friday. And so the judge told the jury the closings will be Thursday. So I think scheduling had a lot to do with it. Do you really need it? If you think, by the way, I have my blanket on today. It's a little chilly here in New York. Do you really think that you either believe Relli or you don't? I mean, I think it would have been a boom because you and I talked about it. That's what I would do. But trials, as you say, Michael, are living, breathing things. And I point out to the Aaron Hernandez case, we had subpoenaed Bill Belichick, who would have given us some really good defense information. But he didn't get subpoenaed very quickly. It was very difficult to get him, as you can imagine.
I think Bill Belichick would be something like this. You ask a long, elaborate question, he'd say,
But we finally got it. When he finally called into the judge, we were just about to rest, and the question would have been, do we not rest and bring him in and delay this jury getting the case, or do we rest and not let the jury hear this information? And so you make those decisions. If you think your jury is spent, that they've had enough, they're done, you may forego having evidence that would be helpful for you in that period of time. And also, my view of this case is if the jury believes that A$AP Rocky is guilty now, nothing's going to change their mind. If the jury believes that he possibly could have done this, but we're not going to convict him because Relli is such a liar and we're trying to blackmail him, they're not going to change their mind. If the jury believes there's not enough to convict, they're not going to change their mind. I think that whatever is in their mind right now, nothing like that was going to sway them. That's my view of it.
Yeah, I think if you look at the reasonable person, whatever that is, of course, we can throw this out the window and we don't know what the hell a jury's going to do, but the approach has to be logical and practical, right? I think there can be a danger when you're in the midst of putting on your trial, putting on your evidence, of getting too close, close to things, because we're giving it a little more 1,000-yard kind of view, and I think most people would think, that might be great if you could get the Duncan person to create just another confirmation that Relli lied about something. But do you need it? Or if you're 95% there, do you need it really? And again, you are the defense. You don't have to prove anything to anybody. So I think, maybe this was a good thing for the defense. There was some practical consideration.
Cat Williams, who's on our Cat.
Williams, yes, thanks to Cat Williams.
Yeah, she was on my Twitter responding to this, and she thought it was great initially, but she said, and there was something really, really interesting. She said, look, this is in California. This is at the COVID time, right? Everybody knew that Dunkin' didn't stay open late, right? That they weren't 24-hour Dunkins like they are sometimes on the East Coast. They close early, and they're not giving a brown bag and a black pen to write on. They're just not. And so that someone from California is laughing at this plastic bags and Dunkin'. That's like she said so many here. And here's the actual quote, okay, from Kat, not Williams. All right. Shout out to her, by the way. I am laughing so hard. So many of us have been like, plastic bags at Dunkin' ? In California after 10 p.m. when there isn't a 24-hour store and during COVID. All right. So that's what she tweeted back to me. So, they were hoping for some of those, but they would love it because it would confirm what people in California know. But I would remind everybody that the people sitting on the jury are in California.
Yep. So, it would have been probably overkill, unnecessary, and to your original point, drag the jury along, for another half a day, perhaps. So,
now, and then so that you had that, and then you had an issue about whether they discussed the scheduling and whether this out of turn, and that's how the judge called it. He was very good not showing who it was for, whether it's for the prosecution, the defense. Out of turn witness would be called at 1:30, and that they had reached, there was a stipulation they wanted to read first. So I don't know if the stipulation has negated the possibility of an out of turn witness, but I will have, hopefully, if I keep working, sources, both in the court, out of the court, in Los Angeles, out of Los Angeles, and if you look on the internet, pretty easy to get sourced. Watching people on the internet, having people that they know. There was a stipulation about the guns, and I think it's important for us to hear it and maybe hear it again after we speak about it. Do you have that pulled into your assets there, Michael?
I do not have that. I do not.
Okay, so let's see if we can. Dizzy, can we get that into Michael's assets?
See if it is there. I will look, but I've not had a chance to dive in there and
It's
dig around.
It's less than I have it on my computer, but it's less than 30 seconds. I can tell you actually, it's 35 seconds. Maybe I don't know if I can pull.
And what was it relate to? Is it the stipulation?
It's basically said that the stipulation, and it was read by not Lewin, by the other Paul P. prosecutor, the lead prosecutor. By the way, Dizzy says it's on the drive, Michael.
Yeah, well, I'm looking for the title. I see stipulation. That's the one I'm pulling up.
Okay. Why don't it basically is important because it said that the two shell casings, this was what was read first. Yes, stipulations. Good, going. Well, if you're going to pull it up, why don't we
I am going to pull it up. So let's
and then we can
let me get out of a couple of things and get back where I need to be, and then I will pull that up for you here. Let's see.
I can't believe the judge turned off jury instructions.
Yeah, it's funny. I kind of wondered if he was going to or not. I was surprised when he actually did it, but it definitely crossed my mind. Okay, here it is, the aforementioned stipulation.
Both sides have come to an agreement on what the witness would say. It's another stipulation. So who's going to? All right. So listen to what he's going to say. This has been agreed to, stipulated. Go ahead.
The people in the defense stipulate that the prop gun testified about in this case would have ejected 2 fired cartridge cases as it was fired. The fired cartridge cases previously marked as People's Exhibit 32 were not fired from the prop gun. So stipulated. Yes.
All right, the court accepts.
Now, to me, just on its face, that's bad. that's bad for the prosecution. Well, now you've said, the jury's going to have to think, okay, those weren't from the alleged gun that was fired by Rocky, and they were found by Relli. Wonder if he may have just grabbed a couple of casings, said he found them there, and said so to support his story.
That's what I got of it. Especially,
I don't know how it. I really am shocked that the prosecution would stipulate to that.
Well, that's what I got out of it, because it went for. I think it was very important that it went first, that the cartridge casings didn't come out of the prop gun. Now, you know what the prosecutor is going to argue. They're going to argue that it didn't come out of the prop gun. We agree because it wasn't a prop gun; it was a real gun. That's what they're going to say. But
Well,
I think that stipulation was certainly a lot better. Now, the question is, was that stipulation, does that stipulation negate the quote out of turn 130 witness, mystery witness that the judge mentioned, because it relates to firearms and an identification of the cartridges?
well,
Let me throw that to you.
if they were going to be able to get something else out of that witness, no. If that was the core testimony expected from that witness, then yeah, the stipulation would obviate the need for that person, and that may be one of the factors, because the judge is, putting his thumb on things, saying, "Can we just get this done?" And I think if anything else, the judge is reading the jury as well as anybody. If you're sitting in that room, you can tell when the jury has had enough and they're ready to move on. Did you hear that alternate? Linda, did you hear the alternate? She piped up. I say she, just sounded like a woman. I may be wrong. She said, so what about the alternates? The judge is like, oh, good question. And then he laid out the bizarro way in which they segregate them but keep them locked up effectively, because if they need them, it's like a hockey team. You got some people in the penalty box, but when they're released, others are going to have to move in and out. So he wants them ready to go. If we need to use an alt to fill one of the people roles in the box, you need to be nearby. You need to be ready to go, which is unfortunate because you could tell from her questioning she was done. She was ready to go. I can't remember. Do they have 4 alts in this case? That sounds right, but I may be misremembering that.
No, I think it was 4
That's
alternates.
4?
But she was like, what are we going to do? And he said, we have to stay close by. She said, well, how close? Can I go home?
Exactly. Well, yeah, we need to be able to, and the
I-
thing is, unless somebody lives a couple hours away, the moment the court needs you, there's going to be this happening and then this. You don't have to be like right there outside the door with your ear to the door. You can be within a reasonable 30 minutes or so, that would be reasonable.
Well, usually when there's a victim that's close by, they allow extra time for the families to get here. But my experience has been is when the victims are not close by. I mean, when the judge says the jury has, you got a verdict, you better get there. I've been in a situation where you walk back to the hotel, and before you get to the hotel, what you do every day is you go in. Just so you know, a good lawyer will go in when the jury goes in, and the judge puts them in the jury room so they can just stand there and just show their respect. You show your respect to the jury, because usually the judge will do that. If the judge doesn't do that, bring them through the courtroom, put them in the jury. Then you don't have to. But usually, so you go in, and you get all dressed like a lawyer, and then you go back to your hotel. Usually I'm trying cases because I'm traveling in a hotel, and you get there, and you just get back to your hotel. You want to make a cup of coffee, a cup of tea. Hey, you got to
kick off your shoes. Yeah.
Take off your shoes, sit down, and you get that. You got to be back here in 5 minutes. It's a little. It takes you longer to get 5 minutes.
This is slightly different when we're just talking about an alt being notified that they are now in the box.
Right.
Because that's in the middle of deliberations. And in most states, when an alternate is brought into the box, guess what happens? Linda, they got to start deliberations over again.
Right.
Because the alt has been outside.
Fast. But it always goes faster. Now, I guess the other people.
Yeah, because they put the alts in a headlock. They say, here's where we are. Here's what we're doing. Got a problem with that? Yeah. Yeah.
That's a good way to explain it. Yeah, it's supposed to be. Yeah, it's supposed to start again, and I guess technically they do. But you're right. I think it's a headlock. Why don't you look at some of? Well, I'm trying to still work my sources. Why don't you look at some of these questions for me, Michael?
Let's see. Let's see what we got here. I'm looking at the starred ones. I'm sorry. Let me look at the starred ones.
Yeah, that's
okay. How could they read jury instructions and someone is coming in afterwards? Brooklyn. That is a very good question. And while I'm thinking about it, Brooklyn, just let us know if you got the mug or not. It may have ended up in Ireland. I don't know where things are going these days, but I think you should have it by now. I've never seen anything like it. I've never seen jury instructions split ever, anyway, for any purpose, unless, if there's a fire in the building, maybe. But yeah, I think Linda thinks it's reversible error. It ain't good, no matter how you look at it. It's definitely grounds for an appeal, and depending on where the break would take place, you know, if they get past just some very introductory material, they stop and then they come back. Maybe there's less harm. Maybe there's less. It's more harmless error than reversible error, but it's not good. It's just not good practice. You know.
Yeah. Yeah. So I mean, you know, you oh yes, Brooklyn got the mug, and she
Yes. Okay.
yes. Did you get which one did Brooklyn get? The one with the
I'll have to check with the shipping department on that and let you know.
Brooklyn's on the chat right now. So which one did she get? It took me a while. I think you may have gotten yours before.
I'll give you a hint without giving you a hint. Oh, wait a minute.
Each time, please keep an open mind. You have not heard everything. You have not begun your deliberations. And please do not look at anything on the internet regarding this case or look at anything in print media. All right, have a good day tomorrow. See you Thursday, 9:30.
Are you kidding me?
That's it. That's it.
So there's no
there's no
witness.
There's no extra witness. I am going to tweet something about that out. I'm going to tweet a question to all of you, and let's see what you think. The out of turn 130 witness. Do you think the DA was trying to get a firearms ballistic expert to testify? That's the first question to you all. And secondly, do you think that the stipulation negated that, where you know that the prop gun would have, you know, the prop gun would have ejected 2 cartridges, which weren't found, obviously, but the cartridges that the star witness brought in, the star witness, right? All right,
Don't match the prop gun.
Don't match any prop gun.
Yeah.
Could
Yeah.
not
So
match
I guess a prop gun has a generic set of markings that these cases did not have. Okay, so I know Missy, you're monitoring because they excused the jury. They may come back
9:30
like this.
on Thursday. Mr. Siegel, anything for the record? Mr. Tacopina, anything for the record?
For the record, no.
Mr. Pazlomian, anything for the record? No, Your Honor. All right, we're off the record. See you Thursday.
The jury back Thursday 9:30, right?
Thursday, yeah, and so we don't know for sure what happened before the judge excused the jury. Did he tell them all the witnesses are in, all the evidence is in, that we'll have instructions and closings on Thursday? We'll figure that out and spread that out there. It's hard to tell exactly what happened as they wrapped up quickly.
They wrapped up jury instructions. I don't think he, you know. So yes. I am. Here's a question: who was the out of turn 130 witness? Was the DA trying to get a ballistics firearms expert to testify? Did the stipulation negate that? And the jury is back at 1:30. I'm tweeting that out. I'm going to tag us at Justice Served. I'd like to have all your thoughts about whether or not that's what you think. That's what I think happened. You know. So you know, I also think that the whole idea of it was more important to get to Thursday's closing than it was to get a there you go, it's out, than it was
Okay.
Yeah.
So look, yeah, eyes out for that. Patrick Taylor, thank you, sir. Winning seems to be the goal for prosecutors, not justice. Zeal is one thing, and that is we've taken an oath to zealously represent our clients. In this case, the prosecution represents the state of California. Zeal is one thing, but the state is demonstrable. The state is demonstrable. Yeah, I mean, you know, that seems to be the takeaway from this case, even for those that have just done a drive-by, you know, that it feels like something's missing from the prosecution's case. They've either ignored things they shouldn't have, Relli, or they failed to get things they should have had, like, I don't know, evidence that any gunshot really took place, actual projectiles launched from a gun. I mean, there's zero evidence of that. There's zero. Even if you believe the casings that Relli found, or as I call him, Inspector Gadget, that he found when 7 cops couldn't find. Where's the projectiles? If not the actual projectile, where's the damage from the projectiles? There's just no evidence that anything with a projectile was fired in that vicinity. So,
yeah. And the interesting issue is there is that tape, and there's those 2 sounds, right? And you know, the sounds we hear on the tape. And the cops were standing right there. The projectiles would have been right there. Everyone ran. No one stopped to pick up anything.
So there is one question that even if you believe that the gun was a prop gun and not a real gun, there
Right.
would have been casings ejected. So where did they go?
Well, that's a question. But maybe, somewhere there's always a little bit of truth. Who knows? Who knows? And we're just speculating if really did go back and pick up the casings and they're from a prop gun. This ain't good because I know it's a prop gun, but it shows me going back there and then I'll just substitute them with casings from a real gun.
Yeah, that would give Relli a lot more brain than I give him because he would have to know, oh, damn, these are from a prop gun. I need to find some from a real gun. And I don't know. That's maybe he's a better ammunition expert than I give him credit for. But
yeah, but even if they weren't found, the point is that Relli says he found them. And that's the problem here. Relli says he found them when no one did. Well, a day later, 2 days later, a day later, yes.
Let's see what else we got here. Thank you again, Patrick. Ooh, did the
Thank
gun guy testify via deposition? Anthony Benet.
There's in California, unless there was a civil action in the civil action in California, it's not one of the states in a criminal case that you get to take depositions. Unlike there's 3 states you do: Florida, I think Kansas, and I forget what other state where you get to take depositions in a criminal case, and that has to be your discovery. If you don't take those depositions and you want to complain about not getting discovery, you can just row your boat down the river.
And that's, I mean, a deposition, it's under oath, so it's a more formal way to gather the same thing you could get with just an interview,
right.
Which we know wasn't done by the prosecution for most of the key players in this particular case.
Yeah.
So and the answer to the question is unlikely. And if the gun guy is, remember, there was sort of a gun guy that testified, kind of, sort of, bullet guy.
A tool mark examiner. He testified. Yes. It reminded me, and I never got to say this, but I think I tweeted. Remember, if you watch the OJ tapes, you'll see a DNA expert named Robin Cotton, because DNA really wasn't known much by then. And my recollection, and Michael, you can correct me, we can look it up probably. She was on the stand probably for days. I mean, I think I watched it again on one of the YouTubes had it or something. And days, just this lecture about DNA. And that's what he did. He had a PowerPoint, a shoe print to explain, class characteristics, which tell you nothing. All you can tell you, well, it's fired from a gun, and it could, because the class was fired from, 44 or this or that, or maybe it had 4 guns it just fired, but it can't pinpoint, and nor are you allowed these days, really. Most labs will not let you pinpoint to a specific gun. They can say, my opinion, these match the same gun. We had that in Hernandez. I questioned somebody for 5 hours over 2 days, and I put up the 2. They're microscopic shots, but they're very detailed a very specialized microscope in the comparison microscope. And he had said that this cartridge matched this cartridge, and then it was like 4 matches that he saw. But then we went through with the jury. Well, how about the other 16 that don't? So it's so subjective. It's so subjective.
It's important to differentiate between, riflings, which the projectile might have, which can be traced very specifically to a gun, almost like a fingerprint. But you're talking about, if the back of the casing is here with the igniter,
right,
where the pin strikes, the firing pin strikes that is much more generic. They could probably narrow it down to the type of gun.
Right, which I think they said it was a Glock. But the problem is there's so
there's a couple of those.
Right. This is a couple. I probably underestimate when I say a couple million, probably a couple 100 million of those hanging out.
Yeah. There are lots. There are lots of them.
There's definitely lots of them. But
here's the $64,000 question from Sheila. Do you think the jury will take long coming back with a verdict?
Well, okay. There are 2 types of jurors, and I'm giving you a little education in how you pick your jury. There are 2 types of jurors. There are jurors who go in and they say, okay, what is your all feeling about this case? They kind of get a feel for where everybody is. If you watch Clint Eastwood's juror number 2, that was kind of like what they did in that jury number 2. And then there's the other jurors, and they're the ones who want to hear the Tubies breaking in.
Weighing in.
Weighing in on
Wait, what is it? What is it, boy?
Mom, what are you doing without me in that room?
Somebody fell in the well? What is it?
Yeah, lastly, so I felt well. There's the second type of juror, and those jurors who want to see for themselves. They want to find the truth themselves. They want to go through everything. They want to go through the exhibits, and they want to come through their independent analysis, of course, with the tidbits that whatever side has given them. So it depends on what kind of jury this is as to whether or not this will be a quick verdict or not.
Yeah, and of course we don't know, and there could be one, aberrant witness or juror out there that just isn't on the same page, maybe hasn't followed the trial as closely as others, is hooked on one little nugget of information that was contested. You just don't know. You don't know. My gut tells me it should be fast. There's only 2 counts. That speeds things up a bit. There's no lesser included. That speeds things up. But other than that, it's all about the humans involved, not so much the technical process. I think it could be a quick verdict. Again, look where we are on the week, right?
Yeah,
they're going to get this case Thursday afternoon, right?
Well, did the judge put time limits on closings?
He may have, but it was off the clock. There was no recording of it. I haven't heard that. He may, but if you think about it, if they start Thursday morning,
9:30,
would you really have to put time limits on? I mean, if Lewin hits 2.5 hours, and I hear that Pauly P's doing the first part, is that right? And then Lewin's doing the rebuttal.
He's going to do rebuttal. So basically, the prosecution's case is going to be laid out in the rebuttal closing. All right, that's what's going to happen.
And he'll address anything that Tacopina has brought up in the defense closing. So I still think dripping wet. There's no way they don't get to the jury Thursday. Okay.
I think the judge should put, an hour limit, hour and a half limit.
Well, it'll be interesting to see. He's been, the only time he tried to impose that time limit was well into the case, well after the fact, well after Relli, who, forced Tacopina to kind of just dig in, So I don't know. I don't think if they really start timely on Thursday, I would think, if it's a time limit, it's a kind of a like, hey, can you guys 2 hours ish? It's not a hard 2 hours, and I'm counting I'm counting up the sanctions against you. It's 2 hours, give or take. Don't abuse that. I could see that. My point is though, they get it Thursday late afternoon, early, evening 5-ish. Hey, can we stay late, Judge? We want to get the hell out of here. Tomorrow's Valentine's Day.
Right.
So Thursday is kind of a quasi Friday verdict, I think. Because not that Valentine's Day is like President's Day or Christmas, or it's a wonderful holiday. I get it. It's a wonderful holiday. And I'm still unsure about Monday. Is Monday a court holiday?
It's a federal holiday, I assume.
So it's got to be. So now we're talking about getting out of there for a long weekend. So
right.
I think all of those things are factors. Does it make them jump to a conclusion they might not reach over time? I don't think so.
No, I agree.
But it does help speed up the process.
Yeah. I think the only issue that 1 or 2 jurors could have is, and they may get over it very quickly. Look, first of all, someone has to say, we're not here to decide really what happened. We're here to decide whether the prosecution proved their case beyond a reasonable doubt. So you need that juror, and hopefully that juror will be your 4-person, right? You need that
keep
juror.
everybody on track. And that's such an important point, and we've seen it in how many cases now. Let's say Karen Reed, what a surprise. Karen Reed case.
We talk about tonight on our show.
There's a couple of things we need to update on that particular case. And I've not heard back yet from the defense on the decision by the appellate court in Massachusetts. So
we actually are asking the lead lawyers, not just the person who issued the statement. So we'll see if we get a response.
Right. And they did have, obviously, appellate counsel was brought in to do that. That's a very specialized practice.
Oh yeah. Oh, yes, absolutely.
Especially in this particular case. And there were some unique issues, and I'm getting off to the side here. Let's talk about it tonight.
6. So that's like, you got to join us back at 6 p.m. Eastern Standard Time when we talk about this case again, and we talk about that case and see what, we'll see what leaks out of that courtroom as to what happened. Because Missy Mayhem pointed out today, she's been following it. They've been very secretive. Sure, they went in chambers, obviously discussing scheduling. They know what they're discussing. They know when the judge was saying an out of order witness, who the witness they're talking about was. And I just asked the question, Do you think it was a firearms expert or ballistic expert, as it's commonly called, even though it wasn't really, it's not really ballistics as we've discussed? Do you think the prosecution was trying to get that, or did the stipulation negate that? Or why would you even want one after that stipulation if you're going to have to stipulate? That sounds like the judge was pushing, like, well, I'm not going to wait till Friday for you to get a new witness. You can stipulate, you have to 1:30. That's what it sounds like to me. The judge may have been pushing and we don't know it.
Yeah, and whatever variable was up in the air, they resolved it, because he was just, I don't know if there's somebody coming in. I don't know if they are not coming in. Well, looks like they're not coming in. So what I was getting at was, I went off on my Karen Reed tangent. We've had these cases where the prosecution is done with their case, even before the defense says a word other than their cross, and you say, what the hell happened? That's the way I was with Karen Reed the first. What the hell happened? I don't know. I don't know. And in this case, I don't know what happened. Do you know for certainty, beyond a reasonable doubt, what actually happened? I don't know.
I have views on believability. I really have views on. I think that tape with Wally, to me, is the most important thing there is, for two reasons. One, because he did say that Rocky pulled out a gun, even if you assume it's a real gun at that point, in self-defense, because he didn't shoot Relli, right? I believe. I don't think those things. And you didn't hear any. If I'm in the jury, you didn't hear any medical evidence saying that was those are from a gun. He went to New York City for a hospital, for goodness gracious. If they were from a gunshot in New York City, they kind of say it. They had to report it to the police. Yeah. And maybe he didn't even say it was from a gunshot, in the records. Who knows? We don't know.
Yeah, that was a question about, the New York visit to the hospital. What did he tell them? And why aren't those records in the case? Why don't we have those?
Well, probably because I assumed that the Metropolitan Hospital wasn't going to go to California.
Yeah, but I think they could subpoena the records without a custodian, and I think they could get something.
I think you need that custodian in Cali. The custodian has to come. I remember that in Inspector, they dragged everybody from everywhere.
I think if the defense was faced with that, I'd stipulate to those records coming from that hospital, because I don't think they help anybody. I don't think it's just they're not going to be definitive.
Yeah, obviously they didn't help.
Somebody at the hospital
didn't help anybody. It's a good clue that we didn't hear that they didn't help anybody.
You think somebody at the hospital a day and a half, 2 days, 3 days later is going to look at that and say, that was caused by a bullet graze? Oh, who's going to say that?
No, absolutely not. And then, he didn't have his clothes. To show any gunshot residue. They asked him, I think the cops asked him, are you wearing the same clothes? So, where are your clothes? I think that was one of the questions that went by. But to me, the most important thing is the Wally tape, where he gives, even if you assume that the gun was pulled and he was shot at to scare him away, he gives the defense a self-defense. And that's the first thing the judge went to. He told him, you're going to hear self-defense. It tells me that maybe there was some issue, maybe the defense.
And then he disappeared.
And then the judge disappeared, because we talked about whether or not the defense would want that, didn't want that. But I think when you get into a case like this, it's lawyer malpractice. I'm not sure as the defense I would want it, but then I'd have to say, well, we're not saying it was self-defense. It was somebody else saying it was self-defense. So we'll have to see how Mr. Tacopina handles that on Thursday. And they may say, look, if all else, if you don't believe it, believe the tape that it was self-defense. Believe him on this issue, when he's clearly talking unabridged, and he says, about the, and again, as I'll keep repeating, I need to have a lawyer to get the bag, or else they call it extortion for $30 million. Okay. That's, and to me, once a witness says that, I'm like, I'm out of here. I'm not going to be part of suborning his getting $30 million from somebody famous, even if he was shot at this point.
And those are definitely some unknowns that hopefully will play out over time. But I can't wait to see what happens, depending on the result of the criminal case. What happens with that civil? I'm going to call it a civil negotiation, because I think that's what it's going to be.
Remember, the prosecution offered. You want to know how weak they thought their case was? They offered him what? How many days? 180 days.
180 days. Somebody just mentioned that.
180 days in the county jail. And
I'm going to get back to Diana Hayes. Stand by, Diana Hayes, but I'm going to bring this up from Brooklyn. And why did they offer such a high probation and 180 days? They couldn't. That seemed like a good deal on its face when the case was about to begin. People are like, wonder if he should have done that, right? And then we started. We broke the story about the 30 million.
That's right.
And it made it.
We're the ones who broke that story, by the way.
Broke that story, and made it very clear that he had good reason Rocky not to take that deal. But if you're the prosecution and you're looking at max 24 years on the 2 pending charges, if you do less
Excuse
than
me.
that, you're really caving in. I think they had to give something. So the high probation and the 6 months in prison or in jail, seemed like a good deal on its face, but the prosecution was bending over backwards just to get any conviction because, in my opinion, they thought the case was crap. Let's try and get rid of this before we embarrass ourselves. Well, now they've embarrassed themselves. What's the one charge I think is more likely to come up with at least arguable either conviction or hung jury as opposed to acquittal? Section 240, that's assault, right? California Section 240 technically reads attempting to injure someone else with the apparent ability to do so. Okay. And it's from the mind of the person being assaulted. So if it is a prop gun, unless Rocky told Relli at some point or Relli has independent knowledge that it's a prop gun, he could have the apprehension of being injured by that gun. We may know that it's a prop gun. Everybody else may know it's a prop gun, but it matters what Relli knew. So if he thinks it's a gun, that could create the apparent ability to injure him. Okay. So here are the elements.
That's where the self-defense then becomes important.
Of course. Yeah. Okay. Here are the elements. Here are the cookbook elements, the crime cookbook. Willful conduct. The accused deliberately acted in a way that would likely result in force being used. Okay. Again, force being used is questionable here because is firing a prop gun, is that force? I guess it is if you're using it to give someone the feeling they could get shot. Intent to injure. The accused intended to commit a violent injury. Well, that's going to be tough to prove if, in fact, it was a prop gun because you can't really hurt somebody with a prop gun. So, and that is an intent that is Rocky's intent, right?
Right.
Awareness of potential harm. The accused understood that the action could cause injury. That's also a tough one. Again, assuming it's a prop gun. Capability to inflict injury. The accused had the ability to apply force or cause harm. So all of those are up in the air if you haven't decided the prop gun versus real gun issue.
Right? But doesn't the indictment itself says that it was with a firearm, a lethal weapon, and so that's what I
don't have the indictment in front of me. Do you have that handy somewhere?
No, but if we'll pull it up for tonight. My recollection is the indictment says that it's with a firearm, a lethal weapon.
Well, I think it is. It's an aggravation. It's assault with a weapon, right? So there's simple assault. Right. There's simple assault, and then there's the enhancement with the deadly weapon. So yeah. I wonder if, as I'm sounding this out, I wonder if simple assault would be a lesser included of the assault with a deadly weapon if they wanted it to be.
I don't know. We didn't hear, since we didn't hear the charges. I wonder whether the judge is going to mark them under California law, the jury charges, and release them. We'll keep an eye, and all of you will keep an eye on California, because technically those jury charges that he charged, those are actual. I mean, that's a public document right now.
Well, and we do know the jury is getting them to take into the jury room eventually,
right?
Because he told them, "Don't worry about taking notes. You're going to get these."
Yeah, right, exactly. Which is a good thing, because jury charges
very
are
good.
Yeah, and normally when jury charge, the funny thing is normally when jury charges, you're like, even when you're a lawyer in the case, you're like, oh, I have to sit for the jury charges, right? You know, you're like, but these were not only fast. These we want to see, because these were important for how we're all viewing this evidence. We wanted to know.
I don't understand the court nixing that. I just don't understand it. It just makes you think, what are you hiding? Don't you want people to understand what's unfolding here for the jury? Right. We're all in the jury, in our minds as we watch the case unfold, and we're all deliberating. Can't we understand the law that you've given to the jury?
And it's just the law. It's the most innocuous thing that's going to, have, even if you publish those on the World Wide Web, the publication of jury charges is not going to influence anybody. It's just going to look at it to give opinions as to what we're seeing and put it in perspective and think about how a normal person who's not a lawyer, because we may read them differently as lawyers, Michael.
Right. And they're very educational for those who have an interest in this stuff. And it's also important to remember that in this case, unlike most that are a little more complex, that there's unlikely any special instructions, right? Special instruction is an issue that isn't quite handled by the cookbook. And so the court will go to the sides and say, hey, give me a proposed jury instruction for this very specific issue. And they'll put together two instructions that one side, one favors the other, and then the judge will help kind of meld that into something that everybody can choke down. That's a special instruction. I can't imagine a special instruction in this case. Can you?
No. Brooklyn asked a great question. Can the judge come in and do a directed verdict? Now, we don't know what's happening with this
It's
directed
another mystery.
For all we know, maybe it was argued in the chambers, because obviously there was a lot of things that happened in chambers today, right? There's things that happened beforehand, right? So we don't know. So if the directed verdict was held, right, to make a ruling after while the jury is out, because he wants to see and again, a lot of times some judges will hold it and see what the jury does, right? So that they'll say I'm just not going to do a verdict, a verdict notwithstanding, not guilty notwithstanding the verdict, right? They'll come in and they'll say, okay, I'm going to now actually rule on your evidence, Mrs. Kenney Baden, for your directed verdict or for your motion for dismissal that you made after the prosecution's case. So obviously those had to be made for the record. So were they made?
We are definitely assuming.
And the judge decided that the arguments, and this is a good point though, he could have decided that the arguments on those, on the directed verdict, which you would then adopt for your motion for dismissal of the state's case, that they were going to be nothing but press conferences by both sides, right? He could have decided that, let them argue it in chambers and sealed it pending, whatever happens afterwards.
Yeah, it's an interesting, if that happened, and we don't know because
We don't know.
it's been far less than transparent. I just think it's an odd slicing and dicing of what he allows the cameras to cover and what he doesn't. I just think that's odd.
Yeah, and I still think that if somebody has lied, and I think it's fair to say that we know that Relli lied in a number of issues, and I assume that the defense is going to put all those lies up and point to them. But I am still concerned about the whole idea. I know you have a right to bring a civil suit and all, but this whole idea of the 30 million in bag, I think, I'm worried. We know the judge didn't like Relli's testimony, right? We know it because he said our report basically was right about our exclusive report about what was happening with him and his discussion about whether the state was going to proceed after Relli 2 times, because he said to the prosecutor, and we posted it, Mr. Relli's testimony, Mr. Relli was not forthright. He was on the stand for 3 days because he wouldn't answer a question.
Yeah.
Right?
Yep.
Not forthright means you're not.
It's a nice way of saying maybe less than truthful.
Less than truthful, right? So we know. So thank you, because we know that and we said that, and that really validated our sources, multiple sources that we had for those 2 reports that the judge asked about whether the prosecution was going to go forward. First, based on ethics, and second, after during the middle of Relli's cross-examination, which was devastating. I thought to Relli, I thought he looked like a fool, and certainly not something that I would want to rely on. If this were, let's say, if this were my child on trial, would I want to rely on this person? No.
Nope. And I just keep wondering what the hell happened in the run up to this trial. Who dropped the ball? Who wasn't honest in how they looked at this case, the evidence in this case, the key witness in this case? Somebody screwed up. There's no doubt about it. You don't look at Relli, you don't talk to Relli and say, this guy's solid, we got a winner here. You just don't. Okay, let's get back to the Diana Hayes question that I disappeared on and brought back. Are you both surprised the state has no rebuttal case? I would say no, I'm not. You?
I don't think they could have had one. And I just tweeted out whether or not whether the state was trying to get a rebuttal case or witness out of turn or something about, I don't know if you call it out of turn, or bring back their ballistics, as they call them, or firearms expert, as we call them, somebody to rebut something that was said by either Lou Levin or by 12E, right? Yeah. And I guess, who knows? It's just that they kind of ended on a whimper in their main case. They ended on a whimper in the cross-examination of Levin, and then there's not even a whimper for a rebuttal.
Yeah, and you got to remember, rebuttal is, it's like a cross-examination or a recross or a redirect. It's finite. You can't open up without a motion to reopen. You can't stray from what has been handled on the defense case. You can't go, oh man, we forgot that thing in our main case in chief. Maybe we can get it in here. No, you're not really allowed to do that. So if you look at that, precise nature of rebuttal, I just didn't know where they might be going.
So I wanted, hypothetically speaking, let's just give a hypothetical. Michael Bryant, hypothetically, you are a DA Lewin. Hypothetically, if you were trying to put on a rebuttal case,
listen to my question.
Yes, listen to this question, and you were trying to get a firearms examiner back in on a rebuttal case. What was the area, hypothetically, that you wanted to address, that you thought should be addressed to rebut some witnesses' testimony from the defense?
Okay, well,
hard one. Okay, I'll scroll while you think.
Yeah, let me think. See if there's steam rising from my head.
Well,
I think
question up.
Yeah, I mean, it would have to do with confirmation of a firearm versus a prop gun having been used, because that's the basic defense is there was no firearm. It was a prop gun that could not fire projectiles. So if there was some way I could bring that issue back to life to help the jury feel better about finding that there was, in fact, a firearm, that's the only thing I can think of, which is why I don't think I would bring anybody back on. To reinforce the vagueness of my primary case in chief. I don't know. If you got something, let me know. I can't think of anything.
Yeah, if you have anything in the chat, think about it. Yeah. In the meantime, Oasis Cat said, what happened to the chain of custody, or rather lack thereof, in some recent trials we've seen streamed? Good question, actually. Chain of custody. You want to explain what it is, Michael?
Sometimes, well, obviously, any evidence needs to have a chain of custody so that it is pristine, that it hasn't been tampered with or subject to being tampered with or exposed to elements, if it's that kind of evidence, or people. And so you have to really have that handoff. Who collected it? Situation surrounding the collection. Who was it handed to? What did they do with it? Where has it been from that moment to the time you're seeing it here, Mr. and Mrs. Jury Member, at trial? Sometimes there is a stipulation regarding chain of custody, which will speed things up in a case. Sometimes it's highly contested,
right.
and it's the crux of a case, because maybe somebody finds shell casings, after the fact, and nobody's quite sure where they went from the scene, if in fact found there, to the day they show up in court.
Yeah, and there's no DNA from the defendant on it, or else you would have heard it. So True Hebrew says, I really believe it was a prop gun, considering all California gun laws. Do you believe it? Interesting, because California gun laws are very strict. Somebody had mentioned that. I think it was on examination of Lou Levin, or cross-examination, about how they were very strict. And, that's why he got security afterwards. Because you have to do all this qualification, and he had some licenses or something, apparently, although the prosecution objected to that.
I remember Levin testifying that the question was, how come you had that Glock 43 cartridge or magazine, but you didn't have any gun for it? He talked about how he bought it by mistake, never took it back, it's too expensive. But he also talked about how he didn't want to carry these things in his car. Right. When he's driving around because of the gun laws in California. He just went pulled over, and he happens to have some of the accoutrement of guns, and in California that can be a problem.
Yeah, so I think that you're right. He would then continue. Why do you think the prosecutors gave up on their last witness day? Something must have happened. Do you think? Have you heard anything? Well, I'll keep trying to find out. But my view is that that's what they wanted. They wanted somebody, because the only thing that they could have rebutted from Levin really would have been something related to guns that they thought they should rebut. And I guess, and I don't know if the stipulation took care of it at all, that's what they're looking for. And the defense has no problem saying, because apparently there's a weapons trainer or something on the jury, I read, somebody who trains people, that, and you even said it, that there are shells that are ejected from a prop gun, right?
Yeah, it's only a prop gun in that it can't fire the projectile, but
right.
Otherwise it's because it's a prop. It's because
that's what makes it sound, right? It makes a sound. So we're going to keep looking, but the fact that the prosecution gave gave up on it. And maybe the judge, maybe there was an issue about whether he was going to get there at 1:30, whether or not it would be a new report that the defense hadn't seen, and it was going to delay things. I think that the defense wanting to get to this jury and making the point about, not if we don't get there, we're going to next week, Your Honor, blah, blah, blah. And I think the judge took that seriously, looking at those jurors, and maybe they're tired, maybe he knows they're tired. So
that happened fast. I had a pretty eyes up there.
I'm sorry, the prosecution's embarrassed. This is the third. This is the C part of the question from True Hebrew. Do you think the prosecution is embarrassed? They should be.
They should be.
You think Lewin's embarrassed?
No. Well, I know Lewin doesn't get embarrassed. No, it's not in his DNA. Paulie P, he might be a little embarrassed. Yeah.
Yeah, and then if you Google it, and we'll report a lot of drama going on in that prosecutor's office, including Lewin getting notice that he's being sued, as I think I mentioned the other night, by 2 prosecutors for retaliating against them.
Yeah,
because they were with the old regime, wanting to let the Menendez brothers. If I find the article, I'll tweet it out ago. But
basically, he took sides against Gascon, and in theory, he's been penalized as a result. And if that happens,
and then
the lawsuit?
No, he took sides against Gascon. He said he was penalized. He sued Gascon. Okay. And then when Hochman got in, he was aligned with Hochman, and then he was promoted again or moved to like where he wanted to be. And then he supposedly retaliated against people who were siding with Gascon on the Menendez brothers. And they sued him because they said he called them a Nazi, basically, and a name that I don't remember who was a Nazi, and some other stuff. It's in the thing. And so that's going on right now. So the question I have, depending on what this verdict is when did John Lewin get assigned, and why did he get assigned, and who in that office looked at that tape, listened to that tape, and was an independent consultant, ethics consultant, to say we should go forward with Relli, given the issue of the possible extortion that goes on. So
so it's still unclear where Lewin's going to end up. He may be on the less prestigious. He was on the big crimes department.
Right.
Durst made him a star. He stayed at that elevation. This case, even though it may have been given to him as a bone, we've talked about how after his demotion, because Gascon was mad at him, Hochman may have thrown him this case as a bone. I'm not sure he did him any favors. It's definitely high profile, but it's going to be interesting to see where Lewin shows up. Is this his last, major crime type case? Is he going to whimper off into retirement with some misdemeanor cases and things?
No, the judge did come down on him a number of times in front of the jury at the end, and it was, you would expect it was. If you're an attorney, it's embarrassing when the judge comes down at you in front of the jury. It really, really is. And I think he did. And just when Lewin was going back at him, what do you mean? Why? The judge would say, I ruled. This is my ruling. And he'd go at him. And, and remember when he's doing that, his back, the way that courtroom is and the jury's over that side, his back is to the jury when he's doing that. The judge.
It's just an odd mindset that doesn't acknowledge this is the judge that just told me to be quiet, or I've ruled. He just doesn't stop. And it's not even in a polite type disagreement tone. It's in your face arguing with the judge about a ruling that he has just made.
Right.
I don't know what is going on in your brain as an attorney, an officer of the court who's been there almost 30 years. Is it just this arrogance that is like, hey, I've been here. I've done this decades. I had the Durst case.
Yeah, well, he was in cold cases. We talked about he was in cold cases in major crime, but cold cases. So you didn't really. That was the first time we really saw him. I mean, I was there.
No doubt.
With Spector,
Yeah.
he wasn't. His name wasn't anywhere near I saw on Spector. I mean, he certainly wasn't trying the case. He wasn't in the courtroom. He wasn't one of the prosecutors. That was pretty high profile, by the way. And twice it was tried. So the first time we saw him after all these years of toiling was in Spector. So you have to wonder, I mean, he definitely is committed and definitely is dogged. There's no doubt about that. But the question is sometimes you got to pull back on your doggedness.
I still remember when he was doing Durst and they were playing, the interviews, especially the one in New Orleans where he ended up being arrested. Lewin is there in the interview, and not just. And I was talking to Bob Bianchi about this, former head prosecutor, and he wasn't concerned that he was there. And I said, he wasn't just there, Bob. He's the guy asking the questions. The cops are there, but he is asking the questions. I mean, that was our first little insight as to this guy's a control freak. And, once he takes a case that is his case, he doesn't let go.
He doesn't let go of it. And let's face it, this is pretty easy to prosecute.
Yes, yeah, unlikable guy, unlikable crimes.
You had the Jinx. You had the movie The Jinx. I mean, you didn't prosecute it. The movie The Jinx came out and got all the evidence for you. Got the notes, got the letters. Got the confession. I mean, you could have got it. And remember, his opening when it finally happened, because we started and stopped during the COVID, was 3 days. His opening was 3 days. Here's the opening. His wife went missing. He was the last person to see her. He made up a story, right? Here is the letter where he says the body is at the house in his handwriting. And by the way, he confessed. That's it. I sit down. You know?
That's it. And he just ground that guy. That he killed. I think he killed Durst. Ultimately, I think he did. I mean, the guy was in poor health as it was.
Right.
But that was a grueling 3 weeks of examination. Holy cow.
Sheila Duffy asks, can the judge overturn the jury's verdict if he doesn't agree with it, Michael?
Yeah, J&OV is kind of how they describe it in California. The judgment notwithstanding the verdict. And it's same standard as a directed verdict after the fact, though. The court is saying, jury members, appreciate your work, but you got it wrong. There's no way a reasonable juror could have found the lack of, could have found guilt beyond a reasonable doubt. So I'm taking that from you and reversing this. That's even more rare than a directed verdict. But it's a procedural weapon. It happens.
Right. True Hebrew. I hear right there in the trial that was mentioned that the prosecution pieced together the videos and there was an overlay. How is that even valid?
Yeah, you remember they had 3 different videos, and they used it with their toolmark expert guy, and they used it with the cop Torres, I believe, as well. Remember that?
Yeah, I do.
And so they kind of merged them to give a more complete picture. And I think that might have been subject to some pretrial maneuvering to make sure it was proper. But I don't think there's a problem with it in theory, as long as it doesn't mislead the jury, as long as they can see the same three images matched up appropriately. Remember, anything that helps the jury is more likely to be allowed. Anything that misleads the jury is more likely not to be allowed. So, I'd have to look at that exhibit again, that evidence again, to see if there's any sort of misleading nature to it. Most of the video is kind of a mess. So,
it's a mess. I think they were trying to get the sound coordinated with the other video.
Right, because the one video had more visuals without sound, and then the one had more sound without the visuals. So they wanted to marry those.
Now, here, one of our mods, here comes Drama, said she's worried because this is not a jury of a few. And that's what the defense claimed in the beginning, is that, you're in inner city LA, right? You're at the downtown courthouse, and there's not one person of color on the jury. But remember, the victim here, usually when you have that issue of discrimination in a jury, it's because your victim is white and your defendant is of color or black. And we've seen that there's all these studies in death penalty cases that somebody who is of color who's charged with killing somebody who may be white, there's a disparity in how a jury imposes the death penalty if they're minority or whatever. Here, I agree with you, but they're in downtown LA, and at least the everyone was of the same. I don't know if they're all the same. I mean, I don't know. I mean, they weren't white. They weren't us. We're white people.
Okay, well, let me throw this out there, because I think it's so easy to just say, defendant's black, where are the black people on the jury? It's being a peer is not limited to race, right?
I'd be a great peer for him.
I think I would too. Yeah. So I think it's too easy to just say he's black. There are no blacks. That's unfair. Peers go beyond race, beyond religion, beyond sex.
But
all of those things.
Necessarily in a jury.
I think
the way we talk about.
Otherwise, that would make everybody upset if there were not 12 black people in the jury, because they're the only ones who could be his peers.
No, but you had not even one. They didn't even get to question and voir dire one person.
I know. Well, we looked at percentages.
That's unheard of in downtown LA.
We know that 9% African Americans in the pool. That was the community pool, because you can't go down to Figueroa Street in LA and say that's the jury pool. There they are. It's a much broader pool, much broader, and it's 9% African American in that broader pool. The people came in, only 6% were African American. None of them got into the box for whatever reason. Maybe their number
This box to be
too high.
questioned, not even to be like dismissed.
No, and if they had taken longer for the jury selection process, maybe some would have made it in. But both sides.
Both sides agreed.
Yep.
Both sides agreed to the jury and all. So, but I think it does raise an issue about the fact that happened. True Hebrew, thank you for following us in this case, by the way, and being so involved. I think Lou Levin's testimony. I'm saying Lou Levin because yesterday we have Lewin and Levin. Levin's testimony was validated. The prop gun. What do you think? I think so too. And I'm going to turn this over to Michael, because one of the issues he had last week was the fact that they weren't bringing the prop gun in. There was no explanation as to what happened to it. And Michael here, that Michael there with his hat on. What does your hat say, by the way?
Oh, this is a Coke, Diet Coke.
Okay.
Diet Coke.
Diet Coke.
Got this at the.
Maybe we're looking for sponsors. I don't know.
I'm hoping. I was at the Coca-Cola Museum in Atlanta when the Rams went there 5 years ago and lost horribly in the Super Bowl. So that's So that's what this is.
Yeah.
What was your question there?
I think Lou's testimony validated the prop gun. What do you think?
Oh, yeah. I think he answered most of the questions I had, which was explaining why we don't have that. Now there may be a more nefarious reason. I don't know, but his description, his testimony was believable and reasonable, made perfect sense. Lewin trying to get him to become some sort of special ops investigator to ask where'd the gun go. He gave it to a guy who was involved with the props for various videos, obviously a collective of let's just say lesser production companies, and they're sharing props. They have them collected somewhere. I gave it to that guy. He doesn't know where it went after that. That was the end of the witness's involvement. And Lewin was trying to.
Lewin's like, "What did you try?
What do you mean? That's it? That's all you did?
What about you, the prosecutor?"
Yeah, maybe you could have followed up on that.
Yeah,
that's where Relli or certainly Lil Woody would have asked Lewin a question. He would have said, "Why didn't you check?"
Little Woody was one of, I think, the favorite witness I've ever seen in a long time on trial. I've never seen anything like again. Here comes drama. So the two people who are Asian on the jury, and that's normal in downtown LA. We had that inspector too. We had a conglomerate of jurors. We had black, white, Asian. I don't want to say green alien, but you know what I'm saying. We had a cross section of the community, and there are a lot of people who live in downtown LA who can form that jury pool. Right now, how do you think the 7 women feel about Lewin yelling at every witness?
I think they're glad they're not married to him.
Well, let me take that with me as a female. I'm appalled at him yelling at them. I'm appalled. It was embarrassing. It was terrible. I wanted every time that the judge would move to strike. I was almost ready to get up. If I were a juror, I was like, "Wait a second, Your Honor, I want to hear what he has to say," because it happens so much.
Yeah, and I don't think that's limited to the females either. I'll be reverse sexist here. I think the guys would also be pissed off by that.
Yeah, I know. Okay, Lisa has a question. We're not going to go there, Lisa. I'll tell you why. We had 2 exclusive reports that we broke. Actually, more than one. We were the ones who reported that the defense had the $30 million. They were going to go with a shakedown. We reported that. No media outlet picked us up because we were small, right? Then we had another exclusive report about what the judge felt that the prosecution should go forward and ask him to consider based on ethics, issues of ethics. And again, the next day, based on Relli's testimony. There was somebody tried to gutter snipe us, and I guess you could figure out who. But so we're not going to get into the weeds with that. I don't know. We have different viewpoints. We don't have any deals with anybody. We don't have any sponsorships. We don't have anything. We are telling you as we see it. And we did this in law and crime too. And people were always amazed at law and crime when I'd said, "Oh, I think that person's guilty or not," because I'm a defense attorney. I tell you like I see it. If I think that they're guilty, I'll tell you. I'll tell you. I just don't think the prosecution has proven their case.
Yeah,
beyond a
and that's very different than is somebody guilty or innocent. It's a very different question. Has the case been proven? And in my opinion, no. Does that mean the jury might not find him, could find him guilty of something? Sure, of course, it's a jury. I just don't think, in my opinion, in my professional opinion, the prosecution has done their job.
Yeah, yeah. So I mean, could different people have different views about this? Sure. Could this jury come back and convict? Sure. Could this jury come back and split their verdict? Sure. Could this jury come back and be hung? Sure. We don't know. All we can give you is what we're feeling, and all you can give us is what you're feeling. And you're like mini jurors, right? You're like mini jurors. So if somebody has a problem with that, fine.
Yeah, fine. There's room for all opinions.
Yeah.
Don't have to get nasty about it.
Yeah, it is the way it is. If you want to try to discredit us because we had 3 pretty much exclusive scoops here, but LA is a big town. This case is televised around the United States. I've actually tried cases. I tried that inspector in that courthouse, right? We know a lot of people from that area. Michael is from California. It shouldn't surprise anybody that we can work sources. There's people in the courtroom coming in and out. There's people in the judge's chambers going in. There's people all over having nothing to do with the attorneys. Nothing. So.
Yeah, enough said. So, anything else we haven't gotten to here?
Yeah, and if you have a specific question, and I know Missy's monitoring. Missy just is monitoring. She's also has to deal. She's been on this stream, which she's going to stay on, I guess. Missy, are you going to stay on and run stuff as we go?
She keeps trying to get her looped in for another. The court's taking the rest of the day off. Missy doesn't get to do that. All right.
Yeah, and Missy points out that we are officers of the court because we're lawyers. We have licenses, so we have high standards. So when we feel we have enough information to report, we will. Now, could we report and things change? Like this morning, we made a report about whether or not the DD person, Dunkin' Donuts person, was going to be called. But apparently things changed because it was more important to get to the jury. And I would probably make that same change. Could Mr. Lewin have had a witness that he wanted to call and for some reason couldn't get it in, or there would be a time delay, or the judge imposed a time delay? Yeah. And maybe as a result, you have a stipulation. Again, trials are living, breathing things, and every time you have to make a decision, and you make a decision for what you think is most important. And if I'm the defense here, I think most important is getting this case to the jury right now, because I think the jury is probably like we are done.
Yes. So, hey, I saw your phone case and your little what do they call that thing on the back? What's that called?
Well, this is the things that you order.
Pop it, or it's got a name of some sort.
Yeah.
Anyway, I noticed it happens to have
a pop socket.
Pop socket.
I actually ordered this special to have Justice Serve TV with my little pop socket that I can hold, especially if we're interviewing anybody. Now, we've been so busy. We've been trying to get our merch store going. And also, I'm going to remind you all that we are going to be doing, I know I promised you February, but it may be March, the finding of who killed Stephanie. I haven't given you the full name, our ghost victim, that we're going to be doing that. And, depending on this verdict, we may try to do an investigative report about how this case got to where this case is, assuming anybody will talk to us.
Yes. So I mentioned that because we're creeping up on 5,000 subscribers here, a couple hundred short. And when we hit that, we should have a little celebratory gathering with the folks and have some merch giveaways. So
yes, we will have merch giveaways, right? Not that you'll be able to get them if we mail them.
Yeah, well, I know Brooklyn has, and there have been a few. Yeah. Sheila is at this point.
We have 2 more questions here, Michael.
The person who hasn't gotten there.
And again, we'll be back at 6 p.m., so it's not that far away. Not 7 tonight, 6, because the court was supposed to end at 3, So we figured 6 was safe. But you may have already discussed this, but do you think with the last stipulation, there's any way the jury can come back with a guilty verdict based on what we think their instructions are?
You know, anytime, this is like a test taking trick. Anytime you speak in absolutes, I always go with the other answer. Is there any way? Yep, there's always a way. There's always a way for a jury to come back with a decision. Is it going to be supported by the evidence? Would it stand up on appeal if it's a conviction? Another question. But yeah, I would never say never in terms of can a jury ever come back with the verdict depending on the instructions or the evidence. Anything could happen.
However, if you were to poll us and we were
Yes,
jury, my vote, and I'd be fighting for a not guilty on the basis that the state has not proven their case beyond a reasonable doubt, because I'm not basing any decision on somebody who said he needed to get a lawyer to get a bag because or else it's extortion. I don't want to be used as a lawyer then, and I certainly wouldn't want to be used if I were a lawyer on the jury to get that. If he wants to do it, fine. You know. So, Kat Not Williams. Hi, Kat. I gave you a shout out earlier in the show about the fact that there could be easily a change on the Dunkin' Donuts for a number of reasons. One is that you're all in California. You all know what you tweeted out, and I read what you tweeted out to me, and that I think it was more important given the wrangling that was going on about having possibly, if they had to wait for the DD person, then John Lewin wanted a rebuttal expert, likely, I believe. Okay, this is not confirmed, so you can't report it as confirmed. Likely, I believe a firearms expert in some way, and that was more important for the defense to go forward, and the judge wanted to go forward too. He's got a jury sitting there. He knows it's Valentine's Day. He knows it's a long weekend. He wants to try to get a verdict to it. I think the judge was on the side of the defense at that point, as opposed to
Kat Not Williams has the prediction that it'll be, before the end of Thursday. So I can't disagree with that. That's what I think will happen, unless there's just some militant person on the jury that has a very strong opinion. Militant is not a bad word.
Yeah, but let's go the other way. If the jury sleeps on it, which usually they do for Friday verdict, right? Friday's Valentine's Day. They have a day off, right? Because if they're on a jury. If they're not on a jury, they're going back to work.
Oh, you think so? They would drag it out. They would come to a decision Thursday, then they'd sleep on it and announce it Friday.
The decision, sleep on it, come and have breakfast, say hello, and then leave. I think that's a possibility.
Are they getting free meals?
I don't know. They did a while ago. They always got free meals. But the judge said that they would be deliberating not in that courtroom. They'd be deliberating upstairs, right? When they get their meals in California, usually they'll close the lock a courtroom where the jury room is assigned to, and the meals get served on, in the courtroom, and then they go back into the jury room. That's normally how they do it on these high-profile cases. So,
especially if the jury room is not all that large.
Yeah, and he wants to keep them away from the media and the press and all that stuff. And he may also have other things to do. Judges, by the way, when juries are deliberating, they do their other cases. Yeah,
they'll be you've probably been in a courtroom for something else, and the judge will be, I'm sorry, we're going to take a recess. I have to go take a verdict in, this other department. So they're not just kicking their feet up. They're juggling many other things.
Yeah. Yeah. So we'll see. Yes, I did let attorneys put on calendar duty. I did ask Michael Bryant if he could get the attorney for the other attorneys who have accused Lewin of retaliation. We'll see. We'll see what happens. We have so much going on. Remember, in April, we're going to have Karen Reed, April 1st. That's unless the full-throated motion to dismiss.
Yes, that's March 4th. That's already, we got that penciled in, March 4th.
March 4th. So we're going to be back at 6:00. Thank you, Kat Not Williams, for giving us that shout out. Thank you for sending your viewers our way. Hopefully, maybe one of these days we can do a joint show together.
That'd be great. Yeah, it'd be fun.
Terrific. And
so what are we covering tonight other than a little bit of this? And we're going to have the latest on Karen Reed with the big decision coming down from the appellate court, right?
Right. And by the way, Kay Schmidt, again, thank you so much. You gifted 5 more Justice Serve TV memberships.
Nice.
That is so nice of you. Really, we really appreciate it. We're trying to do our best for you. I know we're small, but we think we're pretty mighty.
Hey, I think I had a prop here somewhere. And the membership thing reminds me of this because I tend to put my DIY stuff on there just for fun. Anybody tell me what this is?
Am I allowed to say no?
Yeah, you can say. There's no prize involved.
It's pipes for
pipes. Yes, it is pipes.
For a sink or a bathtub? I'm not sure.
Yes, it is very good. It's for the bathtub because I'm obviously redoing that.
Yeah, I can't see the bottom of it.
I'm sure I'll be posting something
There you
very
go. Yeah.
fascinating about the project very soon. I've been bogged down on. I'm putting these faucets in that are on the wall. They're wall mounted.
Right.
So it's a very tricky, what's called the rough-in plumbing. This would be called the rough-in plumbing. This is the valve where you'd have the knob, turn the water on, comes out here. It's the tub. Comes out up top. It's the shower, and it has a diverter to send up or down. If this isn't properly roughed in your walls, then the knobs don't fit right. They either stick out or they won't go on. And this is a water. It's like a sort of a waterfall type faucet, and it's boggling my mind. So I'm working on that.
It's good to know. It's good to know that my streaming partner is not only a lawyer, has not only won an Emmy, but that if I have a problem with my shower and I can't get a plumber in New York City,
I can fix
call
that.
you. It's
I can
so
fix that.
exciting.
Yes. So I don't know if that's a member enticement or not, but I'll probably be posting some of that on the member channel.
If the pipes don't fit, you must quit.
Okay. All right.
All right, Michael Bryant. I'll see you
Okay.
later on. See you all later on. Missy, you're going to run things or not? You let everybody know whether you are.
She is? Okay, then I'm not going to do our normal sign-off thing. I'm going to just
If
say.
she is, we're not going to do it. We're going to get off the stage, and we'll see you back at 6 p.m. Eastern Standard.
All righty. See you then.
Time to start taking notes. Mr. Prislovic, the floor is yours.
Thank you, Your Honor. Good morning, ladies and gentlemen. I wanted to start off by, on behalf of myself, Mr. Lewin, I'm sure on behalf of the defense too, and all the court staff, we all want to thank you so far for the time, attention, and candor that you gave to us during jury selection. We all understand that was a long process, and we appreciate your attention. After going through that long process, I'm sure some of you are thinking, wow, this must be a difficult case, or this must be a really complicated case. And to be fair to you, if I was sitting in your position and I looked out on the number of jurors that we started with, or even the number of attorneys that are up here, I'd probably have the same thought myself. But what the evidence will show in this case, and what will become almost instantly clear, is that this is not a complicated case. The evidence will show that the events in this case were captured on surveillance video. I'm going to start this whole presentation out by playing the video for you. So you will have that frame of reference as we're talking about different features, the people that were involved, the locations that are involved, and what happened. You will already have seen the video. The first video that I'm going to show you was captured on November 6th of 2021 at around 10:10 p.m. just outside of a parking garage entrance, mid-block, so on Argyle, in the middle of Argyle, between Hollywood Boulevard and Selma. The second video that I'm going to show you was captured 7 minutes later, so at 10:17. It was, if we're being generous, 2 blocks, maybe 1 city block away from the first location, down Argyle, around Selma, at a small intersection called Selma and Vista Del Mar. So I'm going to play the first video for you, that outside of the parking lot. Now I'm going to move to the second location, that at Vista Del Mar and Selma, and I'm going to pre-warn you, it's a little small, it's at a distance, so you're going to want to focus your attention at the top left-hand corner. All right, now let's go over the details. As I said,
the people that are involved, the location, and I'll give you an explanation of what you've seen on these two videos. This case takes place in the heart of Hollywood. This is the iconic Hollywood and Vine. The picture you see here is just a demonstrative picture of that intersection, but it's an iconic intersection in Hollywood. That intersection is about 1 block one block west and 1 block north of the crime scene. So for those of you who are familiar with Hollywood and that intersection, it's a pretty big landmark, and that's where I want to focus your attention. Now, the actual shooting in this case takes place on a much smaller street, Selma and Vista Del Mar. But this is the area around where that shooting took place. It is a very densely populated part of Hollywood, and there are some landmarks on there that you might be familiar with, just so that you can familiarize yourself with the location that we're talking about. The Capitol Records building at the top, the W Hotel, and Hollywood Boulevard. The shooting, as you've seen, occurred just outside of a parking lot on that corner of Vista, Del Mar, and Selma. That was a parking lot at the time that was full of cars, and it was ringed by a nightclub on the corner, a sound studio, a hotel, and 3 different apartment buildings right around. As I said, densely populated. This was also Saturday night. Saturday, November 6, 2021 at about 10 p.m. in Hollywood. This is a time that Hollywood is busy. Now that you understand kind of the locations that are involved, I want to start with how this case starts for LAPD.
Hi, I live in the apartment on the corner of Argyle and Selma in Hollywood, and there's just been a shooting.
So at 10:18 p.m., LAPD receives this call, that there's been a shooting at the intersection of Argyle and Selma. The call continues though.
Did you see anything or you just heard it?
Yes. No, we watched it.
Okay, what did you see?
There were 4 men, and they were kind of fighting as they were walking along Argyle, and then they turned left onto Selma. We heard yelling and they started running, and they turned left into the back lot apartments for El Centro Apartments.
Now the 4 men that you see on that screen will be the 4 men that we'll talk about in a minute. They were the 4 that were at that location.
And then someone pulled out, the guy in the black sweatshirt pulled out a gun.
Okay.
And he shot, and I think the guy who shot was in blue.
Now the evidence in this case will be that the man in the black sweatshirt was the defendant, Rakim Mayers. That evidence will be uncontradicted. As you have heard throughout jury selection, Mr. Myers is an entertainer, and he goes by the stage name A$AP Rocky. You will hear other nicknames that he is referred to in the evidence in this case, including Flacco and Luigi. At the time of this crime, Mr. Mayers was 33 years old. He has his own company that I believe is referred to as AWGE, A-W-G-E, that you will hear referred to in the testimony in this case. And as we've talked about, his significant other is Rihanna. The victim in this case is a man by the name of Terrell Ephron. And Mr. Ephron, you will hear, was also a member of the A$AP Collective, and he went by the nickname A AP Relli. Mr. Ephron was also 33 years old at the time of this crime. And what you will hear from Mr. Ephron is that he was friends with Mr. Myers well before this case and well before even Mr. Myers was a famous individual. That essentially, I believe they met in high school and grew up together. He has known Mr. Mayers 18 or 19 years at the time that this shooting happens. And you will also hear that he, too, at the time, was working in the music industry, and he had his own company called Shut Eye Entertainment. Now, I mentioned it already, but to put a finer point on it, the group that both of these men were members of is called ASAP. It doesn't stand for what you probably thought it did when you walked into court. It's an acronym for Always Strive and Prosper. It was formed by high school age kids in Harlem, New York around 2006. They call themselves a collective. You will hear are rappers, producers, music video directors, designers, people that have different artistic pursuits that essentially work together. And there are many members of ASAP. The ones that you will primarily hear in this case are obviously Mr. Mayers, the victim, but also the two friends that were with Mr. Mayers at the time this happened. And they go by ASAP Ills and ASAP 12E. And I will just pre-warn you that 12E gets spelled a bunch of different ways. It's not always consistent. And there will be one last member that you'll hear about briefly, who goes by the stage name ASAP Bari. Sometimes people refer to him as Young Lord. As I said, the four main members of this group that you will hear about are these four men. The victim is on the far right, Mr. Ephron. The defendant is the next person to his left. As I said, ASAP 12E, his given name is Jamel Phillips, and the last is Elijah Ulanger, who goes by ASAP Ills. And these were the four men who were present at the time of both of these incidents. Now I want to take you to that weekend, Saturday night in Hollywood. There was actually at the time a music festival or concert series going on known as Complex Con in Long Beach. And you will hear that Mr. Mayers was to be a performer at that event the day after the shooting, the Sunday, November 7th. Now, although I told you that Mr. Mayers and Mr. Ephron were close at one point, you will hear that throughout their relationship there was tension between the two of them. And that tension was essentially building up to the night of November 6, 2021. You will not hear all the reasons why there was tension between the two of them, but we will get to the point the day before this shooting, November 5th, 2021, when that tension kind of comes to a head. But what happens on that day, Mr. Ephron will tell you, is that he is in a car with that last member of the ASAP group that I talked about, ASAP Bari. The two of them are driving when ASAP Bari receives a phone call from Mr. Mayers. And ASAP Bari takes that call on speakerphone, so Mr. Ephron, who's in the car, can hear both sides of the conversation. He can hear Mr. Mayers, and he can also hear ASAP Bari. And in the course of that call, Mr. Ephron, the victim, heard the defendant saying these rude and aggressive things about him. Mr. Mayers at the time does not know that Mr. Ephron is in the car with the victim. This leads to the next day, November 6, 2021. You'll hear that Mr. Ephron was in Los Angeles working with one of the artists that he managed. He was asleep around 9:00 p.m. when he started receiving a series of urgent messages from not only from Mr. Mayers, but from the two other men that were with him, ASAP Ills and ASAP 12. And you'll hear that he received a number of calls kind of back to back to back from the three of them. Now, he didn't answer those calls because he was sleeping, but when he ultimately woke up, he saw that he had a number of missed calls. He also received text messages from Mr. Mayers that were aggressive, seeking a confrontation with him, asking him where he was. Mr. Mayers is on the left side of this conversation. Where are you at? Let's get to it. Stop ducking my calls. The messages that the victim's receiving are instantly aggressive towards him. So you will hear from Mr. Ephron that he called the defendant. He was groggy because he had just woken up. They had a conversation and they agreed to meet outside of the W Hotel in Hollywood. Mr. Ephron will tell you that as he went to that meeting, he was of the frame of mind that he and Mr. Mayers were going to have a confrontation. That he believed they would argue, and that ultimately this would lead to kind of repairing their relationship. So they would each be able to speak their piece and essentially fight like brothers do, and that it would ultimately bring them closer together. They would repair sort of the issues that they each had with each other. So that's how Mr. Ephron is going into this meeting. Now, let's talk about the location where they meet, this location just outside of the W Hotel. You're going to see this map throughout this case. So I want to take some time to walk through it with you so you understand the various features that are depicted here. On the left side of the screen is Argyle Avenue. On the bottom of the screen is Selma Avenue. And on the right side of the screen is El Centro Avenue. Now you can't see it in this map, but if the map were to continue off the top of the screen, Hollywood Boulevard would be just above that. In the middle of this map, there's a small street called Vista Del Mar that kind of goes north and then forces you to go east. The red arrows that you see here are the path of travel that Mr. Mayers took that evening. So it starts at that mid-block location on Argyle, continues down to Selma, and then up Vista Del Mar, around that corner, all the way to El Centro, and then he made a left turn on El Centro and went above, off the map. The numbers in the red boxes that you see here, 1, 2, 3, and 4, are the 4 different locations where the police were ultimately able to recover surveillance video from. There are 4 different locations. Attached to each one of those locations, you'll see the green triangle and the green, with a green arrow in the middle. And what that represents is very roughly, this is not meant to be, exact, but very roughly the direction that a camera attached to that building was facing. You will also hear that locations 1, 2, and 4 captured video only. But you will hear that the location with the number 3 captured both video and audio. So I told you there's 2 incident locations, 2 altercations that happened. The first happens where the yellow box is right now, right outside of that parking garage. The second happens at that corner of Selma and Vista Del Mar. And that's where the firearm was actually discharged, where the gunshots were fired. So the first location I want to focus on is that where the initial confrontation happens. This location is the entrance and exit of a parking structure. This is that parking structure entrance if you were standing in Argyle and you were facing towards Selma. So Hollywood Boulevard would be to your back. And the entrance is on the left-hand side there. And what you will see in the videos, this parking lot entrance has those hanging indicators on from the roof that tell you how tall the garage is, so that if you are driving a tall car, you don't, of course there's a fly buzzing around me, you don't run your car into the roof of the parking structure. Then I point that out because when you watch the video, you'll actually see that red indicator as a kind of a line through the video, so you know what that is. At the mouth of that parking entrance, there are cameras that are facing the sidewalk. Those are the first view that we saw. And these cameras capture the initial encounter between the victim, Mr. Ephron, who you see there, and the defendant, Mr. Mayers. And you can see that Ills is the first one to intervene to try to separate the two of them. And then at the very bottom of the screen, you see 12E putting his hand to try to also intervene and help separate them. Now I know it goes by quickly, and you're not as familiar with all these people, so I want to kind of break it down a little bit for you and show you what the evidence that you're going to receive throughout this case. The first person that you see in that video is the victim, Mr. Ephron. The second person who you see, who is instantly confrontational with Mr. Ephron, is the defendant, Mr. Mayers. You see on the video that Mr. Mayers is immediately aggressive towards Mr. Ephron. He's pulling at Mr. Ephron's sweatshirt and he's pushing Mr. Ephron backward and pushes him off camera, out of camera view. The third person that you see, as I told you, is Elijah Ulanger, who also goes by ASAP Ills, or he might just be referred to as Ills throughout this. If you look closely, you can actually see his stage name embroidered on the jacket that he's wearing there. And what he attempts to do is to de-escalate the situation, to get between the two men and to physically separate them. And you'll see that all three of them go off screen for a period of time. Mr. Ephron will tell you that during the period of time that they are off screen is when the defendant first produces that semi-automatic pistol from his waistband. He pulls it out of his waistband and he's holding it to Mr. Ephron. Mr. Ephron will tell you that the defendant pointed the gun at his chest and was essentially trying to point the gun around Ills, who was between them. That at the time that he was pointing the gun at Mr. Ephron, he was also threatening Mr. Ephron. I'm going to kill you. Keep in mind, these men have known each other for a long time. And Mr. Ephron will tell you, in his state of mind, he never believed that he was going to be shot. He never believed that the defendant would actually shoot him. He will tell you that had this been a stranger, someone he didn't know as well, he would have been petrified. As you can imagine, anyone pointing a gun at you would upset you. But he knows the defendant. He knows that Mr. Mayers is not going to shoot him. He knows so much so that he'll tell you he looked at the defendant and said, if you brought a gun, you should shoot it. That's how confident he is that he knows the defendant is not going to pull that trigger. Now, the fourth person you can barely see on this video as they come back into frame, I told you, is Jamel Phillips, who goes by 12E or ASAP 12. And you can just see his hand at the very bottom of the screen. When they come back on screen, and specifically when Mr. Mayers comes back on screen, you can see the gun in his hand. You will hear that that gun that he's holding is a semi-automatic pistol, or has features that are consistent with a semi-automatic pistol. Right now, as it's paused on the screen, you can see that he's holding that gun behind his back. But you will also see the gun come forward in front of his body before he ultimately tucks it back into his waistband. And you will see from the video that there were bystanders. As I said, this is a busy Saturday night in Hollywood, walking by as this confrontation is taking place. You will hear that right after that encounter that you saw, that Mr. Mayers walked away and was walking down Argyle towards Selma. Mr. Ephron will tell you that as he walked away, he looked over at 12E, Mr. Phillips, and he saw 12E putting a pocket knife away. And Mr. Ephron, and then 12E, Mr. Phillips, walked behind the defendant, Mr. Mayers, and Ills walked behind him as well. So the three men that had come to confront Mr. Ephron walked away down Argyle towards Selma. And Mr. Ephron will tell you that at that moment, his mindset about the initial confrontation changed. I told you that Mr. Ephron will tell you when he first went there, he believed that this was meant to be a confrontation so that they could strengthen their relationship. But having just had a gun pointed at him and seeing another friend putting away a pocket knife, that his mindset changed and he understood these men never came here to try to make peace with him. That it was always meant to be a confrontation. And he decided at that moment that having a gun pointed at him was sort of a bridge too far in their friendship. And he understood he was probably never going to have the same friendship, especially with the defendant, ever again. And you will hear that as the defendant walked away, Mr. Ephron followed behind him and was yelling and screaming at him, even though he knew the defendant had a gun. Because although Mr. Ephron believed this is going to damage our relationship, he still never believed that the defendant would actually shoot at him. It's not as if Mr. Ephron will tell you that he had some death wish or that he was not scared of guns. He will not come in and say that. What he will tell you again is that had anyone else done this, he would have been frightened. But he had known the defendant for so long and they were close. So he walks down Argyle towards Selma and follows behind the three other men. When they get to Selma, they all turn left and they walk towards Vista Del Mar. And they end up at that location we talked about, that corner of Selma and Vista Del Mar. And as Mr. Mayers stepped off the curb, he walked into frame of the camera at location number 2 that's pointing towards Selma. Now I want to take you, before I play the video again, I want to take you to that corner so that you can see from that night what it looked like. It's a small street with a parking lot immediately adjacent to it that were full of parked cars. And at 10:17 p.m. when they arrived at that intersection and the defendant stepped off the street corner into view of camera number 2, you will see video from that location. The video that I've played for you already and that I'm going to play for you again is from that location number 2. You will also see, that's the main video that you're watching, but you'll see in the bottom right-hand corner, there's a smaller video on top of it that kind of has a bluish tint to it. And that video is from another location behind building number 2 where the number 3 is. And the video that you're seeing from that location is identified there by the green arrow. But what's important about that video, because the video does not capture the shooting at location number 3. What location number 3 captures is audio. And it captures the sound of the gun being fired twice. This is the location number 2, where the camera, the video that actually captured that shooting was. You can see the cameras at the very top corner of the building, and it's about 3 properties away from the location that we're seeing. So again, the video is captured at a distance. It's a admittedly grainy video. It's not the most clear that you could possibly have, but it captures enough features that you can identify who is who when you watch this video. So I told you the main video that you're watching is from location number 2, and that smaller location number 3 is in the corner. Before I play the video, I want to orient you to what you're seeing. Along the top is Vista Del Mar. The parking lot is just out of view of the camera at the top of the screen. Along the top left-hand corner is Selma, forms that intersection. The red arrow is the defendant, Mr. Mayers. And the green arrow is the victim, Mr. Ephron. Okay. Now what you see as the video plays is the various cameras on location number 2 switching between 3 different cameras that are mounted to that building. What's important about that, towards the end of the video, you'll see as Mr. Mayers is running away from the location, running down Vista Del Mar towards El Centro, he trips a floodlight that's motion activated, and when you watch the video closely, that floodlight is captured by both locations. So location number 2 and location number 3, those cameras each capture that floodlight turning on. And when you watch the videos together, you can see that moment in time when the lights flash on, line up. And that's how you know the sound correlates with the video that you're seeing playing at the same time from a different location. Now, I told you, we all know the video from location number 2 is from a distance. If you zoom in on the area where this incident happened, and we will play a zoomed in version of this video, what you see is a very pixelated image. But what even that captures still are the colors the individuals are wearing, which is how you can distinguish who is who on the video. And you'll see Mr. Ephron on the far left. Ills is just next to him. 12E, who's wearing the red jacket, is just next to Ills. And then the defendant, who's wearing all black, is at the bottom of the screen. Again, I understand if you watch this video one time, you may not pick up these features, but as you watch it repeatedly, you'll be able to tell who is who. And you'll also be able to tell when you watch these videos in sequence, because they walk in front of other cameras that are far more clear, that you can easily identify who is who on this video. So this is the zoomed in version of that incident. This does not have any audio. Now, as we play the zoomed in version, you'll also see that Mr. Ephron is struggling with Ills. And what Mr. Ephron will tell you is that immediately as the defendant turned and pointed the gun at him, he jumped behind Ills, essentially to put Ills between him and the defendant. And you'll see on the video the defendant lunging one way and then the other way around ill, trying to get at the victim who is holding ills in front of him. Now, despite how dangerous this is, having a semi-automatic pistol pointed at you and discharged twice, you will hear that Mr. Ephron was not seriously injured by this shooting. He has these injuries to the middle knuckle of one of his hands. Mr. Ephron will tell you that at the time the shooting was happening, he immediately felt a burning sensation to his hand, which led him to believe that these were graze wounds from one of the bullets that was shot at him. Perhaps they were. Perhaps they were not. Whether or not the victim in this case was actually shot or injured by this will not be something that you have to decide at the end of the case. We ask you to wait until the end of the case when the judge instructs you on the law, what elements are actually required to be proven before you make any decision. And to listen to the charges specifically and not consider charges that the defendant is not charged with. In this case, he's not charged with attempted murder, for instance. Now, before I move on, I want to focus in on the last location that I haven't talked about much, location number 4. That location is a loading dock for this building on El Centro. It's right at the corner of El Centro and Vista Del Mar. And what you'll see in the video from that location is the defendant, Mr. Mayers, and his companion, 12E, walking from Vista Del Mar up El Centro towards Hollywood Boulevard. The arrows indicate their path of travel. They're going to come from that corner and then walk up El Centro. The camera itself is in that red circle. And you'll see this video is far more clear. And you'll see features of their clothing that you can match up to the clothing from the other videos that we've already watched. For instance, I mean, you can see just from Mr. Mayer's facial features that he's the one wearing all black. You can see from his facial features compared to the video from the parking structure. And then, as I said, the various features of his clothing, the rhinestones on the hood of his sweatshirt in both videos, and the design, the rhinestone design on the chest of his sweatshirt at both videos. And taking all the videos in their totality and comparing them is how you'll be able to decide on the video who is who. Now, I played the 911 call for you that LAPD received at 10:18, which triggered their response. And you'll see and hear that at 10:27, LAPD officers responded to the 911 call, and as is their duty, they responded quickly to this call to try to of shots fired in the middle of Hollywood. You will hear from at least one of the officers who responded to that location, and the officer will tell you that as part of their uniform, they wear cameras that are mounted to their chest, and you will actually get to watch camera that captures the police response. After this shooting, the evidence will be that all 4 of these men, the defendant, 12E, Ills, and the victim, all left the scene. You'll hear that there were at least 2 people who called 911 to report this crime, who were just people living in the surrounding area, not actually involved in the altercation itself. You'll hear that the 911 callers were reporting different information. So the first call would be that the gunshots were fired at Argyle and Selma. The second call will be that the gunshots were fired in the area closer to Vista Del Mar and El Centro. You will hear from the officer that as they responded, they come to the scene looking for a victim. That's their primary focus. Trying to find anyone who needs immediate life-saving attention. Their second focus will be looking for the potential suspects if they can find them. And you'll hear from the officer that as he's receiving information that's taking him to different locations, he's actually going between the different locations and trying to piece together what happened. But what will be important from his testimony is that he is not given a precise location to exactly where this shooting happened. And with the limited information that he has, he and his partners are doing the best job that they can to find any victims, any suspects, or any evidence of a shooting. You'll hear the officer talk to different people who were just out and about, try to figure out what was going on, that neither of the 911 callers would meet with them, and that they searched not only the surrounding streets, but they primarily focused on the parking lot that was right at that corner of Vista Del Mar and Selma, because the second 911 caller had told him, or had relayed that it was possible that the shooting was happening into a car. The officer will tell you that they searched the area and they did not find any evidence of a shooting. They didn't find a victim with injuries, they didn't find any of the suspects, and they didn't find any discharged cartridge cases, which are what come out of a gun after you discharge it in the surrounding area. But again, they don't know exactly where to look with the limited information that they're given. You will also hear from Mr. Ephron that approximately an hour, and he's not precise on the exact time, but approximately an hour after the shooting, he himself returned to the location. Now at this time, the police have already responded and left. Mr. Ephron will tell you that he and his girlfriend went there specifically to look for evidence that this had happened, evidence of this shooting. And Mr. Ephron will tell you, because he knew exactly where the shooting happened, that he was able to locate 2 fired cartridge cases. And this is actually a photograph that Mr. Ephron himself took of one of the fired cartridge cases that he found. Mr. Ephron, you'll hear, went to the police 2 days later, walked into the Hollywood police station to report this crime happening. He brought the 2 fired cartridge cases with him, and he gave them to the police. You will hear that the 2 cartridge cases that he brought in were 9mm Luger caliber cartridge cases. However, you will also hear from Mr. Ephron that immediately after the shooting, about an hour and a half later, he started text messaging the defendant. And he text messaged the defendant, "You try killing me." That was the first message he sent to him. And you'll hear that Mr. Mayers' response was to deny that anything happened. The defendant, in abbreviation, says, "What the fuck is you talking about? Why are you telling people I shot at you?" Denying that any shooting has even happened. Mr. Ephron confronts him again. "You set me up to try to take me from my daughter." And the defendant responds, "I tried to do what? I know you hate me, I hate you too." The defendant responds again, "Stop making shit up." Again, denying any confrontation took place. Certainly any shooting. We have already told you in jury selection, and you will hear evidence, that after this shooting, Mr. Ephron sought money from Mr. Mayers. In fact, right, hours after the shootings, this is the next day, November 7th, in the early morning hours, 3:40 a.m., you'll hear that Mr. Ephron sent a message to one of his friends saying that he wants money. And identifying the reason why he wants that money is because Mr. Mayers shot at him. You will also hear that based upon these two incidents, the parking lot and the shooting on the corner, that Mr. Ephron filed a civil lawsuit against Mr. Mayers. At the end of this case, you will not be asked to award Mr. Ephron any money. So that consideration will not be a part of your what you're asked to determine. Moving forward in time, you'll hear from LAPD detectives that Mr. Mayers' home was searched on April 20th of 2022, and that during that search, LAPD detective recovered a magazine for a semi-automatic pistol that was 9mm caliber, and that it was loaded with 6 unfired 9mm Luger rounds of live ammunition. You will hear that these items were found in Mr. Mayers' bedroom closet. You will also hear that there was no handgun that was 9mm in Mr. Mayers' home that was for that magazine. So you have a 9mm magazine, but no handgun to go with it. The last point I want to leave you with before I conclude is that we expect, in this case, that the defense will call 12B, Mr. Phillips, to testify. At the time of the shooting, again, he's friends with all these participants. He's 32 years old. And it is expected that he will testify that the defendant was in fact the person on the video who fired the 2 gunshots that we hear. So it will essentially be uncontested that Mr. Mayers was the person who fired the gun at that street corner, and that he will tell you the gun that the defendant fired was a starter pistol. That, ladies and gentlemen, is what the evidence in this case will show at the end of this case. As I've said, we expect that the defense will attempt to present an alternative explanation for what happened that night. But we ask you to do one thing, which is, as you evaluate the evidence from both sides in this case, to not leave your common sense at the door, and wait until the end of the case, when you have all the evidence, to make your decision, listen to the court's instructions on the law, and return the only just verdict there is. Thank you.
All right, folks, we'll take the break now.
We were going to get back through all the reports and make sure that he had everything he did.
All right, Mr. Slomak is finished, and Mr. Tacopina, the floor is yours.
Thank you, Your Honor. Ladies and gentlemen, this case is about one man's jealousy, lies, and greed. And that man is not Rakim. That man's Terrell Ephron, or you've heard the name Relli. He is the source of all the evidence in this case, all of it. That the prosecution is going to rely on, he's the source of all the evidence. The 2 assaults you're going to hear about in this case were both committed by this Relli, both. All the evidence comes through his mouth, every single piece of evidence. For you to decide, these charges comes through his mouth. This case rises or falls on his credibility. The videos you saw, without his testimony, proves absolutely nothing. You need to believe his testimony and his version of events from the video for these charges to be proven. The last thing the district attorney said on his opening statement to you was, don't leave your common sense at the door or use your common sense, something like that. Please don't leave your common sense at the door. I implore you to use your common sense in this case. Look, I will address the credibility of Relli in great detail later, what the evidence will show. But first, let me begin explaining the purpose of an opening statement, what we do here. Opening statements are really lawyers giving you a preview of how we believe the evidence is going to show you, come in. How we'll unfold in this case. But it's more than that, actually. It's a promise to you. It's a promise from us to you. It's a promise that what we say is going to be proven is actually proven. And it's not like one of those politician promises. You know the politician promises, right? If you vote for me, I'll lower taxes, I'll make it safe, unemployment will go down, all those great things that politicians promise, and then based on those promises, you vote. And then you hope they fulfill those promises. Not here. Here, both sides make promises to you right now. You get to see if we fulfill those promises, and then you vote. That's the difference. Ladies and gentlemen, you represent the state of California, the people of the state of California. It's an awesome burden. And there's no greater service a citizen of this country can do than serve in the military or do what you're being asked to do right now. Stand in judgment of another person in a matter of such great importance. It's an incredible burden to bear. But that's why the 16 of you were chosen. There were 106 people here. You made the cut because you all, and even the alternates, assured us that you could carry out that burden fairly, impartially, without a bias, without a closed mind. Listen to the evidence carefully before rendering your decision, you promised. And to base your decision only on the evidence. Not some preconceived notions stemming from the nature of this case or what you may have read or heard.
This is entirely argument. Overruled.
But just on facts. And to abide by the basic tenets of our Constitution, proof beyond a reasonable doubt and a presumption of innocence. And they're not mere technicalities, instead they're the backbone of this country. A person is presumed innocent, the judge Ray told you. And it means he is in fact innocent until and unless the prosecution proves otherwise beyond a reasonable doubt. A reasonable doubt, the judge will give you the law later at the end of the case. But it's a doubt that will cause you to hesitate in a matter of importance in your own life. I submit to you the decision you make in this case, at the end, will be the most important decision in the life of Rakim Mayers and his family. And I'm confident that if you apply the standard and hold the prosecution to the burden of proving each and every element of both counts, beyond that doubt, the reasonable doubt, this will work out. And that's why the 16 was one as jurors. Look, this is serious business, and I just want to tell you one last thing before we dive in. I just think some jurors, some people when they become jurors forget. No one here is going to, both sides are not going to ask you to do anything you don't do in your everyday life. No one's going to ask you to do anything when you're assessing credibility, when you make determinations of credibility. Nothing you don't do in your everyday life. Whether someone's telling the truth, whether they're lying, whether they're mistaken. Just bring your everyday life experiences, and you'll be the best jurors possible. There is no magic formula, there is no elixir. And as you now know, there's no jury school. Use your God-given common sense in looking at this evidence. I know that will package you this case. Ladies and gentlemen of the jury, my name is Joe Tacopina. I, along with Sarah Kaplan and Chad Siegel, have the absolute honor and privilege to represent Rakim Mayers, known globally as A AP Relli. The evidence will show you that Rocky was a self-made man, risen from the most humble beginnings to extraordinary successes through work, dedication, and artistic
Your Honor,
brilliance.
this is argument is also irrelevant.
Overruled. What is said in opening statement is not evidence. What is evidence is what can be proven. Sometimes things are said in opening statement that cannot be proven and are not proven. Sometimes they are. That's what this case will be about.
Remember my promises. I'll remember theirs. When we talk in a few weeks on closing statements. I remember the DA put up a slide in the opening. It's from Harlem, a picture of him and Rihanna. Talked about when he was a teenager. I want to do the same thing. You'll hear he was born in Harlem, like they said. He was raised in poverty.
Your Honor.
You'll hear that
Same, Your Honor, the same objection.
Stop. Overruled.
You'll hear about his upbringing, his mother and his siblings, and how he overcame with hard work, with dedication, and with talent. Rocky is not only a...
I do want you to stick to what you, the evidence will show.
Yes, sir. I do believe the evidence will show that, but I'm going to get deeper into these facts. But what the evidence will also show is he's not only a celebrated artist and a fashion icon, he's a man who raised a beautiful family. That's the district attorney put up the picture. His significant other.
Your Honor.
You got to get to the facts of the case.
You're going to hear the stark contrast in two individuals. Rocky on one side, Terrell Ephron on the other side, known as Relli. He represents a very different narrative. The evidence will show you that this Relli presents himself to the world as a wealthy, successful man. Source light that he's a recording artist, businessman. He flaunts a very lavish lifestyle on social media. He poses with luxury goods.
Your Honor, the same objection. None of this is evidence.
Evidence will show you this. None of this is evidence yet. There's no evidence on both sides. Posting pictures of himself with large sums of cash and whatnot. It's fraud. He is all about a money grab. The truth is far different. And you're going to see this extravagant lifestyle that Relli flaunts is nothing more than a fraud, built on not on success and hard work, but upon criminal activity. Ladies and gentlemen, this case is all about money. I've said it once, twice, I'll say it a few more times. The evidence will show you it's nothing more than a money grab, nothing more. A clear attempt at extortion by Relli so he could keep funding this extravagant lifestyle of his that he presents to the world. You're going to see the only reason we're in this courtroom is because Rocky would not agree to be a victim of another one of his crimes. That's why we're here. Because Rocky said, here's some money. We're not here. He doesn't go to the police. And even after he went to the police, if Rocky gave him money, we're not here. It's not about justice, it's about money for him. Period, end of story. And I will show you that. The evidence will make clear that Relli is trying to leverage a fabricated story to extract money from Rocky, using lies to support these claims. The evidence will show you that Relli is a blatant perjurer, someone who takes an oath, and despite that oath lies. The evidence will show you, and you will see him commit perjury right before you in this court. And you'll see how important that is to this case. Because the evidence will show that despite all the evidence they claim to have, all of it, and I mean all of it, will rise and fall on the word of Relli and his credibility. Period. End of story. You will see, if you can't believe him, the prosecution's case fails. Now let's walk you through the events leading to the incident of November 6th, 2021, which set part of this case. But to do that, we have to start a few years back. From Relli's own testimony, that was the catalyst for this incident. His resentment, from his own testimony, his resentment was the catalyst for this incident, and his animosity towards Rakim. The evidence will show you that Relli met Rakim when he was in high school in Harlem. They were both part of that creative and artistic conglomerate called ASAP, which now you know means always strive and prosper. Over the years, Rakim achieved more and more success in the entertainment industry at first. He did maintain a friendship with this Relli, unfortunate for him. He even sought to help Relli through professional collaboration. But that wasn't enough for Relli, clearly. You'll see the kind of person Relli is in this world. You're going to see it. He was jealous and angry, and as Rakim rejected some of the projects he presented him, Relli's resentment grew deeper and darker. So embittered by the success achieved by Rakim, someone he once considered peer, Relli embarked on a dangerous course of action. And in November 2021, Relli's resentment towards him reached the fever pitch. After tragedy had struck another member of this ASAP group, an individual named ASAP Josh had untimely death, had passed away. Evidence will show you that Rakim stepped up, spoke to the parents and the mom, ASAP Josh, and offered to cover the cost for the funeral, bring the body back to New York and pay for the funeral. But Relli, still blinded by resentment, believed otherwise. He thought for some reason Rakim didn't agree to pay, or had agreed to pay, but they didn't actually pay. And he was furious. He went as far as to threaten physical violence against him, because he thought he didn't pay for the funeral or for the expense of flying the body back. He was wrong, because he did pay. But he went as far as to threaten physical violence. And you're going to see that for yourself, ladies and gentlemen. On October 16th, a few weeks before this incident, that we'll hear about, Relli told his friend that Rakim was a piece of shit and declared, "I'm going to beat this nigga up." Now it's funny, they showed you a lot of text messages. I didn't see that one. Did not see that one. That's the catalyst. That's weeks before this incident, when he came in hot on November 6, 2021, on our ground. And if you fast forward only a few weeks, on November 6, 2021, you'll see that. You see that Relli sought to turn those threatening words into dangerous actions. And he did. The evidence will show you that on November 6, 2021, Rakim was scheduled to attend a music festival, they put it up there, called Tacopina, with two other members of the ASAP crew, Elijah Ulanga and Janelle Phillips, now know them as ASAP Ills and ASAP 12. So in order to address Relli's resentment, because he was really mad, and have him accompany Ills and 12 to the festival, Rakim reached out to him multiple times. As a matter of fact, I think you saw a text from one of Relli's friends to Relli saying, "Hey, I think he wants you, Rakim wants you to perform at Complex Con." So Rakim was trying to get him to come. It was sort of a celebration of the ASAP crew. So Rakim, yes, he was urgently messaging him because they were late for this Complex Con. You're going to hear that from multiple witnesses. He was making them late for the show, so there were multiple messages from both 12 and Rakim. Where are you? Where are you? Where are you? However, you're going to learn that although Relli, because Rakim had reached out to Relli to make plans to meet at his hotel, and you're going to learn However, that Relli said he was staying at the Lowe's Hotel, who was in fact staying at the Lowe's Hotel, lied to Rocky and said he was staying at the W Hotel. Why? Because he wanted Rocky to think he was staying at a nicer place, according to him, which is consistent with his pattern of showing off a phony, extravagant lifestyle. But also consistent with his pattern of lying. You'll see Relli committed perjury about that exact reason. And despite Rocky's best intentions, the evidence will show you that Relli was angry when he agreed to meet Rocky that day. And that anger came to a head when he encountered Rocky on the street, outside of a parking lot, on Argyle Avenue, leading to a brief altercation that took place on the street, which you saw a clip of, a very short clip of. You'll learn that Relli claims Rocky instigated, Relli, by the way, is twice the size of him, but we'll get to that. Relli claims that Rocky instigated the altercation, but the evidence will show you it was Relli who was the one looking for a fight. And you'll hear about Relli's day in the hours before meeting Rocky. You'll hear what happened in that day, independent of Rocky in that evening. You'll hear Relli's claim that Rocky pressed a gun to his stomach, to his chest, and his head. But the evidence, the independent evidence, the stuff that you don't need Relli's word for, will show you otherwise. Fortunately, the video evidence from the parking garage captured the incident. And that puts a lie to Relli's fabricated story about that. The video will also show you who the real aggressor was here. It shows you that Relli approached Rocky and reached out first. It was Relli who made the first physical contact. You can see in a second. The DA said that Rocky was the aggressor. There's a video there. It also shows that what followed was a very quick scuffle. Again, you saw it. With Relli making physical contact and pulling Rocky towards him. Not Rocky pushing Relli, who outweighs him by almost 100 pounds. Not Rocky pushing Relli, but Relli pulling Rocky. The DA said, in his opening, he said that Rocky was pushing Relli. You know who else said Relli was pulling Rocky? Relli said that. Relli in a statement. And when he watched the video, said, yes, I was pulling Rocky this way. That's not a good narrative. So they just changed that. But Relli has made statements about this incident. And they're stuck with those. It shows the incident was over in a matter of seconds, this videotape. And despite Relli's exaggerated claims that there was no evidence that a gun was pressed against his stomach, directed at his chest, or pointed at his head. There's none. Because it didn't happen. Instead, the evidence shows that Relli, again, physically much larger than Rocky, was the antagonizer here. Now, all that being said, I do need to pause here for a second. I need to pause here for a second and address the very thing that serves as the basis for Relli's fabricated story. The video that you saw, the first video, shows Rocky holding an object, what appears to be a gun. And Relli seized on that and manufactured his extortion claim. And we'll get to the extortion. Okay. And remember, this is a promise from me. We'll see extortion. And if I'm not good on my promise, you'll hold it against me. I want you to. The evidence will make clear that the object Relli alleged was a firearm was absolutely nothing more than a prop gun. And the DA ended his opening statement saying, 12B will tell you that. He'll testify on behalf of Rocky and tell you that. Not just 12B, multiple witnesses will tell you that. Not just 12B. Multiple witnesses will tell you that that was a prop gun. You'll learn that that was a prop gun, also called a starter gun, a blank gun, but it's a type of fake gun. It's used in prop movies and music videos. It's also used to scare off attackers by looking and sounding like a real gun. without actually firing a live round. The evidence will show you that Rocky, obviously, I think you all know by now, is a high-profile person in public spotlight, and he was a target. The evidence will show, in fact, that he was the victim of prior violence, which caused him to have to carry this. Victim of home invasions, victim of a stalker at that time, in November of 2021, victim of a slashing on his face, which he still carries with him today. This
Your Honor, there's been no coercion.
Rocky was advised by security to carry a prop gun to scare off potential attackers. And by the way, folks, listen to this one. Rocky was licensed to possess firearms and licensed to carry firearms in November of 2021. He was licensed by the state of California. He could have legally had his own firearm. He didn't want to carry a real gun, though. Despite his ability to do so legally, he didn't want to carry a real gun. For fear that he would either injure someone or himself. Again, I want to repeat that. He didn't need to hide a gun, carrying a legal gun. He was licensed to carry a gun in this state. So you're going to learn that in July 2021, a few months before the incident with Relli, Rocky was in a music video with Rihanna that had prop guns in it. The evidence will show you that Rocky took one of them, which he carried as a security measure, as he was advised to do to scare off potential attackers. And that's exactly what he tried to do with Relli on November 6, 2021. Unfortunately, you hear that Relli was not to be deterred, not scared, because Relli knew that that gun wasn't real. There will be evidence to that effect. And all of Rocky's friends knew that Rocky carried the prop gun for safety. All of them. In fact, the evidence will show you that Relli not only told Rocky as much, but he actually called Rocky's bluff and said, shoot me, knowing that he couldn't. With all this laid out, I do want to show you the video and walk you through it with respect to the first encounter. I'm going to play it once, it's quick, and then I want to show you two snippets. Here's the first encounter. That's Relli coming up. Okay, now, there's two things I want to play for you in there. The first thing is, the first person to raise a hand to anyone is Relli. You're going to see when he comes up, initially, that's him, you all agree, in those black pants coming up. First person in the video, you'll see he goes with his left hand. He raises his hand first. Play that one snippet, please. Boom. Do it again. Boom. He comes up with that left hand before Rocky raises his right hand. And how do you know that? Play the next clip, please. He has his hand around Rocky's neck or shoulder, and Rocky's right hand then finally comes up. Boom. This guy has his hands around Rocky's neck or shoulder before Rocky's right hand comes up. Boom. And then you heard and you saw in the video, they going backwards. Relli, again, who's mustering, you can see that from there, said to the police, yeah, I pulled him back. I pulled him back. They told you, well, Rocky pushed him back. That's not what Relli said. Defies sort of the laws of physics. He outweighs him by almost 100 pounds. Relli pulled him back. And by the way, all the gun pointing to the head, chest, pressed against the stomach would have had to have happened within seconds of that video with that kid Ills in between them. Seconds. You saw none of that on the video. And the second encounter, after that brief altercation by the parking garage, Relli was angry and out of control still. And he wouldn't stop. The evidence will show you that those three guys, Rocky, Ills, and Twelby, walked away. They walked away. There was a map put up here. I don't have one of those, but it was nice. It was a map showing where the first thing happened, and then there's a block, and then a walk around the block where the second thing happened. That guy followed them around two corners, pursuing them. He hadn't had enough, apparently. They were walking away from him, trying to get away from him. He pursued them around two corners. And the evidence will show you that those guys, Rocky, Ills, and Twelby, tried to get away from him. They tried. You'll hear that, although Relli claimed that Rocky had a real gun, now, Relli not only continued to follow the guy with a real gun, but he followed and yelled at them and berated them and told the Ills, "You're a crackhead," and told Twelby, "You live in the projects, you're not successful like me," and told Rocky, "You're a bitch." So the guy who supposedly pulled a real gun on him, and now apparently someone else has a knife too, and they're running away from him, he's chasing them, antagonizing them, bragging about his own successes. You'll listen to Relli's story about that, ladies and gentlemen. You get to assess the credibility. Because it will continue to unravel. The story will continue to unravel. Even the police questioned him. "Why would you continue to follow Rocky after he supposedly pulled a real gun out on you?" said the police to Relli. And you'll hear Relli's answer to the police. "I don't know." That was the answer. "I don't know." I promise you that answer is going to change in this courtroom. That's what he said initially when asked. And of course he didn't know. He had to say, "I didn't know why I followed him." Because he couldn't tell the police the truth that he knew Rocky's gun was a prop gun. Because that wouldn't work for his narrative. One that couldn't actually shoot him. And because he was aware of that fact, Relli continued his aggression. You'll hear that Relli was so angry that he was ready to hit Twelby, according to Relli. You'll hear that he was so angry that he hated Ills, according to Relli. You'll learn that when Relli finally caught up with him around two corners, on the corner of Selma and Vista Del Mar, his anger and hatred came to a boiling point, and he attacked this kid Ills. Attacked him. And make no mistake about this, the evidence will show you, Relli was the aggressor there as well. And Rocky, again, significantly smaller than Plea, fired that prop gun, that starter gun, which makes sounds just like a real gun. That's the purpose of it. He fired it twice, hoping the sound would be enough to scare off Relli and protect Ills. Wrong. Relli didn't stop. He didn't stop because he knew it was a prop gun, but he didn't stop. And the evidence will show you that after Rocky fired those two warning shots with that prop gun, car alarms went off. Because there was that big parking lot right there where they were. Car alarms went off. I'm sorry that you guys are here. It's hard to look everywhere. So Twelby, being sort of sound mind, told Rocky, "Hey, listen, man, get out of here. The car alarms are going off now. People are going to start coming." Rocky obviously is a public figure, and now people are going to have their attention drawn to this. Get out of here. Rocky listened. He persuaded Rocky to leave the scene. 12E said, I'll check on Ills, because Ills was having a rough go of it. So Ills is smaller than Rocky. And Relli was pummeling. You're gonna hear about how Ills' face looked after this encounter. It was a hot mess. So you'll hear a different story from Relli. He claims, like I just heard, he claims he grabbed him, Ills, as a human shield. A human shield. Funny, Ills didn't get shot. But he was a human shield. Evidence will show you that's just another lie. It's another lie. The evidence will show you that. You'll see that Relli knew the proctor couldn't hurt him, first of all. Second, you're going to see that Relli wasn't hiding behind Ills or under Ills. In fact, in the video, you look carefully and we'll show you, you'll see that Relli's on top of Ills as they're on the floor, on top of him, punching. And even after Rocky left the scene, that's simple. Even after Rocky left the scene and ran, the evidence will show you that Relli continued to attack Ills. A witness will walk you through that. That sort of is a problem for them. I mean, this guy was claimed he was shot at one point, and he is still attacking the guy that he started to attack before there was any warning shots fired. He's still attacking, not to be deterred by any star pistol or real bullets from him. The DA played you a video here that had that sound. There was a little box in the bottom that had sound. There were pop pop. That video was called the sequence surveillance video that Michel played on the roll. Funny part about that video is that they cut out that last part of the video. We'll play the full part. But the part where Ills goes back and attacks, Relli goes back and attacks Ills. They cut that part of that video out. It's not on that sequence surveillance video. They cut out those last 3-4 seconds. That's a problem. Now, this altercation, like the first one around the corner, was also captured on video, but as you saw, that thing is not clear. And I saw some pictures up here earlier. It looked like aliens or something. But it's not clear, but you can make some things out. But even Relli in his testimony said, I really can't tell what happened in that video. So we have to go on his word now. And although the video captured that incident, that was less than half a minute, not particularly clear. The evidence will make clear what happened there. The evidence will. Relli physically attacked Ills. Rocky tried to use a prop gun to defend him. And with that, I want to walk you through that video the best we can. We'll play it first. Again, you know this drill here is at the corner. Up here. Focus on here they come. There's Rocky, there's 12E, then Ills comes and he's following him. You see him go right after Ills, Relli, that's from Rocky, fires the warning shots. And there's Ills on top, Relli on top of Ills, punching him, that's Ills going down to the ground. Rocky's gone, 12E's about to be gone, and watch. There goes Relli back after Ills. And then he goes away after he hits him again. Ills eventually caught up with 12E and Rocky. His face was basically busted open. We have the clips to play. Small ones, let's do that again. So I'm going to play broken down little clips. The first one is then all being followed. Upper right hand corner again, guys. All being followed by Relli. Three of them trying to get away. First Rocky, then 12E, then Ills, and Relli's still coming hard. And you'll get to see this as many times as you want later. The second one is Relli on top of Ills on the ground. Is that right? Yes. Okay. Is it gonna help here? Ron, can I stand up here for a second?
Actually, Alex is going to get we have a pointer in the courtroom.
Oh.
And he's going to get it.
All right.
So, yeah, you can stand where you want to stand, but in a little while, Alex will bring up the pointer, and you can use it, or Mr. Lewin can use it, or Mr. Loma can use it, or Mr. Siegel can use it.
All right, so not to hold everyone up, I'm just gonna go forward here right now, okay? All right. Can you go back again, guys? This is the clip where you see Relli, and you get to see it later. Don't worry. Relli, big guy, on top of that little guy Ills, on top of him, not using him as a shield. Watch. Go ahead. There's Relli, that's Ills down, and Relli on top of him. Look at him. He's not worried about a shield. He's going after him. And then the last clip is, are we playing that last clip too? Take a look at it. It's after Rocky's gone, Relli continues his pursuit of Ills. This poor little kid. There. And he hits him again before he peels off. He goes to the left to hit Ills, and then he goes to the right. There's also a witness that saw this. He's going to come in here. Unfortunately, Rocky's attempt to scare off Relli didn't have the intended effect, obviously. Instead, Relli continued his attack on Ills, and then hatched his extortion plan. What you'll learn is that Relli returned to that scene an hour later. He returned to the scene an hour later. And he attempted to fabricate evidence. Ladies and gentlemen, this is some offensive stuff. It's going to be crystal clear to you. He attempted to fabricate evidence. You hear Relli's claim that he came back to the area an hour later with his girlfriend, Lydia Parker, and that while they were there, he quickly found 2 shell casings on Rocky fired right there. He picked them up, and he found them. And then he videotaped them. An hour later. You will see that story fall apart so hard. Why? Because the evidence will show you that well before Relli returned to the area, 7 police officers, like a SWAT team, 7 police officers arrived at that same spot. They responded to the scene and carefully searched every inch of that area. I could not believe what I heard on the opening statement. Oh, the police didn't know where to look. Police searched the exact same spot where Relli claims he picked up the bullets. Not close to it, not near it, the exact same spot. Thank God there's videotapes. There's a body cam from the police where they were searching, and there's that surveillance video that you see here that captured Relli coming back an hour later. Exact same spot. So, we're playing it now? Go ahead. Well, it's not, but we're playing or we're showing? Showing. So this is where the police are. Oh, this is back. Okay. The police are searching with flashlights. And there's 1, 2, 3, 4 right there right now. There were 7, there's another one here. This is where the alleged tussling was with Relli and Ills. Rocky's here, 12's here. Here's the corner they came around. So this is where the shots, yeah. Very high tech, Your Honor. This is where the shots were.
Like, easy on the side.
This is where the shots were discharged according to Relli, right here. Okay, right here. Look at where they're searching. This is where Relli, as he comes back an hour later and picks it up, and here's the landmark. Look, this is the corner that they all came around, right here, and this is where it all started. And here, there's that opening right here. See this big orange, red, whatever this thing is here? Look at the picture below. Okay. That thing there is that thing here. That opening here, this is a big orange thing. And you can't really see this well here. You'll be able to take these with you later. This is that orange thing. Go back up again, guys, down to the other one. This is that orange thing. Directly across a few feet there is where they're searching. Go down. Directly across a few feet there is where they're searching. You know what that is? That's really an hour later. According to the police, they captured that surveillance video. That's him an hour later, coming back to retrieve the bullets in the exact same spot at the, go ahead up. The cops were searching with a flashlight. And the cops weren't there looking for, they didn't know what. The cops were there looking for shell casings because they were called in for shots fired. So, what the police officers searching that scene found were no shell casings, no bullet fragments anywhere, and they were there. 7 officers with flashlights searching everywhere. No shell casings, no bullet fragments, no damaged property. Understand, there was a parking lot filled with cars right across from where this alleged shooting was, real ones, right? Not a window broken, a tire popped, a dent in a piece of metal. No damage to any vehicle at all. Absolutely no sign of a real gun being fired, as one of the police officers on the scene said. I repeat that. One of the police officers on the scene said, there's no evidence of a gun being fired. But still, they're going to ask you to believe Relli, who miraculously found them in the dark an hour later after 7 trained officers with searchlights in the same exact spot couldn't find them. So much for the officers didn't know where to look. They were right in the same spot. So, for that matter, although Relli is going to claim his girlfriend was there with him, because that gives a corroborating witness that can back his story up, right? When he found those shell casings an hour later, the video evidence in this case will show otherwise. That she wasn't with him, unless she's a ghost. That she wasn't with him. Thank God for those surveillance videos. So what did Relli first do with the videos he made of the shell casings? Did he go to the police? No, he didn't contact the police. Instead, he sent them to Rocky and Rocky's manager and said, I'm going to be rich. That was his first thought. I'm going to be rich. I mean, here's someone who basically claims he was shot. That was the initial story, shot. He miraculously recovered the evidence from the crime scene that the police couldn't find. And he didn't go to the police. His first thought was, I'm going to be rich. Well, the evidence will show you that Relli committed perjury without those messages. He actually texted a message meaning, I'm going to be rich. He said, I'm going to be itch at one point. But he said, oh, I didn't mean rich when I said itch. I meant irritable. Okay, because itch and irritable is not very close. And when you type in itch, sometimes both change it to irritable. It's just one lie after the other. He testified at an early hearing in this case, under oath. And you'll learn shortly after sending those messages to Rocky and to his business manager, you're going to learn that Relli sent another message to his business partner, to Relli's business partner, saying, I want to get this nigga's money. That's all that was on his mind, not his near-death experience. Oh my God, how did he even survive that scrape on his knuckles? Not running to the police to arrest the culprit. No. Texting everyone, I'm going to get rich, I'm going to get his money. That's all he cared about. The evidence will show you that Relli fabricated these shell casings in order to extort Rocky, right from the outset, right from the get-go. And why did he think he could get away with that? Why? Because Relli didn't know that the police had already returned within minutes of the sounds and the incidents there and searched the scene. He didn't know that. And of course, they didn't find anything. We talked about that already. There was no actual shooting because there was no real gun. There was no evidence of a shooting because there was no real gun. And that's why that same night, in response to Relli's text to Rocky texts him, "If I shot you, go to the police." They didn't show you that text, though. Showed you a bunch of texts between Relli and Rocky that night. They didn't show you that text. Rocky's saying, "Go to the police." Yeah, because someone who really shoots someone and is guilty said, "Yeah, go to the police." Rocky texted him that night. But of course, he didn't go to the police. That was not on his mind. You'll hear what he thinks of the police, this Relli. After his immediate efforts to extort Rocky failed, because he just wanted to get rich, he wanted to get that, need his money, as he said. When it didn't work, he said, "Okay, I better go get a civil lawyer." After he tried on his own to get the money, let me go get a civil lawyer to try and get money out of Rocky. And you'll hear that because the civil lawyer would only take his case if he went to the police. Relli then went to the police 2 days later. 2 days after the incident, he finally goes to the police. And you'll learn of the inconsistent statements he made to the police because he couldn't keep his story straight. It is all over the place. You'll hear this ridiculous claim like the one about him being shot. You saw that picture. The supposed proof of him being shot, the knuckle scrapes, the superficial knuckle scrapes across his knuckles, which are consistent with him doing what you see in the video, attacking somebody, attacking Hills. That did not feel by the way. But attacking somebody and punching and scraping a knuckle on the ground. What kind of bullet does that? Hits one knuckle, bounces down, hits another knuckle, bounces down again. I mean, it's ridiculous that he said that. He got shot. That was his first story. Now you hear that backed off way off that thing now. You'll hear his ridiculous claim about that injury, that it was a gunshot wound that required medical attention, he first said. Of course, now the DA just said to you, "Oh, you don't have to decide at the end of this case if you got shot or not. You don't have to decide, don't worry about it." Not that easy. Not that easy. You do have to decide because his credibility is at issue here. You have to decide if he was lying, if he was embellishing, if he was making up a story to get money. So if he says he got shot, and you find he didn't get shot, you do have to decide that. Relli at this very moment has a civil lawsuit against Rocky, seeking millions of dollars. Ready? $30 million for the knuckle scrape. $30 million. It's not a lot of money. Not just. Oh, he also claims that he has a permanent disability. Permanent disability from the knuckle scrape. I mean, he lies about almost everything in this case. He swore that he has a permanent disability. You're going to see an Instagram video of him, that permanent disability, showing his manicured hand, turning it around with his Rolex watch on. Permanent disability. It is offensive to a different level. He even claims he went to necessary medical treatment for his injury, to a hospital, but not here in LA, where he was shot. He waited all the way from California to New York to go to a hospital many days later, after getting a civil lawyer and being told by the detective in this case, "Really, you should go to the hospital, not to make sure you're not going to die, not to make sure you don't lose use of your hand, not to make sure your knuckles heal." The detective said, "You should go to the hospital for this case." The detective, it's going to be undisputed, told Relli to go to the hospital for this criminal case. Do you think they're trying to build a case? Is that what we do? We instruct victims to go to the hospital to make it look better? Those scrapes are no more proof of a real gunshot than those shell casings that the 7 officers did not find. And what else did the police not find after Relli turned in the shell casings over to them, finally, after walking around with them God knows where for 2 days? What else did the police not find? You'll hear that the police, despite examining them for fingerprints, they didn't find Rocky's on them. Those bullets, metal, capture prints. So if someone loads a bullet into a gun, the prints are going to be on that. Not Rocky's. Now, the shell casings apparently have no fingerprints on them whatsoever. As if someone who claimed to find them after the fact wiped them completely clean. And what else wasn't found on those shell casings? Rocky's DNA. They took samples, the police did, of Rocky's DNA for the purpose of comparison. They took his DNA to compare with the bullets. 0. Nothing. Never connected to the shell casings. As I mentioned, he was licensed to carry and possess firearms. You'll learn that he legally possessed firearms, which in fact were recovered from his home. You saw that whole bunch of pictures. He had firearms legally in his home. No problem. Police did a search, they recovered. No problem with the police. The evidence will show you that none of those firearms recovered were 9mm caliber. He didn't have one. You'll learn that 9mm caliber of the shell casings that Relli claims to have recovered from the scene are exactly the type of gun that Rocky didn't possess or own. You'll hear, and you heard from their opening, that there was a single magazine containing 9mm ammunition in his home. And you'll learn that belonged to his manager, Lewin, who will tell you, he will be here and testify why that was his. He also was licensed. Most importantly, though, when it comes to this little issue of the bullets recovered by Relli, as in Rocky's fingers, policeman is, and all that stuff, and the 9mm ammunition recovered in Rocky's home, that one magazine, 5 bullets or whatever, most importantly, you're going to learn that the shell casings were completely different than the ones that Relli said he found at the scene gave to the police. Completely different. You'll learn that the 9mm ammunition in Rocky's home was a brand called Sig Sauer, and the Relli shell casings that he claims to have found at the scene, that the police missed, were a brand called Federal. I'm going to show you the difference. I'm going to show you the pictures. This is the one in the house. That's that magazine that they recovered with a few bullets in it. That was Lou Evans. This says Sig. Hello. I can see nothing now, so you zoom back a little bit. S-I-G-S-A-U-G-E-R, or something like that. Sour. What's this? How does it say?
Luger.
What? Luger. Sig. S-I-G. Sig Luger. The ones at the scene are these from Relli. FC, which stands for
Federal cartridge.
Federal Cartridge. Completely different brand, completely different bullet. Those are the ones from the house that belong to someone else who will testify here in the room. And those are the ones that Relli claims to have found at the scene. They're different bullets altogether. Someone should have a big reveal on the opening. They didn't show you that, no. They didn't show you the comparison of the bullets. Just the magazine. Ooh, it was a 9mm. Different bullets. In the end, you'll see that all the objective evidence in this case relied on by the prosecution to support a shooting rises and falls, I mean falls, on the word and credibility of Relli, who is a proven criminal and perjurer. Those shell casings he claims to have found, the superficial scrapes he claims to gunshot wound, the video himself that he even claims he can make out clearly. We have to rely on his rendition of it only, because without his rendition, you get nothing from any of this. Ladies and gentlemen, it's your job when you try to evaluate the evidence. To look at every single piece of evidence they present to you, the prosecution, and ask yourself, does that pass the smell test? I remember Mr. Lewin, on every time he stood up in jury selection, said, possibility? Did we say possibility? No, no possibility. No possibility. The word possible is not part of this trial, he said to you. Remember that. This case is not about possible. It doesn't pass the smell test, and you have to ask yourself that, does it? Or do you have a doubt? about a piece of evidence that's really the focus here when you consider the charge in this case. There are two charges. The first charge is assault with a semi-automatic fire gun in this case. No, actually I said that wrong. It's an assault with a semi-automatic firearm. That's the first count. Both counts of that, actually. The first one is the altercation in front of the parking garage. The second for the altercation around the corner. 2 counts. To prove those 2 counts, they must prove beyond a reasonable doubt 2 things. 1, Rocky possessed a real gun.
Yeah, this sounds like.
Oh. The judge will give you the law. He's right. The judge will give you the law at the end of this, what needs to be proved.
I made the objections, anything right?
And you were right too on that one. They won't be able to meet that burden in this case. When the judge gives the law, you'll see the 2 things that have to be proved. It's not close. On either. The objective evidence in this case, independent of Relli, just is not there. There are no gunshot wounds, no evidence of actual gunfire as officers at the scene, no shell casings found at the scene. When the police arrived,
This sounds again like pure argument.
evidence will show you there's no property damage, no fingerprints, no DNA linking Rocky to anything. And that's because what Rocky had was a prop gun. Either that, or he was the luckiest man to ever walk the face of this earth. What is real in this case wasn't a gun, but Relli's attempt to extort Rocky. That is real. Out of millions of dollars, and using this criminal case as a windfall in his civil one. And folks, and going back to what I first said to you, my promise, it's a promise to you. And I would be doing this so emphatically if I weren't sure.
That's argument, it's improper.
You will see, the evidence will show you hard evidence of an extortion in this case, and perjury to try and cover it up. Hard evidence of an extortion in this case, the evidence will show you, and perjury to try to cover it up. The evidence will show you Relli's understanding in that regard, that if Rocky's found guilty here, he automatically has liability in the civil case and gets money. Lots of money.
That's absolutely improper.
Sustained.
Counsel continues.
Stop, stop. No speaking objections. Stop. Disregard anything about the consequences of whether Mr. Mayers is or is not convicted in this case. The consequences have no bearing on any decision that you have to make, and you're going to be given a jury instruction to that effect.
Thank you. Anyway, it's been Relli's endgame from the start. You're going to hear some of the absolute worst things come out of his mouth when it comes to this case, this criminal case, and how much he truly cares about this case and what he was willing to do through this case. Ladies and gentlemen, when this case is over, you'll see that Rakim Mayers, they said Rocky's innocent. He's not only not guilty, he's innocent. And when we stand up here for our closing arguments in a couple of weeks, we'll talk about how the evidence shaped up. You'll see that for Relli, it was never about justice, ever. It's about a man seeking a profit from a fabricated narrative, using false.
I didn't hear. Read that.
It's about a man seeking profit from a fabricated narrative.
Sorry?
The evidence will show you that Rocky has absolutely nothing to hide here. He's a man, evidence will show you, he's a man who built success through passion, valor, and hard work. He stands in stark contrast to this fellow. You'll see Kate stand next week and lie to you over and over again, trying to destroy Rocky for his own financial gain. He's a parasite who wants you to help him get his payday. So, ladies and gentlemen, at the end of this case, after all you've seen and heard, all the evidence and cross-examination, all the things I promised you today, I will ask at your hands for a verdict of not guilty for Rakim Mayers. It's the only verdict consistent with justice. It is the only verdict consistent with fairness.
All righty then.
Mr. Sloman.
Hey.
So, what we've been doing, welcome to Justice Served TV, the hosted part of the program. What we've been doing is what we suggested everybody do as the case wrapped up, and that is, rewind. Take a look at the opening statements and see what was or wasn't promised, what was or wasn't delivered upon, and that certainly helps you figure out, whether the prosecution made their case or not. What do you think, LKB? Do you think there were some holes in either opening statement?
Well, I just rewatching Joe Tacopina's opening statement. He delivered. He delivered. I mean, first of all, let's start with what we talked about. This is an assault with a semi-automatic weapon. That's what the indictment charges. That was one of the questions we had when we left you all, right? So they have to prove beyond a reasonable doubt that Rocky had a semi-automatic weapon, not that he had a prop gun.
Okay, well, that's a good question. What is the definition of weapon?
Semi-automatic.
No, okay, semi-automatic weapon. What is the definition? Is it a weapon only if it fires a projectall? I don't know. It's an honest question. I don't know.
I think that's what their experts said, that it's a weapon under the law only if it fires that projectile.
Okay.
All right, and so the prop gun doesn't fire the projectile. I mean, I want to see the jury charges on that, but I'm like 99% sure.
No, you cannot see the jury charge. Should we look at the poll results? We had a poll on what people thought. Is it a gun? Is it a prop gun?
Yes.
Here, the numbers were, let's see, where did it go? Prop gun, 68%. Real gun, 12%. And unsure, 18%. Now, of course, if you're the defense, unsure is good as prop gun, right? Because if you're unsure, then you can't go forward with anything else.
You can't prove beyond a reasonable doubt that it was the semi-automatic, the Glock 43, which is what they've narrowed it down to, right? To be able to use that magazine. They're saying that it was a Glock 43. Okay.
Yeah, and just an odd circumstance that Lewin left that magazine, which fit none of his guns, at Rocky's. So, the prosecution wants you to think, well, that's because it was for Rocky's gun and they've disposed of the gun.
Yeah. So, but what I got from that was very interesting. First of all, Lewin's behavior, that last like 5-minute clip that we were on, or 10 minutes that we were watching while we were waiting with all of our viewers here and our chatters, he kept objecting. Sometimes Joe just ignored him, It just went over him. Sometimes the judge said, it's, okay, it's sustained, it's argument, but he got it in.
And the judge said, you don't hear this very often during opening statements. No speaking objections. During opening statement, he's already trying to get Lewin to, calm down, dude. Calm down.
It was. I had forgotten it, and now that you see it, I started getting PTSD. The second thing is, where is Lydia? That was another thing. Remember,
yep. What happened to Lydia?
Prosecution said that he went back with that. You'd see her on tape. Lydia was not on tape. Lydia is the girlfriend of the complainant, Relli, right? Yeah. And when he got to it, because it wasn't on, he didn't realize it, right? Because he had made the statement that she went back with him before he ever saw the tapes, right? He didn't say, well, she's
over there. It's over there somewhere.
But she did not testify, and she was supposed to testify. And if she didn't testify, why was that she didn't testify? Now that she learned probably for the first time that she wasn't on tape. So if I were her lawyer, I'd say, no, Fifth Amendment. Sorry. Yeah, you're not.
That's a good catch. That's a huge hole. I remember when the openings were presented, I said, oh, I can't wait to hear from this girlfriend because, yes, she's going to be biased to a degree, but she's not involved in the fight, right? She was there after the fact, and when Inspector Gadget found the casings. So big hole for them not to bring her on, and leaves a question with the jury.
My third thing that I noticed, again, now that Mr. Tacopina was repeating the text, which we won't say the words, but that he was going to get his money. Relli said, I got to get his money. I'm going to get his money. And then the cop tells him, well, you can't really have a case unless you go to the hospital, right? I missed that, right?
Yeah.
And so he goes to the hospital several days later in New York, but he's already... I'm going to get his money. Not that, I want to get justice. Not that I want to prosecute him because he tried to kill me. No, I'm going to get his money, leading to our breaking exclusive that we had before the start of the night before. That was the defense was going to say this was a $30 million extortion plot. This was a shakedown. And that's exactly what they did. And I'm telling you, now that I hear Mr. Tacopina's opening, I'm like, yeah. Oh yeah. Oh yeah. Oh yeah.
I can't think of any holes. Anything he promised that he did not deliver. And he was already telling the folks, watch out for Relli. this guy is going to be caught lying again and again and again. And he kind of did.
Yeah, I think it was a very, very good, Misty Mays was a good review for all of us, and I think it was. And I'm sure that he must have worked on that opening statement with his team, probably with trial consultants to see what the theme was. Because remember, Joe, as I said, teaches with us at Harvard, and not a question should come out of your mouth and not a statement be made that doesn't go to the theme of your case, not the prosecutor, your case. And his case was that Relli was unreliable, that nothing he could say could be validated, that he lied, that the police evidence will show he lied, the videotapes will show he lied, and that this was a shakedown for money. And that's what I got from that.
Yep. And he, anytime he would stray and use those words like parasite, things that are kind of triggering words, and Lewin would, wet his pants and try and get him to stop. The trick you learn in opening statements is you can preface almost anything with the evidence will show.
Right.
And if you do that, then that's all you're suggesting. I'm not arguing. The evidence will show he's a parasite. All right.
Right.
So, yeah.
The evidence will show he's a parasite. The evidence will show this is a shakedown. The evidence will show this is extortion. The evidence will show he lied. The evidence will show the police were on the scene. I know when,
and those are all arguments, but watered down by suggesting the evidence will show.
which is what the judge told him to do, because I'm always of the viewpoint you should be able to say it once and then say everything I say to you is because we believe the evidence will show, and I'm not going to repeat it. But this judge made him say it before every time he did it. There was an objection.
Yeah, I would sprinkle it in. I wouldn't do one and done. I would sprinkle it in. It wouldn't be every single thing. But anytime I got near something I knew might be kind of triggering, I would definitely throw it in there.
Yeah, when we were gone for about an hour, because we were on for about 3 to 4:30 answering questions, and I thought to myself, what's the one thing the prosecution had today? They wanted that stipulation, and I'm sure they wanted to get some kind of firearms expert in if they didn't get the stipulation. And both sides got something. One, that the prop gun would not shoot, but it would eject casings, right? And two, that the regular gun did not match the casings that Relli bought in from the shooting gun that he had, did not match any prop gun. And I'm thinking to myself, let's assume for the moment if Relli did go back to the scene, right? I mean, we have all things. And if he knew, he could have easily picked up casings if the police had missed them, right? The prop casings. And I'm going to grab those, and I'm going to get them out of the way,
Yeah, if the cops missed them.
If the cops missed them, which where are they? Who knows? But whatever they were, they weren't around, and no one from those people, the three people that were with Relli, were shown picking. They were shown running away from Relli. And who's the last one in the video reel? It was Relli, right?
And I was looking again at the initial confrontation at the parking garage. With just trying to look at it as somebody observing a scuffle. And it really is very difficult to tell who is wrestling with whom, who's trying to get away from the other and who's grabbing the other by the collar. And, the one argument is that Relli is pulling Rocky toward him. The other is that Rocky is attacking Relli. It's very difficult to tell. Very difficult.
That you can see that Relli has, I don't have my hoodie on tonight to do it. Relli has grabbed Rocky by the hoodie on both sides with his arms and has got him really close. So you can see that. So that's kind of an interesting thing, because if somebody has a gun, right, and they're shoved into you, why are you grabbing the hoodie to pull the person closer to you? Why are you doing that? If anything, you're going to be pushing away.
Or reaching for the gun. If it's there, you can try and wrestle with the gun.
Right. So that was something that else I was thinking, because I'm thinking, we're jurors here. The jurors are going home, right? They're going home and they're thinking about it, even though they can't discuss it and they can't look at what's on the internet or TV. They're going home. So thank you. Wait, what?
Wait, what? Wait, what? Yes.
A new member for us. Thank you very much, and please feel free, anyone, to ask us questions. So, Michael, I'm here for you. What questions did you have? I told you what I was concerned about.
Yeah, and we talked about it earlier today because, they kind of cut the day short, and we've had a little bit of time to ruminate here. And as I've said before, when the prosecution's done, and now in this case, everybody's done, and you still can't piece together exactly what happened in terms of the elements of the alleged crimes, I don't know how as a juror you get there. I don't know what you have to fill in, what hole do you fill in, and where do you get the information to do that? And the key to me is not just Relli being a lying sack of poop. There's no doubt about that. Just some of the physical evidence, just some of the logic between the stories that we've heard from Wally, from Lewin, and from Levin. I just did that. Levin.
Lewin.
Levin. What makes sense? Just common sense. And I heard Pauly P use this in his opening statement. It's right out of Law School 101. Don't check your common sense at the door, right?
Right.
And it works for both sides. So
Right.
what do you think, using your common sense, using what you've heard from these witnesses and the evidence or lack of evidence, what does common sense tell you? Tells me there was a scuffle based on something, maybe not paying Josh's funeral expenses, maybe Relli just feeling left out by Rocky, who had attained a level of success. So they had this altercation, whatever drives it, okay? Then you have this gun, maybe it's real, maybe it's not, pulled out to defend against Relli or to threaten Relli. That's the first why you have to come to, I think. Was he threatening Relli? Was he defending against Relli's threats? Then you get to the actual gun itself. Was it a real gun? Was it a fake gun? And I think you have to go through and hit these junctions, and it's almost like a flow chart. If yes, here's your answer. If no, okay, let's move on to the next thing. And I get to the bottom of my flow chart, and it comes out, I haven't seen the prosecution prove their case.
Especially beyond a reasonable doubt. Oh, racist cat. This is the important question. Do we think I don't know. I know that Miss Shorty's group is doing something that they are kind of obsessed with Tacopina being the lawyer incredible help or something like that. Hulk or something like that. So I don't know. I think I can't answer that.
I think it's safe to say he works out. That's if we can learn more, we'll certainly share that. But
we're gonna, obviously, when we finish, we're going to try to ask everybody on the show, to come on. We'll see about that. So, I thought that rewatching the openings was really, really, really good. Now, Raynette said Joe had the script in front of him, or he's a fortune teller, right? Yeah,
and really, that's what I'm talking about when you rewatch that. Where are the holes? And you mentioned one which was huge for the prosecution, and that was poor Lydia.
Yeah, poor Lydia. Lydia was to me a really big hole that they're going to have to deal with. If he was there picking them up, where was the only witness?
The other person that was there in the altercation, I thought we would hear from, was Ills, and for whatever reason, no Ills. I don't know if it was a jurisdictional thing, or I don't know. It just seems logically he'd be somebody you'd want to hear from. He was there.
Except that whatever it is, he's probably outside the jurisdiction of California.
That's what I'm guessing.
And he doesn't want to get involved.
He wasn't voluntarily returning.
He wasn't voluntarily returned. There we go. One of these days, with Mr. Tacopina, we're going to have to save all of these for him.
That was one of my first comments when I started watching it. I said, I got to give a shout out to his tailor, because that is some finely tuned suit wear.
But I thought he did a wonderful job in the opening, because you don't realize how much we heard. You just don't realize how much we heard. Now if there's a guilty verdict, we're all going to be sitting here and eating bananas or something like that, saying what happened.
Yeah. Yep. And then that's where I gotta hear from these jurors. I gotta hear how they got from point A to point B, because I went sideways somewhere. If you're not thinking like I'm thinking, not that I'm right, but just that mine's logical, and I want to hear where somebody made an impression on jurors to go the other direction.
Yeah.
I did see. Just got a comment. I was looking at some of the stuff, and it just said Rocky is guilty.
Really?
Not a lot of analysis. It just
right
said
here,
Rocky
in
is guilty.
In our comments.
It was not a comment on our live right now, but it was one of our postings.
Oh, and
It
what
was
about, isn't that
yeah.
interesting that they believe Rocky was guilty? Well, I'm sure that really has a bunch of people, and
His
the
people.
prosecution is like them, and what can we say? That's the danger when you try to a jury, because you never know what someone's thinking. They may just think this whole thing is BS.
I know that Tubi does. That's no doubt about that. We know how Tubi feels about it.
Tubi is way in, on this. So, yeah. So we'll see. We'll see. Any questions about this before we go on to what's happening in Karen Reed?
Oh yeah.
Okay. I know I see all of you are commenting, and we love that you keep commenting and all. But wow, what a day, right? We expected a longer day. We expected things to happen, and things did happen.
Yeah, things did happen by not happening. Yeah.
But not happening. And then tomorrow, obviously, there is no court. The attorneys will be taking the day off, I'm sure, to get their closings ready. I would like to know if the judge imposed any limits on them. If he says closings are going to be Thursday, maybe that's the way. He's already charged them, remember. He's charged them. So once they close, and the way California works is the prosecution closing. And you practice there, It's a defense closing, and then the prosecution gets a rebuttal. And usually it's supposed to be like a cross-examination to rebut what is said there. But my experience has been, and our experience, I think, watching shows has been that the rebuttal argument really becomes the main argument for the prosecution.
Yeah, and sometimes if two attorneys like now are doing it, they'll split some of the substantive issues. So it's not like, hey, you can't get into what you should have covered in your first argument. It's a little looser. And sometimes, and if it's a really simple case, there won't even be a rebuttal. That will not be happening.
Right.
Lewin, and this case. But yeah, you're not required to give a rebuttal.
Yeah, yeah. Oh,
Try and stop him. Try and stop him.
Let's say, I think that, people wager on everything. I wonder if there's wagers in Las Vegas on whether or not John Lewin would give a rebuttal in this case.
Oh my gosh, that I don't think any bookie is going to take that bet.
Rocky did decline to testify. It was very quick. Usually the judge goes through all these questions and, are you happy with the advice of your lawyer? He said, are you testifying or not? He said, I'm not testifying. Okay.
Okay, moving on. Yeah, so much for knowingly, voluntarily, and willingly.
It was very short.
This is from Crystal Allen. The question I've had from the very beginning is, how did Relli know that the police didn't find any bullets, casings, because he never spoke to them? For him to go back and magically find 2 casings, that's an interesting question. Could be that he just had those just in case.
He didn't know the police had been called to the scene. That's the answer to that question.
Well, yeah, but he can't have imagined that they never showed up there at this scene of this shooting.
He didn't know the police had been called. He didn't know the 911 had been called. So
but I'm saying, if you were involved in that incident, are you going to think that there never will be a police? No police showing up. Well, that's just stupid. Why would you think that?
No, because I don't think
that's ridiculous.
It was just, these are the 4 ASAP guys. They're having a dispute. He figured this is a good time. He never knew the police were called, and that's what happened. He never knew, and that's why his attorney said, well, you go back to the scene and see if you can find the stuff, the day after, according to him. And he says, that's what he says, the attorney says, and then he goes to the Dunkin' at 11 o'clock at night, which apparently everyone in California knows during the pandemic, Dunkin's weren't open at 11 o'clock at night, which is apparently why the defense didn't go there, decided not to have that witness. I assume it's because if they got into that, then Lewin would cross-examine and we'd be here till like next week.
Very little upside.
Yeah, very little upside.
I mean, it would have been something, but not considering the whole scheme. So I'm thinking, if in his mind, the cops will never ever investigate this, that somehow explains why he thinks he can get away with just showing up and finding casings they never found. However,
one other thing, remember, he was told you had to go to the cops to make a complaint by the lawyers.
Oh yeah.
That he knew that the cops hadn't.
But that was very quickly. It wasn't days later.
It was like a day or two later.
So if he learns after the fact that the cops did in fact go, I'm just, because I don't know what he really knew and what he didn't know. He's a liar. But then he just doesn't, and they find something. then he just doesn't use the casings he found because, doesn't need those. I don't know if those help him or hurt him, to be honest with you, because they don't seem to match anything that matters.
Well, I think that they now hurt him because it looks like he was trying to set up evidence to help. Because remember, the cops said they never told him they went to. He didn't even see the video. He didn't know there was a video. And then
That's the girlfriend factor. Yeah.
Yeah, he went and filed the police report 2 days later. The cops hadn't been. They didn't say that they'd been there. They never told him. So as far as he knew, he had to go file the police report to make a claim. Then he had to fly. Then he flew to New York, and then he went to the hospital because the police told him he had to go to the hospital. So as far as he thought, there was no police report. This was it. This was easy money.
Well, he's really as dumb as he appears to be then.
Yeah. Oh, Brooklyn wants to know when Bob Bianchi is coming on. That's your turn. You got to call Bob.
What's that?
Brooklyn would like to know when Bob Bianchi is coming back.
I don't know. He was on the night shift last night, so he was working till 6 a.m.
Right.
So.
That's what he covered for me when it was on a Wednesday. I think he covered.
And then he works on Friday, but I think he does a day shift on Friday.
Friday, yeah, which is really wonderful. So you have to sandwich Bob when he can be sandwiched. Because remember, he's still practicing law full time. Also, he's a good guy. Bob's a good guy and really good attorney. Another really, really good attorney. Yeah, he has unspoken writ. There it is. I knew unspoken.
There it is.
All right, so we'll see what we can get Bob back on. Maybe we can get him on Thursday. Since he's got the day shift Friday. Tomorrow, are we doing a live show tomorrow night?
I'm not sure. We'll think about it. I can't, really, if we're unless something happens, I can't really think about what we would do. And so we'll think about it. I think we might do a pre-tape though for perhaps Friday.
Get some of our work done. I'm sorry to say I love you all, but somehow we have to get some cases done. But that's okay. We're coming to the end of these all-day shifts. Poor Missy. Missy says, I need a break from the all-day shifts.
I know, really.
Dizzy starts in the morning, Missy goes to late at night, and they're really great. They do that really for you. So definitely back on Thursday. If we do anything tomorrow, maybe a pre-tape show. Just so you all know. But that's okay. Our pre-tape show are pretty good.
Yeah, well, we haven't done a comment show in a while, so it's about time. And we've got a lot of them that we like to throw out there. So we can send along comments. It's hard to clip them from this forum or format, but if you do them, respond on any of our segments that are re-aired and replayed, that's usually where we cull them from. So, and anything is open. Anything, criticisms, how great Linda always looks, how glamorous she is, all the usual comments.
All right, so we should move on to Karen Reed for the last 20
Yes, we should. It was, we talked about, let me do the scene setter here, just so that for the two people that don't know the Karen Reed case. We're just past 3 years. It was January 29th. John O'Keefe died. How did it happen? Well, unclear, at least to me and to the jury, apparently. So Karen Reed is out hanging out with some friends at some local bars there in Canton, Massachusetts, the Waterfall Bar, the what's the other one called? I can't always forget what it's called.
The Waterfall Bar.
Mix somethings. So they go from one to the other.
So we knew this like you were just there.
I was there and I can't remember. I can picture it. But anyway, they go over to the Waterfall Bar, which is a lovely little spot. And then, at the end of the night, they think they're going to gather at 34 Fairview because that's where John O'Keefe is and some friends are. Well, he's going to be there with other friends and, McCarthy's, that's it. I think it's even C.E. McCarthy's, which I labeled. I misidentified it when I was there. I'm looking at the sign and I said something like CF, and it's clearly not CF, it's CE. Anyway, so they all wind up at this 34.
Says CF McCarthy's.
It is CF?
Yeah.
Oh.
No.
Okay. Anyway, so they all end up at 34 Fairview. And the question is, what really happened at that point? John O'Keefe is dropped off by Karen Reed. That seems to be undisputed. And then she goes home. They had kind of the relationship been a little rocky. She goes home, meaning his home, because there's some kids there that it's kind of a convoluted story, but there are kids there. And so she stays there, wakes up at 5-ish or so. John's not around. Nobody's seen him. Calls are made. They drive around. They find him. He's ultimately he's on the lawn, 34 Fairview. Big storm coming. Snow's already started to cover him. Still alive at that point, but ultimately dies from exposure. So she's accused of bumping into him with her car, and then him dying from exposure as a result of whatever injury suffered by hitting him with the car. Others suggest that maybe something happened in that house at 34 Fairview. There were a number of Albert folks there. There were a number of Higgins folks there, and McCabe folks. So did something happen in that house that resulted in injury to John O'Keefe that left him stumbling and out into the snow, where he may have passed out and then died from exposure? And don't forget Chloe. The dog Chloe, also a factor. Did Chloe or some other dog get into attack mode and tear up John O'Keefe's arm? So we go through the trial, hung jury. Judge Bev immediately says hung jury before the breath is out of the juror, who says we can't do anything. They've already had the dynamite charge. So
they had the dynamite charge 2 times, I think, right?
Yeah, and the second time it was just it seemed very truncated to me. So anyway, that's it. Hung jury. Wow. And then almost immediately we start hearing from anonymous jurors via affidavit that, hey, wait a minute, we were unanimous on counts 1 and 3, but not on 2. 1 and 3 are the more serious. 1 is the second degree murder, and I get the wording on 3 wrong because I don't have it here in front of me right now. I got it here somewhere. Anyway, they said we're unanimous on those. So what's the deal? Well, the court never asked the jury when they came back and said we're hung up, did you come to a unanimous decision on any of the counts? That question would have cleared up whatever validity there is to this apparent unanimous decision on 1 and 3, but it wasn't asked by the judge. So everybody wanders off. So now they're starting to collect up these affidavits, and I think there were 5 total. Even the prosecution got some. And so that went up on appeal. And just today, do I have my little thing here? Just today, and we were hoping it would happen before the trial, just because the second trial, because it makes things a lot Okay, well, not breaking news at the moment, but close enough. We get the decision down from the appellate court in Massachusetts. We knew this was going to happen. It was just a function of when. So denied the defense motion, basically based on double jeopardy, suggesting that, hey, the jury already decided counts 1 and 3. We don't need to do that again. And the appellate court said no. Now
Well,
we can get into the hows and whys when you're ready.
You scared Oasis cat with that with the and Brooklyn.
What's that?
You scared Oasis cat and Brooklyn.
Oh,
but there were reasons that they gave them, right? I actually posted,
and I've got some for you here.
Yeah, also on my private Twitter at Kenney Baden. I don't know if Missy retweeted the Justice Served, but Michael Bryant has them.
Yeah, I just took a few different of the chunks that you were posting and playing with. Let's see if I can get them in the right order here. I like an appellate court that tells you right up front what they're deciding, so you don't have to wade through everything and then find out what it is. So this is one of those courts. So here's the outcome. Ultimately, either to acquit or convict. Accordingly, we affirm the trial court's denial of the motion to dismiss and the defendant's request for a post-trial juror inquiry. Okay, so there's the headline, right?
Right.
So we've now digested that. Let me get for you the first of a couple of screens here that just give us some of the. I'm not going to read the whole 35 pages for you.
No, I read it this morning.
Yeah. So let me find some of their reasoning, and we can chat about that for a second here. Okay. So, talks about the questions. Can post-trial accounts of jurors' private deliberations that are inconsistent with their public communication in court render the declaration of a mistrial improper or constitute an acquittal where the jury did not announce or record a verdict in open court, which goes to my point at which the judge could have said, you guys unanimous on anything? So we conclude they cannot. The jury clearly stated during deliberation they had not reached a unanimous verdict on any of the charges and could not do so. Now, that was, I think, before the first dynamite charge, because there wasn't a lot of conversation in the second time, just before mistrial was declared. Only after being discharged did some individual jurors communicate a different supposed outcome, contradicting their prior notes. So what do you think about that? Let me say this right up front. I think the appellate court never was going to dive into this mess. They had to reason their way through their denial, and this helped them get there. Thoughts?
It's what you've been saying, that the time was too long to go into their reasoning. But the problem I have with not going into the reasoning is that then you're saying, well, if you screw up, right, and because screw up has to work to the detriment of the defendant, right? Because now it's not the defendant's fault. They got the stuff from the jurors right away. They went right in right away once the jurors contacted them, and the court said no. And now we're several months later, and they say, well, it's just too late to go in now. They've been subject to this. So it seems to me that the screw up inures to the detriment of the defendant twice. So that was one concern I have. The second thing is I never have seen a jury not being dismissed without being, but not ever told, but, did it come back on the defense, but never told, hey, you can reach a verdict on some of the counts, not all of them. You don't have to reach a verdict on all of them. Jurors usually think that. And really, it's a good lesson that every jury charge is, say, look, if you come back and you feel you're hung on some, but you have a verdict on others, tell me. Let me know if you have a verdict on anything. And that question was never asked of the jury. And I think it was endemic that the judge should have asked that question.
Yeah, I agree. No, I think, but that's not how we do it in Massachusetts. I mean, that seems to be the answer to anything that kind of sounds like an irregularity. We don't do it that way in Massachusetts. See this note referencing your fine work?
Yeah, now I see that.
Kind of Karen Reed related, but not factual lie. I watched you this morning, Linda and AJ, in a rewatch of Phil Spector. There was a lot of talk about physics.
Yeah.
Made me think of AJ's cross of Trooper Paul. Yeah.
Yeah. Well, Alan's a very good cross examiner. He's what Lewin would like to be. Okay, because he can take a little tiny bit of a fact, a little tiny thing, and just like blow it up into a big thing. But he's not annoying in the way he does it, right?
Yeah. The substance, they could say the exact same words, and Lewin would be annoying.
And when we agree with, when I was out sick with the pneumonia during that, and one of the things Alan and AJ would say when I came back is like, well, she's always prepared. She's always prepared. I mean, we fought we fought the good fight, but we have respect for each other. And I think you were out there and you interviewed me and he said he loved me, and I was like,
he did. That's what he said.
Yeah. You're gonna play it.
Oh no, I don't have that. Sorry,
okay. Yeah.
I don't have that. I don't have that at my fingertips. No,
you don't somebody complimenting me. Okay, we have to load that in.
It's around somewhere. I think Missy probably has it handy.
By the way, no, this is not a vintage necklace. It's by an artist named Sam Patania. He's a third generation jeweler out in Arizona. His father they're all in the Smithsonian. His grandfather, his father, him, and now his son's doing this. But it's not vintage, but it's just exquisite work, all handmade work. I'm not sure Sam's doing most of the handmade work, but that's the necklace. I'm actually going to put some of his work up for sale because at this point I've used it, and I think it should now go to the next group of people that would like to have some of Sam's work. It has a ring, it has a bracelet, it has earrings. As a matter of fact, I lost an earring playing poker one day, and he had to remake the earring.
It's a whole ensemble.
How
do you lose an earring playing poker exactly? How does that work?
Everyone's asking.
Violent poker playing.
I think the back got caught in my hair or something. I kind of do this.
Everything is so complicated.
It's very, very complicated. It's very complicated. You have a hat on. Have you ever
I got lazy today. I was working on stuff. Allowing inquiry into remember, this is ultimately one of the reasons the court decided as it did in denying this appeal, and they cite law to back up their decision, of course, allowing inquiry into a private agreement reached in the secrecy of the deliberation room would also contravene the prohibition of probing the content of juror deliberations. Remember, we cannot invade the minds of the jurors anytime we're challenging. If there's misconduct, you cannot be invading their thought process. Maintaining the secrecy of those deliberations is a, quote, bedrock of our judicial system,
Oh,
end
Michael,
quote.
don't we have like 7 jurors though who've not maintained the secrecy? At
Yeah.
least I went to the defense, 2 went to the prosecutor, say we decided that. That's what I'm confused about. I would love to hear from the jurors.
I would too. And I really think, and they mentioned timing as one of the factors, but I think it was so important that it's the overriding factor. These folks have been out there, they've been exposed to who knows what. Maybe they changed their minds. Maybe they said something in the deliberation room that suggested they might not be, aligned with everybody else. I mean, who knows? It is not only to prevent jury tampering, but also upholds the finality of jury verdicts and fosters confidence in the judicial process. Of course, in this case, we don't have a jury verdict, but anyway. Probing secret deliberations to determine whether the jurors may have privately agreed on a verdict they never returned would undermine these fundamental principles. So the court citing various cases for the analysis that gets them where they want to go, which is, I'm not getting involved in this case. You've got a second trial queued up for April Fool's Day. Why don't you go to it? I think it would have been shocking, Linda, if they did not deny this appeal.
Yeah, you said that, and I thought that the judge should have inquired more right to the get-go, right at the beginning when you had that. I mean, and we kind of saw that in the Murdoch case in South Carolina, however bad it was, in terms of the inquiry. And I guess if you're going to have an inquiry that's bad, then you don't want to do it at all, because then people won't want to be on a jury if they think they're going to be attacked for their opinion. So, but that's what happened, right?
Yep. So full steam ahead. At least that's not hanging out over the trial, and we assumed that it would be decided prior to.
There's a glitch.
What's that?
The attorneys, we've asked for a statement actually from Jackson and Yannetti, I believe, but the attorney on the brief.
I'll check again to see if we've gotten an answer, but yes, go ahead.
Has said that because this involves issues of double jeopardy, which is a constitutional right, they are deciding whether to take a writ of certiorari to the U.S. Supreme Court. So they could do that.
They could. Do you think the Supremes would look at it?
Well, they'd have to look at the writ, even if they were going to deny it, right? They have to look at the petition, the writ, if they were going to deny it. The question is, would they take this case? Probably not. I think they're dealing with other issues, a policy, more. And quite frankly, if she gets acquitted, then it's moot.
Yeah, and so, if you look at the Supreme Court, their goal is to clarify disputed or confusing decisions, right? Underlying court decisions. They're going to be the ones that figure it out. If you got 5 stacked up that say A and 5 that say B, well, we're coming in to tell you what the rules are, what the law is. That's not really the case here. I mean, all these cases cited by the court are pretty well established law in terms of how you can get into a jury's mindset, and how the delay in hearing from jurors or trying to bring them back in to hear more, how that is, it's pretty well settled. You just don't do that.
Wow. But the jeweler's name is Sam P. Michael's like laughing. Patania. Okay. It's Batania Jewelers. There's a website. It'll tell you, if you Google them, you'll find all about the Batania, Patani. But Sam is who actually designed and made this. All right, so there we are. That's decision.
Anything else? Anything else you got? Who made your glasses?
These are Chanel.
Oh, well, of course. What's the Chanel logo? Is it just what is it?
It's 2 double C's. It's on the side of the glass. You really can't see it here.
Okay, are they like? I'm thinking of. I'm thinking of. Are they the back-to-back C's?
No, they kind of. Well, they back to back, and they kind of circle each other.
Okay. Okay, I got it.
It's a great logo. We should think about it for JSTV.
Yeah. Let's see if somehow steal their look-alike logo. Okay. All right.
Oh, we'll have to see about it. Anyhow, so the next thing that happened today was an additional attorney. Michael, who was it?
Is that weird, or is it just me that thinks that's weird?
Well, I guess it depends on who the attorney is. It
Okay,
wasn't me.
it's Betterow, right? His name's Betterow. Yeah, he's been representing Turtle Boy Aiden. What's Aiden's last name?
Carney.
Yeah.
A-E-R-N.
Isn't that weird? He's
By the way, you have a tape.
yes, but I also will not play. And so there's, it's just a weird, strange bedfellows, I guess we should say. But there was a pro hac vici application.
And it said that she wanted him on the team.
Yeah, and he's a New York attorney, so they need the pro hac vici for Massachusetts, and that just means permission to appear in that court when it's outside your normal jurisdiction.
I got it.
I'm not telling you.
No, but I had a pro hac vici in I've had a pro hac in Tennessee, Massachusetts, Connecticut, California, Florida. I've been pro hacked a lot.
Yeah. It's a nice little tool. Look at this case alone. Yanetti's the only Massachusetts attorney. I think everybody else is far flung. So what do you think about this guy? I mean, obviously they're in.
Wait a second, in terms of geography, not in terms of their mind.
No. Just their geographic location. So what do you think about Betterow and his client? Obviously there's no conflict, but it just seems odd to me. What does he bring into the mix?
He brings some information that his client may have that they can now share, right? That they can now share together, right? Because then it's attorney-client. It's not anything that, well, you got that from somebody that you don't have an attorney-client privilege. So I think that's why this was done, so they can share information. Or he can whatever Dr. Turtleboy gets, he can share information. He gives his attorney Betterow permission to share it with the attorneys for Karen Reed, and that's why I think this is done.
And what kind of information do you think that might be?
I don't know, because there's been so much going on with him. He got arrested, and he was arrested because he was for Karen Reed, and they were trying to silence him. So maybe he has more information going forward, in terms of if he's bringing a suit or anything of that sort. But whatever it is, I'm a firm believer, in collaboration on teams with attorneys. So whatever collaboration he brings, they have a hunch that it's going to be good.
I hope they have room for him, because the courtroom is kind of small. They might have to, have a little side space for him. There's just so much crammed into the well of that court. It is crazy.
Well, there may be times that he's there, another attorney's not too.
It's possible.
Because
anything is possible.
The dog bite attorney really only needs there for testimony on the dog bite, right? All right. So
and there was another motion for an extension of some deadlines, and that's still hanging out there.
What was that about? Was that?
Well, because the Commonwealth, remember the supplemental discovery that they provided? It was voluminous, I think was the word that was used by the prosecution. And it's like 12 categories, but I think it's thousands of pages or 1,000 pages. It's a lot.
I think it was 940 pages, if I recall.
It's what?
I thought it was 940.
Yeah, I knew 1,000 kind of came to mind. And so, your buddy Alan Jackson, he's like, we have this full-throated motion for dismissal coming up, maybe now even more full-throated, but it's unfair to have to go through all of this late to discovery, which may impact our full-throated motion. So I don't know. I haven't heard that. I don't believe there's been a ruling on that or not. We know that Judge Bev has been, as best she can be, kind of hardcore at keeping the schedule moving forward to April 1st. And that's why, at least at this point, March 4th is the dismissal motion. We'll see if that changes.
So, Kay Schmidt, thank you, by the way, again, for all the memberships you granted this week. But curious also about Betterow. Alessi is the dog bite specialist. Yannetti and Jackson. Yannetti's the local attorney. Are great, but wonder if they're getting burnt out. Well, let me tell you, you do get tired of trial, but boy, I'll guarantee you, Yannetti and Jackson know this case inside out. I mean, I can pick up a file from a case that I've tried in the past, And there'll be certain things I don't remember, but mostly as soon as I look at, oh yeah, and then it all just
Yeah.
it's all the storage cabinet just comes out. So whatever it is, this is the case they're concentrating on, and normally you don't have more than one of these cases every couple of years that has this kind of intensity.
Yeah, I think if anything, they're chomping at the bit now. I'm sorry, champing at the bit. I said that wrong. It's champing at the bit. I think they are. I think enough already with the preparation and the surprises. Let's get it on.
And Karen Reed gave interviews. She gave interviews to Ted Daniels News, right? On Boston 25.
Boston 25, yeah. They're dropping that in segments, right? I think I've seen one. Is there a second one out yet?
There's a second one that came
Second
out.
one out too.
Yeah.
Nothing. Here's my take. Here's of all that I've seen, and I haven't seen it all yet, but I saw enough to make this observation. What happened to the Fall River accent? She speaks like vanilla, like I do. There's no sign of an accent. What's going on there?
Well, sometimes when you speak slower, you lose your accent. Now, if I go really fast, I can really speak Jersey. So yeah. I say that because you can when you start speaking slower, you can lose your accent. You don't have an accent from California.
No, we're not allowed to have accents in California. Native Californians, and they say there are very few of us, but native Californians don't have accents. There is no accent.
Yeah, and you see that with stars from Europe and all, and they start speaking normally, and their accent comes back. But when they're,
I think there's something more deliberate. That's what I'm getting at. I think it's more deliberate because you remember in the trial how she was maligned, by the Proctor factor. Not that I would use that as a reason to change my behavior, but that there was talk about it. Judge Bev gets bugged a few times because she's from Boston. So I think that maybe there's been she does these appearances. Karen Reed does these appearances, which is unusual, right? For
Alan Jackson has no fear of putting her out there. In fact, he let her walk out the courthouse last week, and she was except for the fact that he loved me. She was answering the questions to the news media directly. So, I'm not,
and to the fan base,
and to the fan base, So, she's not fearful, and but it's a new way of dealing with cases. It used to be, never let your client talk to the press. You never did that. But she's got a fan base. People think she's innocent.
Definitely.
They want to hear from her.
And so my point is that none of this happens by accident. Okay. And I think I would include her being less local is the way I'm going to describe it. Could be deliberate because she knows she's out there.
Except for the fact that she's going before a jury in Massachusetts. I parked my car.
You think she's going to testify?
Yeah, no, I don't think she's going to testify. But the jury pool is hearing her now, right? They're hearing her. So.
Yeah, I think her audience is bigger than that. I mean, obviously the jury is the most important audience, but I think her audience is big, and that's just my observation. But to me, it was so obvious that it had disappeared almost entirely.
Well, the other thing that disappeared was Chloe, who miraculously has appeared to give dental impressions.
Yeah, that is not coming into the second trial.
I don't know.
First of all, I don't even know if it happened. Number one, I don't even know if it happened because Brendan was not under oath.
Right.
He could have just been baiting. We're talking about Dr. Marie Russell, the dog bite expert, who the prosecution tried to get excluded from the second trial. Denied. So she's going to testify. But he made it sound like
denied close, according to Judge Bev, right?
Oh yeah, well, I think that was she's throwing a bone to the prosecution. It was a close call, very close. And so they rehomed Chloe, right? Rehomed the dog.
Right after this, Chloe, who put somebody in the hospital, right, with the dog bite. So we saw those pictures, like, whoa, I was bitten by a dog. I told you how many times.
Yes, we've shown our dog bite scars here.
You and I, right?
Yes.
Yeah.
So that's in, and the question was, well, you didn't, Dr. Russell, you didn't, see the dog, you didn't, visit the dog, you didn't get a mold of the dog's teeth. I mean, we did. We did that. And everybody's like, you what? Was the defense involved in this? Apparently not. If it happened, And so as a result of that, I don't think it's coming in.
And you know, you can say something is a dog bite, but you can't attribute to a specific dog, just like you can't attribute forensic odontology to a specific person. So I don't know. I guess the Whitey, remember the Whitey Bulger defense attorney, who's a really good attorney, obviously. Okay, or else he would have taken. You know, he wouldn't have had Whitey Bulger. I mean, because you know, you don't. Even though Whitey Bulger went to jail, got and then got killed in jail, but that ain't coming in. I'm sorry, that ain't coming in to specifically identify the Chloe.
And who cares anyway? And who cares what dog it was? You know, you can fill in that blank if you want, but it all goes to the wounds on his arm being caused by something other than the car.
Yeah, and Alan Jack, they just filed something on this this week, and they said there's nothing that says below his neck that he has any fractures. He has
no bruising,
no car imprints. You know, do you have your car? Do we have our car?
Oh yeah, of course we do. I think it's back here somewhere. Oh, is it out of frame? Let me see if I can reach it without pulling my
because I think we
wires off.
I
got it.
I'm not wearing my earphones. Something's going wrong with my computer with my headphones. So there you go. There's the car. There's the car. We even have the taillight that Michael has.
Yeah, that's even further away.
So whatever it is, Moon Goddess, the dog didn't kill him. Yeah, but the dog could have incapacitated him after he was, and then he's in the snow, and that kills him. And that's
exactly. Could have dragged him down. He hits his head on something. I mean, who knows?
Right. Yeah. Walter Amber asked Linda Michael, would you take a special prosecutor position as well-known defense attorney? Wouldn't that jeopardize your future as a defense attorney? No, not really. I mean, I would if I firmly believed in it. I was a prosecutor. I don't know if Michael was, but I was a prosecutor. I was a trial team. I headed a trial team. I tried a death penalty case as a prosecutor. I would, but I'd have to believe in it. Just like I believe in my defense cases when I take them. I believe that the person is wrongfully accused, certainly be accused of the top charge that may have been leveled against them.
And I've been on both sides of the fence, but primarily in civil. And the fact is, you're an attorney. You take the facts, you take the law, you make the arguments that are best for your client. We talked about it in the context of Doug. Remember Doug Weinstein, his first criminal case. And I always said, good attorney's a good attorney. You may be using a different cookbook if you're in criminal court. There may be some different issues to resolve, but it's still, same analysis, the same skill set. You got to be able to swing both ways. Does that make sense? Is that inappropriate?
Well, that's what most there's very few really high profile attorneys that handle cases. Quite frankly, I mean, Doug Doug was a great civil attorney in a very specialized area.
Yeah.
But he was also with a great trial team, so he got to learn criminal law. And he had other people arguing the criminal law motions. He had the fabulous criminal law attorneys. So he got to learn the law, but the same skill set in terms of when you decide to question somebody, what you decide to question them on, when you decide to just sit down.
Yep.
John Lewin, you have to learn.
Hey, one more thing before we go, and I think this is the big enchilada hanging out over the Karen Reed case, the federal investigation.
Right.
Where is it? How is it going to play a role in this second trial? What's coming in? What's not? I think that's going to be huge.
Well, Proctor was supposed to have a second hearing, right? I don't know if it happened.
Yeah, I think it was the other day. Again, his court-martial. But I'm talking about the investigation into.
Yeah, it was 14 minutes at sidebar, and that's clearly that wasn't about the ARCA. That was clearly about.
I'm glad you remember that 14 minutes because I timed it. I took time to time that.
I know 14 minutes at sidebar the other day, and she wanted to know. So they know more about the federal investigation than we do, and that's the case. That's the federal investigation that spilled over into the Staunton case that my husband's involved in with the Sandra Birchmore, because Proctor's name is in that case from everything you read. And that's some issues that have come over apparently from what I could read in the newspaper in his court-martial, whatever you want to call it.
That's what I call it. Yeah. Disciplinary hearing, I guess, or something like that.
These are all very small departments and they all know each other. People know each other.
Oh, yeah.
So obviously there's a lot more going on here than you and I know, but the judge knows about it too.
Well, yeah, she's listening. So she's learning a lot in that 14 minutes, right?
So I don't know what the push is to get this case tried, quite frankly, that comes
Yeah.
forward.
Well, that's why that to me is the big matzo ball that we have no real clue about how it's going to impact this trial. So
Yeah. So anyhow, I don't see how they get a conviction if they can't prove the prosecution that the cause of death is related to her hitting him, even if she thought she did. You've got to have a cause of death. And so far, the two medical examiners and the federal medical examiner, I think there were three people who testified, right?
yeah.
Yeah, three people testified. Said the car, there was no car impact. There was no car evidence of a car impact, and they couldn't, and therefore he didn't die of a car impact. Although the jury,
they seem to hang their hats on, a little bit of fragmented glass of some sort in his sweater, right?
Right.
I guess if somebody wants to believe that, I guess they can.
Yeah, but I don't think anyone did a refraction to see whether or not it was the glass from the glass he was holding. But he was holding a wine glass. So that was my recollection of it, because you talked about it.
And a hair on the bumper. A hair on the bumper.
But that's the car that he was around. So what?
Yeah. And he was all, even if he was standing back there, you could stand back there and shed a
what if
hair.
he's sitting back there and she's back up and he just falls, right?
I kept trying to come up with ways where I thought he could be hit in a weird way that would cause him to lose consciousness or stumble and then fall. Maybe, if he's truly drunk, he's holding his glass and he just kind of, kind of bends forward so that his head's exposed.
No. Yeah.
What's that?
Either stumbles and falls in snow, either before or after Chloe.
Or he just kind of moves, he's drunk, so he kind of leans forward and one of like drunken, but he doesn't lose his feet. And she bumps into him as he's moved forward, so his head is hit by the back of the car.
I don't know if she bumped
I'm just trying to find a way to
but
make
the
that
prosecution
possible.
has to prove the way. See, that's the thing. We should. Moon Goddess. By the way, thank you, Joanna. Joanna was the one who came to us with the Peggy McGee case, and she was there in that courtroom, right? Judge Bev's courtroom, told us about the case, told us that the medical examiner was full of baloney. Quite frankly, nice woman, but full of baloney in terms of calling it a homicide, and asked us to look into it. And the next day, Judge Bev acquits her on the basis that she didn't cause her ex-husband to die of a heart attack. Basically, it was his own anger.
Another one of those cases that we've talked about where you wonder why you're in trial.
And Joanna came on the show. Thank you, Joanna. We appreciate it. We found her. We tracked her down. She wasn't.
Yes. You thought you were safe just being an anonymous name.
Yeah. And Moon Goddess, there you are. So we hope that you will also do that for us when we're looking at the Karen Reed case, because we'll be talking about that on and off from April, obviously the next month on motions in April 1st. And Michael may go have to buy another taillight because he's already destroyed the one taillight.
Yeah, that was fun. Oasis Cat, no chain of custody for any of the evidence when Proctor has possession of evidence or how much time before turning it in. No doubt about that. And I can't wait to see how they handle the Proctor factor. I think there's going to be some serious motions in limine about what they can get into, what they can't get into. But it's pretty tough to just say, yeah, the lead investigator is not here. Don't worry about it.
Well, they may force the defense to call him and then cross-examine him, because all those texts that he wrote are good for the defense, right? Without Proctor.
Oh, yeah, that's true. That's true. All of those, yeah.
And then what if he does if he says, I take a Fifth Amendment? The worst thing that could happen for the defense is Proctor now gets on the stand and takes the Fifth Amendment, whether they call him, whether the state calls him.
Yeah. So the Proctor factor is going to be interesting.
Yeah, very interesting.
All right. So we'll figure out if we're going to do something tomorrow or not.
We'll let you know. Missy will let you know. If we do something, it'll be pre-taped, but it'll be fun. It'll be fun. We want your comments. And of course, Thursday, we're going to be around all day because of the closings. And Friday we'll be around. I think I have to check, Michael, because I think I have, one of those personal beauty appointments that I'll have to deal with.
On Thursday?
I don't know, Thursday, Friday. We'll see.
Thursday, Friday.
The one thing about it, if it's in the morning, I can always change it. I mean, my work is suffering, but for our viewers,
for good reason. Come on.
Look, I'm going to work all weekend on all my cases.
That's what weekends are for.
My clients they're very happy to see me. They love seeing me on the air here. So.
All right. Okay, then. Well, we'll see you next time. I'm Michael Bryant. Try to do the right thing.
And I'm Linda Kenney Baden, and together we are Justice Served TV. And if you like us, please subscribe, share, hit that like button, and also the notify button. And we'll see you tomorrow or Thursday.